what were you doing back in 2021 or March of 2021 when that order was entered?
I was receiving pandemic unemployment.
Are you currently working?
No, sir.
One of the documents we did receive was a physician statement that stated that you should only be working 20 hours a week. Is that correct?
She has multiple college degrees. She's worked in the safety department in plants before,
Right.
Making close to 200,000,
Mom provided medical records from her doctors and psychiatrists for the court to review.
It's in the interest of Isabel Marlowe. Ms. Marlowe, do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Hand is in the air.
Mr. Trussell, do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
The court's going to take judicial notice of its own file. Contained within my file is the controlling support order that was signed by me back in 2017. I think 2017. Nope, 2021. Wrong case. All right, come back in 2021. You can call your first witness, Mr. McNulty.
At this time, the state will call Ms. Marlowe. Ms. Marlowe, do you understand that in a previous order that was entered on March 17th of 2021, you were ordered to pay Mr. Trussell $280 a month in child support?
Yes, sir.
Thank you. And you also understand that you were ordered to pay $45 a month in cash medical support?
Yes, sir.
Do you understand that as of February 29th of 2024, you have a current child support arrearage balance of $2,780.61?
Yes, sir.
And do you understand that you also have a medical support balance of $458.12?
Yes, sir.
Now, in this previous order, there was a finding that your average monthly income was $1,950 a month. Is that correct?
I'll take your word for it.
Well, in the time of that order, what were you doing back in 2021 or March 2021 when that order was entered?
I was receiving pandemic unemployment that ended, I think, in June or July of 21.
Are you currently working?
No, sir.
Do you have any health conditions that are preventing you from being able to work?
Yes, sir. For myself, I'm still dealing with the fallout from a concussion and a traumatic brain injury and a clavicle spinal injury. I see my therapist weekly. I see my psychiatrist every 4 to 6 weeks. And I saw a neurologist finally for the first time back in January. And I talked to my PCP probably once a month or every other month. And I had previously faxed in all of that information and documents to the Office of the Attorney General Child Support Division. I didn't know until today, talking to Mr. Joseph and Ms. Sidney, that those documents weren't all available. I was trying to locate them in my paperwork, but I don't have the actual papers, but I have the people and the phone numbers to be able to contact people.
Okay. Your Honor, at this time, the state would like to enter into evidence of State's Exhibit A, the payment record.
State Exhibit A is admitted in debit.
Okay.
Now, Ms. Marlowe, one of the documents we did receive was a physician statement that stated that you should only be working 20 hours a week. Is that correct?
Yes, sir. I believe the one that you were showing me was from my psychiatrist. I receive services through the Harris Center for Mental Health and IDD. It's a program policy to list the 20 hours to provide additional support and referrals, like to the Texas Workforce.
Miss Marlowe,
Yes,
could
sir.
you do me a favor, please?
Yes, sir.
Just answer the question that Mr. McNulty asked you.
I apologize. I thought I was.
No, what you're doing is you're giving me a whole lot of additional information that I haven't been able to look at or see, okay? So,
Yes, sir.
right now, you don't work for that company, so you don't have the authority or the ability to testify to what their policies are, okay? You can testify to specific things that they do on your behalf, but you can't testify to their policies.
Yes, sir. I apologize.
That's all right. Go ahead, Mr. McNulty.
Ms. Marlowe, do you have any objection to Judge Webster looking over that physician statement? If I
No,
submit
sir.
it to the court?
Absolutely.
Your Honor, at this time, the state would ask that the court review off camera as State's Exhibit B, the physician statement that was provided to us by Ms. Marlowe.
Mr. Trussell, the state has sent me something that they wish me to look at. It's the physician's statement in regards to Ms. Marlowe that she just testified to. Now, generally, I don't put these type of statements on the screen because that means they're broadcast to the internet and everybody can see it. Is it okay, Mr. Trussell, if I review this doctor's statement for Ms. Marlowe?
Yes, sir.
All right, I'm going to look at that in camera. Go ahead, Mr. McNulty.
Now, you're saying that there's been additional documents that you might have sent in that from other doctors and from other health professionals saying that you shouldn't be working at all?
Yes, sir.
Okay, and can you testify to the court what they say about you not being able to work any amount of time?
I was told to apply for SSI, and I did. And I apologize. I was told that I was not cleared yet from the concussion and other things, and that I needed to anticipate a recovery timeframe that would be about a year to 18 months, if not longer.
Now, how are you currently supporting yourself?
A variety of domestic violence agencies. I'm a recipient of those, as well as my youngest daughter receives SSI, and I'm her rep payee.
And do you have any safety concerns about your address being and contact information being disclosed in any order that the court enters today?
Yes, sir. I filled out all of those documents. I also crime victims compensation. I filled out their request for anonymous address.
And what are your safety concerns about having that information disclosed?
I don't know who contacts who or how and in what ways. I don't want my location known.
Do you have any concerns about Mr. Trussell?
Not currently.
Do you have any concerns about any other third party that you're afraid might have access to your address?
Yes, absolutely.
And who do you have concerns about?
Helena's father
Have
and
there been
any of his family.
Have there been any instances where they've made threats or have been violent towards you in the past?
No, it's more low level than that. That's the wrong word. Covert, no. Subtle maybe.
And do you have any other minor biological children who are below the age of 18?
Yes, sir. Besides Isabella.
Yes. How many other minor biological children do you have?
One.
And does this child live in the household with you?
Yes, she does.
Are you currently taking care of this child?
I am.
And is having to take care of this other child taking away from your ability to work?
It does frequently. She's medically complex. And while she does receive nursing support services, it's not always consistent. And when I don't have a provider, I frequently have lost a job or things of that nature because I didn't have consistent care for her.
I have no further questions. I pass the witness. Mr. Trussell, do you what kind of health insurance do you currently have for your child?
It's state insurance.
You understand that as of February 29th of 2024, Ms. Marlowe has a child support arrearage balance of $2,780.61.
Yes.
Are you asking the court today to order Ms. Marlowe to pay back that full amount in the child support that's owed to you?
Yes.
And you also understand that she has a medical support arrearage balance of $458.12.
Yes.
And are you opposed to reducing Ms. Marlowe's child support amount?
Yes.
And why do you oppose reducing her monthly child support amount?
Well, 'cause she hasn't stuck with the original agreement. Why would she stick with something less?
Thank you. I have no further questions. I pass the witness.
All right. Ms. Marlowe, when did you apply for SSI?
The official review started on October 27th of 2023.
Okay, so you're still in the middle of it.
Yes, sir.
And based on your testimony, Ms. Marlowe, I'm going to assume that you have been the victim of domestic violence from a partner in your household.
Not exactly, but yes.
Well, you described a concussion. Did that not? How did that happen?
He was not a person in my household. He was my child's father.
He was
Subtle
who?
difference. He was my daughter's father.
Okay,
Subtle
so
difference.
well, I understand it from a judge's perspective. I don't consider it to be different because he's a member of your family because y'all have a child together. All right, so there was some domestic violence between you and the father of your second child. Is that correct?
My youngest child, yes. She's my baby 5.
Okay. That's the child that's currently residing in your household?
Yes, sir.
Okay. And when did that happen? What year and the month?
The event, it ended June 24th, if that was the Friday of 2023. That's
Okay.
when he was arrested.
Okay. And they obviously they charged him with an offense?
Yes, sir.
Has it gone to court?
Yes, sir.
And what was the outcome?
A limited 8-year protective order and probation.
Okay. So the criminal charges were finished. He accepted a guilty plea and he's on probation for it.
I believe so.
Okay. Well, I mean, the best of your knowledge, that's what happened.
Yes, sir.
Oh. Now, the doctor's order that I'm looking at, this appears to be a doctor's order from your psychiatrist. Is that correct?
I believe so. Yes, sir.
All right. And he says that you struggle with PTSD and bipolar disorder. How long have you been diagnosed with bipolar?
When I was a teenager, although that it's a diagnosis that they don't think fits any longer.
And they don't think you're bipolar anymore?
No, sir. I didn't respond to any of the mood stabilizers.
All right. So basically what you're telling me is that you're just still struggling with the PTSD.
Absolutely.
And that comes directly from a result of your domestic abuse from your prior father of your child.
No, sir. I've struggled with PTSD most of my life.
Well, Miss Marlowe, that's a problem for me. Okay. Because back in 2021, I set child support based on the fact that you were capable of working and earning a living. And nobody said anything to me about bipolar then. So why should I use that as a basis of reducing your child support now?
Because I wasn't given the opportunity in 2021 to provide any information for
Hold on, let's see.
that.
Let's see what you were not given an opportunity. Well, I mean, they filed the lawsuit. They served you with it. Why didn't you show up for court?
I did attend court, sir.
You sure did. All right. And did you tell me back then that you had problems with PTSD?
I don't clearly remember court from 2021. I remember the feeling of not being heard whenever the court was over.
So
I
now
don't-
I'm offended, Miss Marlowe. I'm offended because I was the judge in your case, and you're telling me that I didn't listen to anything that you said.
I apologize for offending you, sir. That's not my intent.
Okay. Well, here's the problem, Miss Marlowe. While I understand the nature of what it is that you're trying to tell me, I take my responsibility as a judge in regards to these children real serious. In fact, I'm deadly serious about how I take it. And I make it a pattern and a plan that I listen to everybody that's in my courtroom. Now, you might not have liked the ruling. You might not have liked the decision. But as I'm sure if I went back and looked at my records, I would advise you that you had a right to appeal my ruling. You had a right to appeal it. You had the right to hire an attorney and file a motion to change it. You didn't do any of those things.
Actually, sir, that's not accurate.
No? Did you appeal it?
When I had the ability to get the funding together, I
Hmm.
did seek a lawyer, and I did try to work that avenue with regards to the custody, visitation, and support.
Well, so you talked to an attorney. Did you hire the attorney?
Yes, sir, I did.
Well, how come he didn't file a lawsuit? Or she?
I apologize, sir. I'm not sure I know how to answer that question.
You paid an attorney to represent you to either fix or correct or change the court order that I did in 2021, correct?
I apologize, sir. I feel very unsure of how to respond or answer your questions.
Okay. Well, let me just tell you the fact. The fact is that no person that represented you, Miss Marlowe, ever filed a lawsuit on your behalf in regards to this case after the court order from 2021 was completed in my courtroom. Okay?
There should have been some documents that we sent to the court about visitation and support. They were over the summer, I want to say in 22.
Nope. Nothing filed in my court since the last order was done in 2021, except for this modification filed by the state. So whoever the attorney was that you hired, Miss Marlowe, to help you in this case, they didn't file anything on your behalf. Okay? All right. Let's see what we got here. All right. So your current doctor, at least the one that I saw, said that you're capable of working 20 hours a week and that you would be released in August of 2024 or possibly reevaluated at that time. But this current release that you're under, this current doctor's order that you're under, does expire in August of 2024. Is that correct, Ms. Marlowe?
I believe so, for the one that you're looking at.
Right. I'm probably going to say the doctor's name incorrectly, but it looks like it's Akiwono. And I'm pronouncing it based on how he's got it spelled, or she's got it spelled. And you said, so this is your psychiatrist. Do you also have a medical doctor as well?
Yes, sir, and a neurologist.
Okay, and your neurologist has got you under doctor's care that says you can't work at all?
I believe so. Yes, sir.
Thank you, Ms. Marlowe.
Yes, sir.
All right, Mr. Trussell,
Yes, sir.
is there anything else that you think I need to know about this case before I make a ruling?
Well, just that not much has changed on this end. You know, we don't. She doesn't have much contact, no visitation. Again, I can't tell the kids where she lives. There's no address.
Right.
The individual that caused these concussions or issues are the same individual that she was living with our child during the case that you proceeded over. you know, Isabel is still in extensive therapy from the abuse and neglect from that household. So
Okay.
she
Mr.
has
McNulty-
multiple
I'm sorry.
college
I'm sorry.
degrees.
Mr. Ross, go ahead.
Yeah, she has multiple college degrees. She's worked in the safety department in plants before,
Right.
you know, making close to 200,000, you know. So I guess that's all I got to say.
Mr. Trussell, I can't, I mean, I can't deny anything that you're saying, but I also can't deny the fact that she is currently under a doctor's care. I mean, it's there. I mean, I'm not a doctor, so I have to look at what the doctor's telling me as far as what her, you know, what her limitations are.
Understood, sir. Understood.
Mr. McNulty, the state has filed this motion.
Yes, Your Honor. So
Does the
according to
state have a
Ms. Marlowe,
position?
yes, so according to Ms. Marlowe's testimony, the income she was receiving at the time of that 2021 order was from a pandemic era relief that she was getting at the time that she testified that she's no longer receiving that income.
So what do you want me to do, Mr. McNulty?
The state is asking that her child support be adjusted based on the current circumstances and based on her current situation.
She doesn't have a job. She's not working. She doesn't have any income. What do you want me to set the child support on?
Based on her testimony, she said that not able to work because of a health condition.
So is the state asking me to set the child support and the medical support in this case to 0?
Yes, based on her testimony, because she's not able to work, we're asking to reduce it to at least 20 hours a week based on what was provided to us.
Okay, so you're saying that while she is telling you that one doctor says none, the fact that the other doctor says she could work a minimum wage job at 20 hours a week, you think that's how it ought to be set?
Yes, we're asking the court to set it based appropriately based on the testimony, but the evidence that we did get from that physician statement does say 20 hours a week, and that was a updated figure of how many hours that she could work at maximum, which would come out to a monthly income of 628 a month.
Yeah, that part's. I just needed to get your position, Mr. McNulty, on the record.
Yes, Your Honor.
Ms. Marlowe, is there anything further you think I need to know about the case before I make a ruling?
I don't believe so, Your Honor.
All right. Anything further, Mr. Trussell? I didn't mean to cut you off, but I wanted to get Mr. McNulty on the record as what his position.
No, I'm okay.
All right. The court's going to find the court has jurisdiction. The court's going to find, based on the testimony of Ms. Marlowe and the in-camera information that I have, that there has been a material and substantial change in circumstance. Ms. Marlowe is currently under a doctor's care and is only allowed to work 20 hours a week, according to the evidence that I've seen. Therefore, I'm going to order Mr. Trussell to maintain the current health insurance that he has on the child. Ms. Marlowe's child support is going to be reduced to $75 a month plus $5 a month in cash medical. I'll grant judgments against Ms. Marlowe in favor of the state and Mr. Trussell for the child support pay record that's been submitted to me, and find that as of February the 29th, 2024, Ms. Marlowe is behind in child support, the amount of $2,780.61. Medical support, the amount of $458.12. Did I get those judgments right, Mr. McNulty?
Yes, Your Honor.
All right, the child support is going to get paid back at a rate of $20 a month, the medical support at $5 a month, all payments beginning April the 1st of 2024. Ms. Marlowe will be responsible for court costs, but I will give her until September the 30th of 2024. Now, I'm going to grant the non-disclosure for Ms. Marlowe in regards to a third party. We have a problem, and we're going to go into that once we get off the record, but we'll figure that out. But Ms. Marlowe is entitled to the protections under the Texas Family Code in regards to non-disclosure. There is a prior person in her life that was guilty of domestic violence, and therefore that address will need to be kept out of the court order to make sure that whoever that person is doesn't find her through my court order. All right, Mr. McNulty?
I think that covers everything, Your Honor.
All right. Ms. Marlowe, Mr. Trussell, for the record, The state's gonna send me a court order. If it matches what I said here today, I'm gonna sign it. I'm gonna get it back to them. And they're gonna make a copy of it and send it to each of you. Now, as before, you don't have to live with the ruling that I've made today. If either party is dissatisfied with my ruling, you have 3 business days for which to file written notice of appeal with the district clerk's office in Sabine County. Your appeal has to be in writing, has to be on file. You have to be specific in your appeal to tell the referring court what part of my ruling you disagree with. You're also responsible for sending.
The mother is only having phone contact with the children as a result of she was pulled over for a DWI with one of the children with her. How do you know that she's residing in Hawaii, sir?
I guess a man's Facebook, he always posts things on Facebook and he always shows the baby and her on the beach. So she's still in Hawaii.
I believe the evidence will show that the mom who doesn't have custody is living in Hawaii. So the state is asking the court to use the minimum wage presumption for the state of Hawaii, which would be calculated at $2,080 as the gross. So there's 3 children subject to this suit, and then mom has 2 others outside the suit. So the state's going to be asking for 56 in cash medical, 447 in child support, and the state will follow the ad litem on any custody, possession, or access recommendations.
Yes, sir. The evidence is going to show that the mother is only having phone contact with the children as a result of she was pulled over for a DWI with one of the children with her. Since then, the children have resided with their father and only had telephonic contact with their mother. The father's not asking for mom's rights to be limited. He wishes she would have more of a relationship with the children, but unfortunately, she is relocated to Hawaii where she's not exercising any kind of contact. And so based on my conversations with the children and with their father, I'm going to be asking for guideline child support and that visitation be by agreement of the father and the mother.
All right, then she's not on any type of probation or anything that would prevent her from actually having the children in her possession, is she?
Not as far as I know. She
Okay.
had a county DWI, I believe. It was in Tyler.
Okay. All right, Homer Earl Campbell, got it. All right, let's go ahead and let's get some testimony and let's see what we can set up. All right, thank you.
And who are the children subject to this suit?
The children's name
Yes, sir.
is Angie Anna RC, Henry Angel RC, and Angel Henry RC.
And what is Miss Terrafina's relationship to them?
That's the mother.
And were you able to listen to the statements that Miss Farah and I made to the court just a minute ago?
Yes, sir.
And anything that needs to be corrected?
Or no, sir.
Where does Miss Yazzie reside?
In Hawaii, not here.
Okay. Is she capable of working?
Is she working? I'm not sure if she's working or not, sir.
Is she healthy enough to work though, if she chose to?
Yes. Yes, she is.
Okay. And do you know if she has any other children?
She has 2 little babies that she had not too long ago. And but you know, she also has 2 older ones.
Do you know
She
how
also
old
has
those?
the other one's, one is 17 and the other one's 15. They reside with their grandmother in Louisiana.
Yes, sir. Do you know if she's been ordered to pay child support on either of those older 2 children?
I'm not sure, sir. I am not.
All right. And what do you do for health coverage for your children?
Well, they have Medicaid.
And do you know what Miss Yazzie does for her 2 younger children for health care?
No, sir, I really don't.
I understand. And I'll pass the witness, Your Honor.
All right, thank you very much. Ms. Farah, you're a witness.
Yes, sir. Now, how did you come to have the children living with you, sir?
Well, when on that Christmas day she got arrested, CPS called me. She had Angie. And CPS called me. And I picked up Angie from CPS in Tyler, Texas. And from there, I had the kids because they were on a Christmas vacation. So that's how I had them.
Okay. So
She never
you
involved-
had the boys with you and
Yes.
with
I had
her-
Angie too, but she picked up Angie saying that she's going to take her to get her presents and come back. But she never came back. She took Angie with her. She took her.
At the time, were you living in Bell County, sir?
I'm living where I'm residing now.
Okay. She took Angie all the way to Tyler. I mean, that's a long way.
Yes,
correct? And how long, what Christmas was that? How long ago was that, sir?
2021, I believe. They've been with me almost 2 years already in December.
Okay. And do they have any contact with their mother?
Well, they try to call her a lot, but to no day, she hardly ever answers. She calls them, I'll say once every 2 weeks, if that. But the daughter, Angie, do try to call her a lot. She just doesn't answer. But
And that
then
was-
her two daughters were in my house this weekend. They came down from Louisiana. They were with their brothers and sisters, and they had a good time. But her older daughter said that her mother have phone connection. She only could use Wi-Fi, I guess. That's the only way she could make calls. So I guess when Angie tried to call her, she can't pick up because there's no connection, I guess. I don't know.
What sort of visitation do you think is appropriate for Miss Yachty?
I mean, I don't mind her seeing the kids, but for her to see them by herself, that scares me because she likes to take them and leave. She likes to run away with them.
Here's the deal, sir. I'm giving you custody today, and that's kind of a crime. So, yeah, she won't have the legal right to do that anymore. So don't worry about that.
Oh, okay.
Okay.
But I would love for her to see them. The kids would love to see her.
Okay. Are you asking the court for those visitations to be supervised because of her past, having taken off?
I would like that. I would like that for a while. That would be good.
Okay. And okay. And how do you know that she's residing in Hawaii, sir?
Well, on Facebook, I guess a man's Facebook, he always posts things on Facebook, and he always shows the baby and her on the beach. So she's still in Hawaii.
Okay. Is that also what you understand from her older children and from your?
Yes.
Okay. All right, sir. And you're not asking for any sort of retroactive child support or anything. You just want child support moving forward. Is that correct?
Yeah, that's correct.
Okay. I'll pass the witness, Your Honor.
Right. Any other witnesses at this time, Mr. Diamond?
No, Your Honor.
Any other witnesses, sir?
No, sir.
All right, folks. Mr. Darcy, I'm looking at naming you, based on these circumstances, I'm looking at naming you sole managed conservator, maiming mom, or possessor conservator, ordering guideline child support. I think the state originally said that they thought there were only 2 children, but obviously have 4 children out on this one. A 17-year-old, 15-year-old, and then 2 babies.
I can calculate those numbers if the court would like them.
Yeah, we're using the Hawaii minimum wage presumption going forward, so we don't know our information. I'm looking at naming him sole managed conservator, giving her possessor conservator rights. But right now, I'm not going to order to have any, not to have a standard possession order. I'm leaving, she's allowed to see the children from, she's coming in from Hawaii, and we're looking at an all-day thing. I'll say from 11 o'clock to 6 p.m. on any Fridays or Sunday that she gives dad advance notice of at least 72 hours. She wants to see the children in his presence or his designated agents present until further order of the court. So in other words, sir, she can come see the kids any Saturday or Sunday she wants to, as long as she gives you at least 3 days notice that she's going to come in and see the kids. Okay.
Okay, sir.
All right. And then she's got.
Sir, Your Honor, is that visitation supervised?
By him in his presence or his designated agent.
Okay, thank you, sir.
Yeah. And if she wants to agree to something else, he can. Anything he wants to agree to, I'll let him, but I'll give her something that's enforceable. So she has to, now she's not here, so I don't want to use the parenting app, but she has to do, ask for that in some affirmable way, either email or text messaging, okay?
All right.
All right, is there anything else the state's wishing, the state got me those figures?
Yes, Your Honor. So I calculate with 3 in and 4 out, I calculate $414 would be the child support, and $40 would be the cash medical.
All right, so granted, no retroactive is requested. If there's any court costs to be paid in this matter, it'll be responsibility of the mother, and she has until July 31st, 2024 to pay that. All right, is there anything else on this matter, Mr. Diamond?
No, Your Honor.
Ms. Fire?
No, sir. This time.
Any questions, Mr. Arce?
No, sir.
All right, Mr. Arce, is Ms. Arce free to go, Mr. Diamond?
Yes, Your Honor.
All right, you're free to log out, sir. You'll be getting a copy of this order. Good luck to you and the kids. You take care, sir.
Thank you.
All right, we're off the record.
Child will be around other people that you may not like wife or other people, or husband. That's just the way it is.
One time, she did shoot in my mother's house.
So as far as physical fights between the two of you, have there been any physical fights between you two since the child was born?
No, ma'am.
And you said that she shot at your mother.
She was like, she had to be around. I couldn't come around with my wife. It got to the point to where she was making up different things. She lied about being pregnant one time.
The child support calculation that was giving her so much child support had her income at $15,000 per year. When we recalculated child support, the child support was at $50,000 per year for Ms. Chilton's income. And that was what it was recalculated on. Client's kind of stuck where he's overpaid child support for years, essentially.
I was not trying to be deceiving in any way.
Arthur Robertson versus Brandon Chilton. Today is
the court will note the appearance of Ms. Greenlee-Clore on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for repayment of overpayment of child support. I've read the pleadings, Ms. Greenlee-Clore. Is there anything else you have to add?
The only other thing I have to add, Your Honor, is looking back at the documents, the calculation, first of all, Ms. Chilton is an intelligent woman. She knows how child support works. The child support calculation that was giving her so much child support had her income at $15,000 per year. When we recalculated child support, the child support was at $50,000 per year for Ms. Chilton's income. And that was what it was recalculated on. There's no way that Ms. Chilton knew, or there's no way that she did not know that child support shouldn't have been at that level that it was at. And I don't know that's not up for debate today because it's already been modified. But at this point, my client's kind of stuck where he's overpaid child support for years, essentially, to Ms. Chilton, but he has no way to get any of that child support back. And as our motion indicated, he tried to pursue this. It didn't come back. And I think what we need to do is we probably need an order from this court with how this is supposed to get paid so that if he does need to, he can pursue collection action. Okay. Thank you, Your Honor.
Thank you. Ms. Chilton, what's your response?
Good morning. At the time when this was calculated, as I presented to the court, I was only working part-time, and the order was based on that part-time work ending in that summer of June or whenever that school year ended. And again, as I put in my answer, that I was not going to be working over the summer because I was going to school. And then once I went back to work in August, which, I did have a full-time job at that time, that is when I submitted the documentation to the child support court that I was in fact earning more money. So I did submit documentation. I didn't understate any income. We had to submit documentation to the court at that time to prove my income at that time. And so I don't feel like it is at my fault that that the child support stayed in that way. Once I submitted documentation to the court of my full-time employment, it had not changed, so I took it back to the court. I submitted it twice, as you will see in the documentation and supporting evidence that I did submit this documentation to the court twice. So I submitted, I did everything that I knew to do. I was not trying to be deceiving in any way. I submitted the information that I had that I knew that I needed to submit. And that income was based on him working more at that time. And then he went on to a different job that caused him to make less. So the recalculation, I'm not sure where the $50,000 is coming from, but again, I was not working prior to that due to COVID. And then I started working part-time, and the childcare that I was asking to be paid for at that time was not being paid for. So that's when the child support came up, because he wasn't meeting his obligation that we had agreed upon.
Okay. Well, in this particular case, I'm not going to address the issue of the amount of support because that was changed and it's already been resolved. I understand the arguments, but it would be inequitable to charge the plaintiff an amount, and again, it would in essence have him paying over $7,000 that he should not have had to have paid had it been calculated at that correct amount at that particular time. So the court is going to grant the motion for the repayment. Ms. Greenlee-Court, what I'm going to do is order that the amount of $6,891 would be repaid over the same term that it was collected. So if it was collected over, I think you said over 12 months, then that would be repaid over 12 months. If it was longer, I just don't know based upon the pleadings that are filed over what time that was collected. So I'll simply order that you can figure it out when it was collected and then have the repayment over the same term.
Your Honor, so just to clarify, dating back to the court backdated support to March of 2022. Are you saying March of 2022 to today would be the repayment period?
No, I'm saying the time that he paid the overpayment, that the repayment would be over the same term. So if it was 12 months, if it was 18 months, I don't know from the time that he began paying that $764 and the time that it changed to the 34. So it would just be repaid over the term that it was paid.
Okay, and equal monthly installments, Your Honor?
Yes.
And then no, we also made a request for attorney fees in this case. Is that
I'm not going to award attorney fees in this case.
Okay.
It sounds like there were enough issues and problems in the case to go along. I don't hold anybody responsible for that.
Okay, thank you, Your Honor.
Okay, thank you. You're free to go. You can submit that under 7 days.
Thank you.
There was a fraud committed on the court. Plaintiff had filed a motion to set aside referee recommendation, claiming that the defendant was making more than that she had told the court. Sir, at the hearing on October 20, 2023, you could have presented any evidence you had concerning her income. Why didn't you do that?
Well, I actually sent out I sent out a subpoena for it, but I might have sent it out too late. I have a date my date of delivery was on when I got this back was on the 18th. I think that was what, 2 or 4 days before the actual hearing. So I sent out for the evidence, but I got it sent out a little too late, I believe. Not enough time to get it back.
Well, a couple things you could have done at the hearing. You could have asked the referee for an adjournment to be able to get that information, rather than at this point, you don't, my understanding, you don't have any information now at this point that would contradict her testimony. Is that correct?
Correct, because they still haven't sent it to me yet. I sent out the like I said, I sent out the subpoena for it, but I never got the information.
Okay. Well, what the court's going to do is the court can't just speculate as to what somebody's testimony may have been. What I'm going to do, no,
Can I
you can't.
say something?
You don't need to, ma'am. What I'm going to do is I'm going to deny your motion, sir. If in fact you get information that in fact her testimony was incorrect, you always have a right to file a motion claiming that there was a fraud committed on the court, and the court could take that up. Likewise, you also mentioned that you are now paying for medical insurance that you hadn't before. If that's correct, send the information to Mr. Todd, and maybe at that point he would agree to modify that, taking into account or giving you a credit for that medical premium. But at this point, you don't have anything which would cause the court to, again, modify and change the referee's order. So I'm going to deny it at this particular time. But that would be the way you want to proceed if you get other information, sir.
Okay, so I have another question. As far as he backdated it to July.
He would date it to the date that the notice of again, the modification would have occurred. That's correct.
Yeah, so that put me over $1,600 in arrears
I
already.
understand, but what happens is during that interim period of time, you weren't paying the correct amount. So that's always a risk because we don't know if it's going to go up, if it's going to go down, et cetera. But again, the referee did exactly what he was supposed to do, is he would have modified it effective the date of the motion to modify. So he did everything correct. So again, the court's going to deny the motion, and that will conclude this matter at 10:36 a.m. You're free to go. Have a good day.
Your Honor, did you want me to prepare an order, or was the court going
No,
to-
the court will have an order that we'll send out.
Okay, thank you, Your Honor.
Okay, thank you.
He still refuses to provide Ms. Smith with his new address. More importantly, the plaintiff has not seen or had contact with the remaining minor children since he moved to Kalamazoo. He's missed their holidays. He didn't even wish them a Merry Christmas. He has not even reached out to my client to ask about the children's well-being. Just a little before moving to Kalamazoo, he did send the children a text message stating that he had sacrificed financial stability and freedom for them, which we attached as an exhibit. Even though he hasn't seen the children in about 6 months, my client, due to the current child support order, has been paying child support to him, even though he hasn't had the children with him and he hasn't provided any financial support.
Court will note the appearance of Mr. Vanderhorst on behalf of plaintiff, Mr. Umloff on behalf of defendant. This matter is before the court on the defendant's motion for modification of custody, parenting time, support, and other relief. Mr. Umloff.
Your Honor, the parties have 2 children, ages 16 and 14. Their current orders give them joint legal and joint physical custody and equal parenting time of those children. However, circumstances have changed significantly. In August of last year, the plaintiff moved from his house in Battle Creek to a 2-bedroom apartment in Kalamazoo, Michigan. He did not tell Ms. Smith when or where he planned to move, and she, in fact, did not learn that he moved to Kalamazoo until months later. He still refuses to provide Ms. Smith with his new address, despite a request that he do so. He hasn't updated his address with Calhoun County friend of the court. It appears he is working for his apartment complex, but I do not know which apartment complex that is in Kalamazoo, and there are many. More importantly, the plaintiff has not seen or had contact with the remaining minor children since he moved to Kalamazoo. He's missed their holidays. He didn't even wish them a Merry Christmas. He hasn't attended their sporting events. He missed the 16-year-old getting her driver's license. He has not even reached out to my client to ask about the children's well-being. Just a little before moving to Kalamazoo, he did send the children a text message stating that he had sacrificed his financial stability and freedom for them, which we attached as an exhibit. Because he now lives approximately 40 minutes away, and the minor children are in Penfield High School and involved in the community, they have several extracurricular activities in this area. It is simply not feasible to continue a 50-50 parenting time schedule. The children have been deeply hurt by the plaintiff's decision to cut them out of his life, and for that reason, do not want to go back and do not want to live with him full time, and certainly do not want to live with him half the time. Even though he hasn't seen the children in about 6 months, my client, due to the current child support order, has been paying child support to him, even though he hasn't had the children with him and he hasn't provided any financial support for the children. For this reason, what we are asking is that the court grant my client legal and physical custody of the children and award the plaintiff parenting time at her discretion. We also ask that the child support order be recalculated according to the formula. If the court is inclined to order an evidentiary hearing on this matter, we would request that my client's child support obligation be suspended as we wait for that evidentiary hearing. We would further ask that my client be permitted to claim the minor children as dependents for tax-related purposes, as they have been living with her full time. And again, if the court is inclined to order an evidentiary hearing, I would request that we be permitted discovery to further explore where Mr. Pemberton is living and where he is working, and to get a sense of his income in advance of that hearing. Thank you.
Okay, thank you. Mr. Vanderhorst.
Yeah, thank you, Your Honor. Does the court have my answer?
Yes, yeah, we received that.
Thank you, Your Honor. When we filed that answer, my assistant noticed that my answer was a 201st entry in this case. I'm new to this case. The courts are well aware of the long history in this case. The divorce was in 2013. Here we are 11 years later. The parties have 3 children. Mackenzie's 18, Michaela's 16, and Madeline's 14. So the courts has jurisdiction over the 2 younger daughters. There's a lot of false statements in this, Your Honor. My client has given his address. My client has given his address to the friend of the court. My client has not seen the girls. The girls are teenagers now, and it is not because of his doings. Believe that there's just an environment at the home of the mother that does not promote it, that does not respect the court order. And so the defendant here has been really in violation of the court order for the last 6 months. My client did sell his place he had in Battle Creek area, did move to Kalamazoo. That's the most of his work is in the Kalamazoo area. He has a nice 2-bedroom apartment that has a bedroom for the girls to stay. He did purchase a car for them. I believe Michaela can drive now. She's 16, and he loves his daughters very much and would like to continue the parenting time arrangement. There's an established custodial environment with both parents, Your Honor. The other important factor in this case is there was a court order before regarding counseling, and I believe counseling now would be very, very fruitful. And I did reach out to Margaret Hunter, who's a very skilled counselor. I've used her before in other cases that could deal with the family issues we have here with the teenage daughters and the parents. And I have made that known to opposing counsel that Margaret Hunter, I've spoken to her, would be willing to take this case on and get involved with this family to kind of bring healing back to this family. I know the counselor that was court ordered before has retired. So she is no longer practicing, but I believe this case would be just tailor-made for Margaret Hunter. As far as the tax exemptions, there was a court order to that effect back in May of 2015 that awarded the tax exemptions. And my research was, I'll give you, it's been a few years on tax exemptions. They can be either be property where they're non-modifiable if they're awarded, or they could be awarded in child support. But in this case, clearly they were ordered back in 2015, where the parties basically share the children because they've been sharing the children as far as parenting time. So going forward, Your Honor, I would like the order to be enforced. And the issue of child support, my client's willing to say no child support. He would terminate the support as far as I think she's paying $100 a month, Your Honor, or something to that effect. Would waive that for now, but he does make substantially less than the defendant. I believe that I haven't subpoenaed incomes or anything, but I believe the defendant is making close to $100,000, if not more. My client he's self-employed, $50,000 or so. So he makes substantially less anyway than the defendant. But I would ask that the court order be followed, Your Honor, that counseling be ordered in this case once again with Margie Hunter, who's a very good counselor, that the defendant, not badmouth the plaintiff at home or do anything to that effect, promote the girls to see their father, and to go forward in this case in a positive way. We only have a few more years left before we're across the finish line, and I think counseling actually would be very helpful to these folks.
Yeah, thank you.
Your Honor.
Mr. Vanderhorst, when you say that your client's willing to terminate child support, do you mean actually we terminate that effective at this time, or are you talking about suspending it?
Oh, well, yeah, I probably used the wrong term. I would say we would suspend support now. To move this along as far as what the defendant is paying him at this point in time. I think that would be an act of graciousness as well.
Okay, thank you.
Your Honor,
Mr. Umlauf, what's your response on the counseling issue?
Firstly, I have not received opposing counsel's answer to my motion, but he and I have had extensive discussions, and what he's presented today is consistent with what he and I have talked about. As it relates to counseling with Margie Hunter, we would not oppose it. I did have an opportunity to speak with Margie Hunter, and she did confirm that while she had spoken with opposing counsel on this matter, she has never treated Mr. Pemberton or had any involvement with this family previous. And so I think she would be an appropriate counselor.
Okay,
However,
go ahead.
I would still note for the record that given the distance and the length of time, our position is still that this is a significant enough change of circumstances to warrant an evidentiary hearing to revisit legal and physical custody and certainly parenting time.
What we'll do is the court does believe that based upon the pleadings and basically the argument today, that the defendant has met the threshold of the BARCA for proper cause change in circumstances sufficient for an evidentiary hearing. The court will, in the interim, based upon the stipulation put on the record, the court will suspend the child support obligation effective today's date through the pendency of this until we have resolution of this matter. The court will further order counseling with Margaret Hunter. The parties can utilize that for purposes of, if you want to say co-parenting, or also for purposes of reintegration counseling, whatever you want to call that, but we will set it up in that manner. I'm going to give you some period of time, maybe 90 days of counseling before we would schedule the matter in, but we will contact your offices and find out a time when you're available after the 90 days. And hopefully Ms. Hunter can make some inroads and then make a recommendation to us at the end of the 90 days as to where we're going to proceed with counseling, or how the counseling is going, et cetera. Mr. Umlauf, I'll ask that you would prepare the order, and you can submit under 7-day.
Well, one question, Your Honor, and that is, what about my request for discovery as we await the evidentiary hearing?
Well, you've got 90 days to while the counseling's going on. I guess you could effect discovery during that 90-day period.
Thank you, Your Honor.
You can put that in the order as well, Mr. Umlauf.
Thank you, Your Honor.
Okay. Thank you. You're free to go. Have a good day.
Thank you, Your Honor.
Thank you.
Do you understand what I just ordered?
Yes, I understand what you're saying, but he's
I
right
don't,
here.
ma'am, this is not up for discussion. This is an order.
Mom came and took one of her 3 kids away from the guardian.
Mrs. Yusanovich, where are you on this?
We are adamant that, well, Mickey and Mackenzie and Colton are both right here with me. They have written declarations stating they do not want to go back with their mother. We were at a point where the last time we saw Commissioner Nelson, we were going to continue with the evidentiary hearing. However, on October 8th, Tesla came into my home and took Braden. I was not able to get on the phone. We kind of live out in the country, so I wasn't able to contact 911, which is a whole nother issue. But once the sheriff did arrive, he said that because Commissioner Nelson did not put in writing on the minutes that I had that the children should stay in my custody until I filed the evidentiary hearing, you know, to continue it, that there was nothing they could do to uphold it. So that it basically, they couldn't go get Braden back. However, I am requesting that we continue with the evidentiary hearing. Again, Mackenzie and Colton are here. They have written declarations, and I can get those filed. I can get the notice for the evidentiary hearing filed today if you'd like. But the kids would like their brother returned back immediately. He was going to school here at Lexington Elementary, and then I got a call on Monday or Tuesday saying that she was trying to put him in Columbia Heights Elementary. So they had questions about that. I don't know if Braden went to school yesterday or not, but upheaving him from his home, and these kids have been here since last December.
Okay. Hang on, ma'am. Hang on.
Yeah.
Ms. Smith, are you there?
Yes, I am.
Oh, Mallory Smith?
Good morning, Your Honor.
Good morning. Have you been able to do any work in this case?
Your Honor, I have met, and I apologize, I have limited bandwidth right now. I have been able to meet with the children in this case and with Ms. Yozanovich. I've had conversations with Miss Ivy as well. Father's been pretty avoidant of this matter in totality. It would be my recommendation to the court to consider Ms. Yozanovich's preference right now. The children have expressed a desire to remain in Ms. Yozanovich's care. It's been a consistent and stable home. I'm proud of Miss Ivy for pursuing and maintaining sobriety. She indicates having 6 months clean and attending meetings and participating in those things. The children unfortunately have a long history of just living in influx while in Miss Ivy's care. So their concerns are valid. They do want to remain connected to their mother, but they are just in a place right now where they do appreciate and are feeling much more stable and able to participate in schooling and extracurriculars and those types of things while in the care of Ms. Yozanovich.
Miss Ivy, what do you want to tell me?
Your Honor, I do have my son in school.
Where?
At Columbia Heights Elementary. And he's doing very well. I've got him potty trained because he wasn't potty trained. He is happy with me. He does want to live with me.
Okay. I don't want any schools changed. So whatever school he was in last week is the school he's going to be in going forward. Understood?
Then
Yes.
that would be Lexington Elementary. That you mean the school that he was originally.
Ma'am.
Yeah.
Miss Ivy, do you understand what I'm saying?
Yes, Your Honor. He likes it at Columbia Heights.
Ma'am, do you understand what I'm saying? The child's going to be in the school he was in last week. Period. End of conversation. Do you have any question about that? Miss Ivy, do you understand me?
Yes, Your Honor.
And that happens tomorrow. You understand that?
The same school he's in now, because he's doing
He
really good.
goes to Lexington Elementary tomorrow. Do you understand that?
How is that when he's already going to Columbia Heights?
Do you understand what I just ordered? Yes or no?
I understand what you're saying, but he's
I
right
don't,
here.
ma'am, this is not up for discussion. This is an order. He will be at Lexington Elementary tomorrow. Do you understand that?
They told me though that because of where he lives with me that he couldn't go to Lexington. That's the only reason why I changed.
I'm going to say this one more time. If
I
the
do
child's
understand.
not at Lexington Elementary tomorrow, I'm issuing a warrant for your arrest. Is that clear to you?
I said I understand what you said.
Is that clear to you?
Yes.
All right. That's number one. Number two, we need to set a hearing date on this immediately. So we're going to set a hearing on this matter for next week at 11 o'clock. It will be the last case on this calendar. I want it to be in person here at the courthouse. It'll be the last case on this calendar. It should start no later than 11 o'clock.
Okay. And do you want Mackenzie and Colton to be present, or are the declarations going to be sufficient for
No,
you?
I don't want the kids present in person. I just want the adults.
Okay.
And Ms. Smith, are you available then?
Yes, Your Honor. And to confirm, this is for trial assignment or for evidentiary hearing?
This is going to be an evidentiary hearing on the original petition.
Okay, thank you, Your Honor.
All right.
And then, Your Honor, I just have one question. So is Braden going to stay in Miss Ivy's care, or is can I pick him up from school tomorrow when she takes him?
I'm not making any change on where kids are living at the moment. We'll have to make that decision next week.
Okay, no worries. Just wanted to make sure.
All right.
Thank you, sir.
That will be all.
Let's be honest about it, Mr. Averitt. I mean, you testified that you make $3,500 over 2 weeks, but your employer told the state of Texas that you made over $145,000 last year. That's a lot more than 35. That's a lot more than 3,500 every 2 weeks.
Wow. Well, like I said, I can get a letter from our employees stating what I'm saying today.
The problem is, Mr. Averitt, is that your employer has already told the Attorney General what they paid you last.
The father was the custodial parent and the mother was paying child support.
Wondering if it's possible to get back pay for the year that I had them.
Ma'am, when you say back pay, what do you mean?
I mean, for the year that, because see, the money that was taken out of my paycheck this whole year, can I get money from him for that past year?
There's been a change of circumstances and the children have been living with the mom since August 2022.
Just a little bit of background on this case. We had previously had an establishment order where the father was the custodial parent and the mother was paying child support. Children, there's been a change of circumstances and children are now with the mother and have been since August 2022. We've reached almost a full agreement. I'll read the agreed portions into the record, Your Honor.
All right.
Parties agree that child support arrears for mother are $0 as of March 5th, 2024. And of course, the payout would be zero since those arrears are confirmed at zero. Medical support arrears for mother would be $6,986.31. As of March 5th, 2024, parties have agreed that that be paid out at $0. As such, child support and medical support should be set at zero from now on for the mother since she has the children. The parties have agreed going forward, mother should continue carrying the insurance through a third party. That insurance is through the marketplace at a cost of $50, but the mother is not asking for medical support. So medical support for the father should be set at zero. As of 4/1/2024, the sole contested issue is the issue of child support over the father to pay. I now call the mother. Ma'am, can you state your name for the record?
Amy Haney.
Ma'am, the state has calculated child support at $443. Are you in agreement to that?
Yes.
Ma'am, the issue, has there been any family violence between you and the father since the last order?
No, ma'am.
And is there any reason that your address should remain private from the court record?
No, ma'am.
Okay, and are you asking the judge to accept the agreements we've reached so far?
Yes, ma'am.
Do you have anything else you would like to say?
I was wondering if it's possible to get back pay for the year that I had them or not. He did send me $2,000 the other day, but that was because he claimed the girls. So he really wasn't supposed to do that, but he gave me money to, to put towards the girls. But
ma'am, when you say back pay, what do you mean?
I mean, for the year that, because see, the money that was taken out of my paycheck this whole year, can I get money from him for that past year?
So ma'am, do you understand that the child support was set at zero because you were given 19 months of credit for possession of the children?
Mm-hmm. Because I paid it?
Because you had them.
Yeah. Okay.
So this would essentially be asking for you to be paid twice. So you owed, so do you understand that?
Oh, okay. Yeah. I get it. Yeah. I'm sorry.
Okay. I pass this witness. I now call the father. The state has calculated child support at, one moment, $443, giving you credit for your additional minor child. Are you in agreement with child support being set at that amount today, sir?
Yes, ma'am.
Okay. And you understand that that would start on April 1st, 2024?
Yes, ma'am.
Has there been any family violence between you and the mother since the last order?
No, ma'am.
Okay, and is there any reason that your address should remain private from the court record?
No, ma'am.
Do you have anything additional you would like to say to the judge?
No, ma'am.
Okay, I pass this witness, Your Honor. I believe that now on the record, the parties are in full agreement. I ask that this agreement be accepted and be made the order of the court.
All right, I will accept the agreement. Either one of you have any questions?
No, sir.
No, sir.
All right, then she's going to email both of you a copy of this order. If you have no additional questions, you can press leave and you're free to go. Thank you both. I appreciate your time today.
Thank you.
I always have a concern when somebody pays nothing, month after month of $0 paid.
The day after I had my baby, we got hit by a drunk driver and my car got totaled. So I haven't been able to return to work for lack of transportation and lack of childcare. We have to choose between paying the child support or paying rent. And I can't in my right mind put my brand new baby and my stepdaughter homeless to pay my ex money for the kids when he's making more money than we are on a regular basis.
We only have to 2 child support payments made in 12 months.
So we're on here today for review regarding contempt. And my concern is we really have not changed course. If you look back through the pleadings, we've started the contempt back in April. It took us some time to serve Ms. Stockwell. We were before the court, I believe in June. And then we had a review, and then we set this review out even further. The issue here is that when you look at the debt calculation, we have no child support payments made in January going all the way to June. We have her basically getting served, the court kind of giving her some ultimatums. So we see a small payment in June, a small payment in July, and then once again, nothing in September, nothing in October, nothing in November. Here we are, December. So if you look at this sort of little debt calculation just for 2023, and assuming, here we are, December, not seeing any payments made. So essentially over the course of a year, we have 2 months out of 12 where anything has been paid. And I always have a concern when somebody pays nothing, month after month of $0 paid. So it's not, I couldn't scrape together 20 bucks. I couldn't scrape together anything. And so that does get to where we're talking about intransigence, is somebody who just says, not going to do it, and you can't make me. And that's where the teeth of the sanction, unfortunately, need to get sharper for Ms. Stockwell. My client's been very patient. We've kicked this out, for not just like a month or 2 weeks, get a payment, but sort of like months at a time, saying, hey, kind of get it together and start making a plan and start making payments. And Ms. Stockwell just, instead of sort of taking that grace from the court and from my client, has kind of just blown it off. At this point, we've been at this again since April when we filed the contempt. We're kind of done with some of those simpler encouragements. And we're at the point where we need some teeth to get Ms. Stockwell to get real about the fact that she has to make payments. She has to pay child support. So at this point, I think what is most appropriate, we've got a couple weeks. So either I'd like to come back on the 26th, or in my preference, it's the 26th because Your Honor is here. And I know that the docket changes in January, but essentially I'd like to see some real payment this month. And if she doesn't, that she shows up on the 26th in person, ready to spend some time in jail until she writes a plan on how she's going to pay. Because so far, none of this has gotten through to her, and it's been an extended period of time where these children who are entitled to support aren't receiving it.
Thank you. I just, for the record, I do see that, so there was an order on contempt that was entered in June for the April contempt. And then there was, it appears, a satisfaction or partial satisfaction, a judgment in July after after the amended tax return was ordered. And then in August, there was another $250 in attorney's fees ordered. I'm assuming that, or has that been addressed? No.
No, she has not paid those. And we've tried to give her credit anywhere where it's appropriate to do so. And you can kind of see from that debt calculation that in August, she paid a little bit over the total arrearage, I think by about almost $300 over the sort of monthly amount towards the arrearage, which was good, but then once again, no payments thereof.
All right. Ms. Stockwell, any updates for the court here?
Yes. So we have been trying to figure out how to piece together a plan because the day after I had my baby, we got hit by a drunk driver and my car got totaled. So I haven't been able to return to work for lack of transportation, and lack of childcare for lack of transportation. And we've been scrapping together and trying to piece together money, and neither of us felt like the $20 would make a difference. So we've been trying to make sure we are able to pay a lump sum so it doesn't look like we're just, here's pocket change sort of thing.
I don't care if it's $20, pay it to the court. Of course, if somebody pays $20 for the court, I tell them, why even pay it if it looks worse?
We've been trying to rework billing. We've put off paying multiple things, just trying to come up with the money. Right now we're in this space where if we have to choose between paying the child support or paying rent. And I can't in my right mind put my brand new baby and my stepdaughter homeless to pay my ex money for the kids when he's making more money than we are on a regular basis. I would absolutely love to be paying them. I would love to be able to help support them. That is my goal. And my boss is very understanding about the fact that I can't get to work. She said, as soon as I am able to get transportation, I'm able to start right back up. We've been keeping in contact every 15 to 14 days to make sure that I'm still trying to find a car. I've reached out to family members to see if they'd be able to help so that I can get back to work and get back to paying. Where there were payments to the child support, those were months when I had a steady job and had finally gotten all of the auto like taken out of my paycheck directly sort of payments, so that it was one less headache of trying to schedule payments and get everything figured out. I have applied at jobs for stay at home. There's not many that are actually hiring. Just kind of a, hey, apply. And then I never hear back from them. I just heard back from a job that I applied to in January saying that they were full and didn't need anybody. But I've been applying for jobs stay at home wise so that I can still be able to put money towards this. But if the $20 is going to make a difference, I will send the $20 we have or the $5 or whatever we end up having left over. I will gladly send it. I just didn't think that was going to make that big of a deal, or even really look good to the court's eyes for me to be sending pocket change. So my apologies for not knowing that that would be such a big deal. And that's about all I can say right now with not being able to even get to work currently to help pay for this.
Briefly.
Yes, just so I just want to confirm. So, and I'm sorry to hear about the car accident. Nobody was injured. Everybody's okay, other than the car, I guess.
No lasting injuries.
Okay, I'm glad to hear that. Yes, Ms. Baldwin, go ahead.
So unfortunately, these are sort of similar story, different day. Anytime we come to court, it's always sort of a woe is me. Gee, all these things have happened, and perhaps that would make sense to consider if we were in a situation where I set the review like 2 weeks and we were sort of dogging her the whole time. This is a case where we are setting reviews out months at a time, giving her an opportunity to sort of get it together, and she never does. She makes these choices of, I basically want to be a stay-at-home parent to this new child that I chose to have and to my boyfriend's child. Instead of, the boyfriend has an obligation to take care of that child. That is not her obligation. So these are choices that are being made, and perhaps collectively between her and her boyfriend, but there's ones where they're consistently over a year, 10 months out of 12, deciding that the 2 children that she had with my client deserve $0. So again, we're making choices, and she's had a year at this point, or since April, I guess, since we filed the contempt, to get these things together. She just never does. And unless there are some true teeth to the court's order, she is never going to do so. So that's where, we've put it out long periods of stretches, hoping she would get things together. She just isn't. And unfortunately, we need to have a harsher penalty. And I believe that will unfortunately result in action, because so far what we've done has not resulted in really any action on her part. It's all, gee, I wish I could, but even now there's no stated plan on how she's going to pay. It's completely vague of, here's what I'm doing, here's what I've done. It's sort of all, well, if something comes around, I guess I'll pay, but that's about it. That's not appropriate when we're talking about child support. The children in my client's home, they don't deserve support. This is a court order, not a, gee, we'd like you to do this some period of time.
So I understand the frustration. I understand Ms. Stockwell's circumstances. It's unfortunate the court often sees folks have kids and without the forethought about how they're going to support those kids. And in this case, it's I understand the frustration here. There was an order of child support entered in January that changed the temporary support, and in the most recent debt calculation, it appears that as Ms. Baldwin stated, there was a payment made in July of $90 and August of $780. For a total of $870, and the arrearages just for this year alone are over $5,000. So while I understand making decisions between being homeless and providing for other children, there is an order in place. So here's what I will set a review for December 26th at 1 p.m. I would ask that Ms. Stockwell be present in person on the 26th at 1 p.m. However, Ms. Stockwell has until December 15th at noon, so that's next Friday at noon, to provide a plan to Ms. Baldwin's office regarding payment of child support. As you know now, Ms. Stockwell, some payment is better than nothing. No payment is kind of like a middle finger to those other two children that you have, and that's not appropriate at all. I appreciate you saying, well, we want to give bigger chunks. Doesn't matter. Frankly, the court would see a $25 a month, $50 a month payment as much better for everyone than 0.00000. If the plan that's provided to Ms. Baldwin's office is acceptable to Ms. Baldwin and her client, that date on the 26th can be struck. And if you want to renote it for another review, by all means, we can do that. If it is not acceptable by Ms. Baldwin, and so I'm putting the ball in Ms. Baldwin and her client's court for this, if that plan is not acceptable, then I expect Ms. Stockwell to be in person for court on December 26th, 2023 at 1:00 p.m. on the second floor of the Hall of Justice. And I guess the implication, Ms. Stockwell, is the court is most definitely considering jail time in lieu of child support, as this is just, it's gotten out of hand, and it's only going to get worse and worse the longer non-payment happens, and those arrearages are just going to keep growing, and then interest will start applying, and it's not good for anybody. Okay. So Ms. Baldwin has the authority to strike that 26th. And if they don't feel the plan is sufficient, and frankly, if there's some negotiation between the parties after you review the plan, I'm fine with that. I feel like Mr. Gilliam and Ms. Baldwin have been willing to work with you, Ms. Stockwell. So, the sooner you get a plan to them, the more opportunity you have to have some discussions with them about how you're going to address this moving forward. Okay. Any questions or concerns?
No, you are. Very good.
Thank you.
All right. Good luck.
Because of the, yes, corrupt nature of the court, there's a felony on my record, and that should not be there. And so I'm struggling to gain employment. When I requested this entire child support review, he bought a house in Tennessee and he still owns that house in Tennessee.
You signed a contract in June of 2022. Essentially,
Based on the information that David Reynolds was going to be, I was forced to sign that, claiming that that was the only way I could see my kids. Who would not allow me to present anything, just like now.
I understand that I have to pay something for Nathan, but it just feels unfair because Jake deliberately took them from me. I believe that this was very much orchestrated. His motive 100% of the time has just been to get money from me. So they just kind of used what I had made year to date and then divided that out.
If you pick up a quarter on the street corner, it's income. If I grant you an order to enforce your parenting time, the police will not enforce it.
Mom has an objection regarding the amount of child support that she is ordered to pay.
Both of you received the recommendation, and ma'am, you're the objecting party, so let's go through your objections. Why don't we start with the pay objection? Go ahead with that one.
So they just kind of used what I had made year to date and then divided that out. But I work in healthcare.
That's the mathematical equation they use. They take the longer in the year that we've got you, the more likely it is that it's most accurate. The closer we get to December, that's your yearly income. And on the front of the court, if you pick up a quarter on the street corner, it's income. Basically.
So my only objection to it was that because of COVID and healthcare, I had these extra shifts that I was working. And when the COVID subsidies ended, those were no longer available for me. So that's why I supplied kind of what my salary is.
Do you have a current pay stub?
I can get one to you.
Supposed to be doesn't matter. Actual matters. So if you're working overtime and stuff, that's all considered.
Yeah.
The law does not have a choice.
Going forward, those wouldn't be available to me.
Well, the going forward is something that we will look at going forward. Right now, because forgive me, but we've had a lot of people that come in at this point, look at their employer, go, I'm stopping overtime.
Oh,
then they come in with your store
overtime.
Or shift differentials or extra shifts or whatever. But then they stop it and then they come in trying to make that complaint. And a month later, we find out they're doing it again. So forgive me.
I understand that.
Yeah. That's why we always use the past, not the future.
Sure.
And if you're lowered income, you can come back in like 6 to 8 months and show us that, hey, there's been 6 to 8 months. You've got my income wrong. That's a valid argument 6 to 8 months from now, when you can show us that it actually stopped and didn't restart.
I'm here to rule on cases. I am not permitted to give legal advice. It would be a violation of ethical codes and improper.
Sure, that's fair. I understand that.
It is what it is, then we relook at it. But a change of circumstance in child support is a change in your income through no fault of your own.
Okay.
All right. As to your argument as to his income, I can tell you that how this is calculated is 100% based on your income.
Okay.
Normally, it's based 96 to 98% on your income.
Okay.
Mathematically speaking, because there's 0 overnights, what the thing does is it calculates what percentage overnights you have, what percentage he has. It calculates what he would pay you if you had 100% custody, then what you would pay him if he had 100% custody, and then it subtracts the 2.
Okay.
And that's what generally went. But since there's 0 overnights, anything times 0 to his income mathematically is 0. So I can double his income. I can cut it in half. It will not affect this.
Okay.
Also mathematically, anywhere from 1 to 70 overnights minimally affects the child support.
Okay.
And that's based on the fact that they don't want people arguing over the standard parenting time of every other week, every other weekend, 3 or 4 weeks in the summer, every other holiday, every other spring break.
So I guess
mathematically speaking, they carve it out. So 0 is just one of those weird exceptions, but 1 to 70 doesn't do much either.
Okay. I guess I have a question about that too.
Sure.
Because our custody is in dispute. I technically have custody, but he is in contempt in keeping them. So that doesn't matter that he's just
in what way is he in contempt for keeping them? How is that?
Our divorce decree stated that I would have Jack 100% of the time, and then he would have Nathan Wednesday night for a couple hours, and he would return home, and then every other weekend He'd have them Friday night,
Okay,
Saturday night, overnight.
So I guess my question would be, has this been sent to the front of the court for a custody review?
So what we've been doing is mediation. What happened was
Okay.
Nathan ran away, and then
Oh, okay.
so we're in the midst of all of that. And
So,
like
so,
I
so
get it,
Nathan,
like our like my
Nathan voted with his feet, basically.
and his dad kept
Well,
him.
and Jacob, we'll get to Jacob because I think Jacob may be or may not be in or out of the picture. Because
Okay.
he's 18, I can't control what I lose jurisdiction of parenting time in custody when they turn 18. The only thing I can maintain is child support as long as they are attending full-time high school.
Okay.
with
And he's
anticipation of
graduated
accolade.
and he's 18. So
Mr. Warner, what has happened with Jacob? So he's graduated?
Jackson graduated December 21st or 22nd of this year. He turned 18 in October.
Okay.
So our review was done. She was supposed to pay November and December for Jackson and Nathan.
Yeah, that's what would happen. That's why both of them are on it then, because it would continue through December 31st after he graduated. So it's 18 and out. So basically he's 18 and now he's out. So it would go to, it goes to the end of the month he graduated. So December 31st is when it would end. So November, December, and then the lower rate for the one child starts then, and it may be arguable because it may be preserved if you guys have been coming to court.
We've been going through this parenting counselor.
How old is Nathan?
16.
Yeah, good. Another 16-year-old running the show. Sorry, last motion day I had 4 motions with 16-year-olds running the show.
Yeah.
Because I have no legal authority to hold them in contempt. I have no legal authority to force them, and no police officer. Ms. Warner, if I grant you an order to enforce your parenting time, the police will not enforce it. He's 16.
I understand. The day Nathan left, I contacted the police and they told me that the other party had already contacted them to find out what would happen. And so right there, my hands were tied, and I've been going through all of the steps that friend of the court has asked of me.
And our problem is we can't hold people in contempt.
Your Honor, if I may.
Yes, Mr. Baker.
I gave overnight some scrutiny based on the submissions, and the last 2 parenting time orders grant Ms. Warner 0 overnights. That's a parenting time order from June 7, 2023, and from October 31st, 2023.
Okay, so we actually have
They're both
orders
stipulated.
Okay, thank you, Mr. Baker. Yeah, I'm sorry. I generally only concentrate on the child support order, but thank you for that, Mr. Baker, because if the court's ordered 0, then the court's ordered 0. There's not much I can do on the child support issue.
Okay.
But I would continue because the only thing we can do is probably order counseling eventually, but very rarely after they're 16 does that work. I'm not exactly sure what happened, but we keep trying. We'll keep trying it because we have to keep trying till they're 18. But at some point, there's not much we can do.
We're doing counseling, and I know my relationship with him is never going to be the same, and he's not likely to come back around until he's an adult and can see what it's worth. Right. I get that. And I understand that I have to pay something for Nathan, but it just feels unfair because Jake deliberately took them from me. I believe that this was very much orchestrated. He went through court to get custody the proper way in August of 2022. It was denied by the judge, and he kind of set this plan into motion after that. And I feel like I'm being punished for that. And, he had Nathan for a week and then filed to abate the child support. His motive 100% of the time has just been to get money from me. He has threatened me. I don't even know how many times. And he told me right off the bat, Nathan's not coming back. The only thing that I would ask is that with our mediation, our child support wasn't supposed to change. So I would hope that this would be going forward, and Jack would kind of be a moot point, and that maybe I could pay a more reasonable amount for Nathan, kind of the equivalent to what I was receiving.
I'm afraid child support is set by law. I'm not sure what it was calculated at before, but child support is set by law, and it's set by the actual placement of the child.
Okay.
That's why the court orders don't necessarily equate in this manner. In other words, yeah, it is unfortunate, but that's what the law is. And generally, this is the morning I unfortunately get to explain it to people that have never read it, and not many of us walk out of here happy.
No, I mean, like, I guess it is
Yeah,
what
I
it
know.
is, and I'll accept whatever it is, but I don't think it's fair and I
I
don't think it's right.
personally, I agree with you, but legally, I can't change it. It is what it is. We've got your actual pay. You can come back in 6 to 8 months and show that, you know, here's the annual amount that you calculated me on. That was based on this. I need it recalculated because that is long gone and this shows it.
Okay.
At this point, that's the best I can do for you, unfortunately. And I will give you both the same warning I gave everyone with 16-year-olds. They tend to vote with their 70% of the time, they vote with their feet and move back with the other parent after about a year with the parent they moved to, because they find out it's no different. The other 30% of the time they do change.
Nathan is out running wild, so he won't be coming back.
Well, you never know. If he's out running wild, he may wind up in the delinquency court, and then they control where the kid's placed.
Yeah, unfortunately, that might happen.
You never know. All righty. Good luck, everybody. It is what it is, so I'm going to enter the recommendation. Mr. Warner, did you have a question? Yes, ma'am.
Yeah, is this going to be like going back to when?
It starts on November 1st, which means you'd pay for the 2 kids from November to December, and then we are going to make sure that ends on December 31st for Jake, and it goes down to the only one child as of January 1st.
Okay, and then like if that is going to be a financial burden to me, is there a potential for me to pay a lump sum, like take out a loan to do that, because I can't afford to pay that?
You don't have to. It's only collected, like, I forgot, $80 a month or something until paid off.
Even that $750 towards Nathan.
No, the $750 is going to come out of your pay.
So that's what I'm saying. That $750 plus the $500 that I'm going to be losing, that's like almost $1,300 a month. I can't afford that with my bills. So I'm wondering if I could somehow get a personal loan, like to pay a lump sum just at once and be done.
You can't pay a lump sum because it's then non-changeable. What you could do is take out a loan and then use it like a HELOC and pay it. You take out of that loan monthly to pay the child support.
Okay.
It comes out to $172 a week. A month is 4.35 weeks. So while the charge comes in at a monthly rate of 12 months per year, because there's 26 pays for most people, not 24, it comes out a different amount. So it's $172 a month.
Okay.
All right. Take care, everybody.
The child support takes into account the multifamily income, but that child will be covered solely by her spouse. She's not responsible for the medical for that child.
Does the state have an oral amendment that it wishes to present?
Yes, Your Honor. The state pled for a suit for modification and confirmation of arrears. The parties are in agreement, and we'd ask the court to approve an oral trial amendment that also modifies conservatorship and visitation, and then we would modify for the mother, Your Honor, to pay child support to the dad based on minimum wage presumption.
All right, Mr. Krause, do you agree to that change in the pleading?
Yes, sir.
Ms. Allen, do you agree to that change in the pleading?
Yes, sir.
All right, that amendment is accepted and approved.
Thank you, Your Honor. And I offer into evidence as State's Exhibit a copy of the pay record in this case where Mr. Krause was ordered to pay child support for the children.
Ms. Allen, I just placed on the screen a copy of the pay record between you and Mr. Krause. Is it okay if I look at this pay record?
Yes, sir.
Mr. Krause, the same question. May I look at the pay record?
Yes, sir.
State's Exhibit A is admitted into evidence.
Thank you, Your Honor. If I may call as my first, Ms. Rachel Allen.
Go ahead.
Yes.
Ms. Allen, you were the obligee. You received child support in the prior order from 2020. Is that correct?
Yes, ma'am.
And we're here today modifying that order. It included 2 children before the court at the time, but your oldest son is now emancipated or 18 and graduated high school?
Yes, ma'am.
So it's just your youngest son. Is it Jacob?
Yes, ma'am.
Mr. Krause. How long has Jacob resided with Mr. Krause?
I believe since it was March of last year. I know it was spring break of last year.
Okay. And his child support obligation continued and you're not in, or you're in agreement for the court basically to confirm whatever arrears, but then order a zero judgment so he doesn't owe you any money.
Right. Yes, ma'am.
As well, you both agreed that you all will continue to be joint managing conservators and you'll have standard possession with Jacob.
Yes, ma'am.
And with regards to you paying Mr. Krause child support, are you working, ma'am?
I am a realtor at the moment. Yes, ma'am.
How long have you had your real estate license?
I got it in December of 21.
Okay. And who do you work for now?
Right now I work for Summers Cook and Company in Longview, Texas.
Okay. Did you file taxes in 2023 or 2022?
Yes, ma'am.
And what was your gross earnings at that time?
I believe it was around 35,000.
Okay. And did that include the real estate income?
No, ma'am, because I had just started. I was probably about a month into it.
Okay. What income did that include?
It included, I did have a job at the time from January of that year till September when I got laid off, but I was receiving unemployment.
Okay. So after you were laid off, you went to real estate school. That's 2023's income.
2023's income was, I had one closing and then I think about a month of unemployment.
Okay. So you actually made less than minimum wage all of last year. Because what we're looking at now then is last year.
Yes, ma'am.
And that's your reason, or you think it's in the best interest for support to be ordered using that minimum wage presumption?
Yes, ma'am.
Okay. Do you have health insurance available, ma'am, through your employer?
Not right now.
Okay. Pass the witness, Your Honor. Well, do you have any other children?
Yes, ma'am, I do.
How many other children do you have?
One child.
And how's that child covered by health insurance?
My husband just recently switched jobs and we are looking into private insurance at the moment.
And he'll cover that child?
Yes, ma'am.
Okay. Pass the witness, Your Honor.
Do you have an agreement in regards to how much the child support is going to be, Ms. Pinister?
I do, Your Honor. $192 for child support and $113 for medical.
Doesn't Miss Allen have another dependent?
She does, Your Honor, and that takes into account the child support takes into account the multifamily income, but that child will be covered solely by her spouse. She's not responsible for the medical for that, or it will not be responsible for the medical for that child.
What is the payment start date for this?
May 1st, Your Honor.
Oh, thank you. You can proceed.
Okay. If I may call Mr. Krause.
Yes, ma'am.
Mr. Krause, according to the pay record, as of March 31st, 2024, your arrears are $11,662.94.
Yes, ma'am.
You agree that the child Jacob has been with you though since about March of 2023?
Yes, ma'am.
And you're asking the court to grant you possession credit for that amount, and basically find that you have zero arrears as of that date.
Yes, ma'am.
As well, your support obligation be modified to zero, and it will be if based on the trial amendment for Miss Allen to pay you.
Yes, ma'am.
And you understand that we're basing her child support obligation off of minimum wage, the minimum wage presumption.
Yes, ma'am.
Okay. And you're asking the court to approve this order because well, let me ask you this. Do you have medical and dental insurance for Jacob?
I will in 60 days.
Okay. And you're going to be able to get it through your employer?
Yes, ma'am.
And you understand the maximum cash medical reimbursement is the $113 based on minimum wage presumption?
Yes, ma'am.
You're asking the court to basically, or you'd be ordered to carry health insurance and then Miss Allen reimburse you.
Yes, ma'am.
Pass the witness, Your Honor.
What's the agreement as to the judgments, Ms. Penister?
Your Honor, I'd ask the court to actually find that the arrears as of today's date or through April 1st is $12,712.40. Grant a possession credit in that amount and a final judgment of zero.
Okay, so you just want a zero judgment as of what date?
As of today's date, Your Honor.
So you're changing conservatorship to the father's primary, mother's being granted standard possession. The father is going to carry the health insurance. Child support and dental support is going to be, or child support, medical support is going to be $192 plus $113 beginning May 1st, 2024, and a zero judgment as of April the 16th of 2024.
Yes, sir.
Miss Allen, did you hear and understand the agreement that was just placed on the record of my court?
Yes, sir.
Is that your agreement?
Yes, sir.
You're asking me to approve that agreement?
Yes, sir.
Thank you. Mr. Krause, same question. Did you hear the agreement that was placed on the record?
Yes, sir.
Is that your agreement as well?
Yes, sir.
You're asking me to approve that agreement?
Yes, sir.
All right. Now the court's going to find that it approves the agreement that was placed on the record of the court today. Mr. Krause, Miss Allen, what's going to happen is Ms. Penister's office is going to send me that agreement that y'all just did on the record. If it matches what y'all agreed to, I'm going to sign it and get it back to them. Then they're going to make a copy of it and send it to each of you, okay?
Yes, sir.
All right.
How long has he resided with you?
Since he was born.
What is Miss Griffin's relationship to Messiah?
She is the mother.
Okay. And do you know the whereabouts of Miss Griffin presently?
Where she's at now?
Yes.
Yes, ma'am. She is incarcerated.
Okay. Do you know where?
I believe it's Harris County.
Okay. And do you know the nature of the charge that she's in on?
Yes, ma'am. They're drugs.
Okay. Judge, if I may screen share.
You may do so.
Okay. At this time, the state would like to admit the Harris County criminal records for Miss Griffin as State's Exhibit B.
So do you have any objection to me admitting that as State's Exhibit? Let me see what I entered the other one as.
Do I have a judge? No.
No, I'm going to be sharing my screen.
It's State's Exhibit 2. I'm going to admit it as State's
Two.
Exhibit 2.
Okay. 2. Okay. And this exhibit shows that Miss Griffin is presently incarcerated in the Harris County Jail. She was booked on September 17th, 2023. And she's currently being held on a $40,000 bond.
She has an extensive criminal record if you look it up.
May I go ahead and stop sharing?
You may stop sharing.
Okay. Okay. Who does Messiah live with?
Me.
Okay. And how long has he resided with you?
Since he was born.
Okay. Was he placed with you by CPS?
Yes, ma'am.
And is there any type of CPS case presently open?
Not that I'm aware of, no.
Okay. Okay. There's no court cases or court orders?
No, ma'am.
Okay.
I haven't received anything.
And does he presently have a relationship with Miss Griffin?
No, ma'am.
And so do you make all the decisions for Messiah?
Right.
Okay.
Yes, ma'am.
Do you know if Miss Griffin has any type of income at this time?
Not that I'm aware of, no, ma'am.
Okay. And are you seeking any type of back child support?
No, ma'am.
What type of health insurance does Messiah have?
It's through the state,
Okay.
Medicaid.
All right. And does Miss Griffin have any other children?
Yes, ma'am.
Do you know if she has any other child support cases?
Where she's on child support?
Yeah.
Yes, ma'am. I went 3 that I'm aware of.
3? Okay.
Yes, ma'am.
I think I'll pass the witness.
Does she have any children that live with her when she's not in jail?
No, ma'am. She's never, all her children have been taken from her.
Was the child ever placed with, and I'm sorry, I don't have her name memorized.
Her daughter had him when she went to jail, right?
How did that come to be if you had the child? How did that come to be? How did the daughter get possession?
I was also in jail.
Okay. Was there any legal paperwork done regarding
No.
her daughter? And how did you get the child back when you got out of jail?
I went and picked them up
From who?
from her, Haley's grandma.
So at some point, her daughter gave the child over to her grandmother.
Right.
Has Haley asked for the child back?
No, no.
And about what time, when did you get the child back from the grandmother?
This was 2 years ago.
Okay, so a while ago.
Yes, ma'am.
Okay. Okay. Is there anything else you'd like to say, Mr. Hicks?
No, ma'am.
Do you plan on leaving the Liberty County area?
Not at the moment.
Okay. Do you have anything else you'd like to say, Ms. Simone?
The state is asking to establish Mr. Hicks as Messiah's father. And I believe that child support would be zero based on the fact that Ms. Griffin is currently incarcerated and being held on a fairly large bond. She has no income history. And even though the child's on the government plan, we would also ask that medical support be set at zero because she's incarcerated. And no retroactive child support. And I believe court costs, if applicable. She's incarcerated, so I'll leave that up to you.
And sir, with regard to visitation, rest.
Supervised visitation.
Is there
She's
someone
present.
who?
I was going to say she's currently incarcerated, so I didn't know if we wanted to reserve that till a later date when she can appear.
Well, that would be a temporary order.
Oh, I'm sorry. Well, I would say, like, do we typically don't order visitation at this time because she's incarcerated?
I could make the finding she's incarcerated and not order.
We could, and we
just
could come
lose
back.
him though.
Oh, I guess
You
we
left
did.
the party.
Yeah,
We lost. Yeah.
hopefully he'll call back in.
I was going to say, I think typically we just do no visitation. There we go.
Sir, can you hear again?
Yes, sorry.
Okay. The AG's office was suggesting no visitation because of her incarceration at this time.
That'll work.
Okay, and back to your request for non-disclosure, sir. It's a pretty high burden to not have your information in the order. So I just wanted to give you a chance to give me more information about why you have concerns about your address and phone number being in the order.
Like I said, it's like she's threatened us before, and she's been.
When did she threaten you, and what did she threaten?
She threatened our lives, actually.
Threatened
She's
your
gonna
lives?
take mine, her kids, and herself.
When was that?
Back in 2020, but she's been in and out of the mental hospital trying to kill herself. That's on record.
And just so you're aware, sir, I can only make my rulings on evidence presented during this hearing. I'm not empowered to research. So when you say things are on record, unless I'm told about them or they're admitting as evidence, I don't know about them.
Okay.
Okay, I just want you to be aware of that. I'm not trying to come across as obstinate, but I'm not supposed to research.
Right. I got you.
I'm going to establish the parent-child relationship between Mr. Hicks and the child. I'll leave the last name the same. I'm going to appoint him the managing conservator and Griffin, the possessory conservator. You'll have the right to determine the child's residence within Liberty and any county that touches Liberty. This time I'm ordering no visitation because of her extended incarceration. Child support is being set at zero because she's incarcerated for more than 90 days. I'm ordering you to apply for a government medical plan with cash medical support at $0 each month because of the incarceration beginning November 1st of 2023. I'm going to order no back support as you requested. I'm going to approve the non-disclosure as to you, sir. I'm going to deny it as to Ms. Griffin. I've heard no evidence about Ms. Griffin or any need for her to have a non-disclosure. And I'm going to waive court costs. And so the Attorney General's office is going to draft an order based on my ruling today, and they'll be sending it to me through DocuSign to review and sign off on, and then they'll be sending you a copy for your records.
Okay.
Unless you have any questions, you are free to go for the day.
That will help me get on this birth certificate and.
Yeah, technically the order will establish you as the father and say that you're on the birth certificate, but to actually make that happen, it's a whole nother process. You're gonna have to get a certified copy of the order once it's signed by me and in the court file.
Okay.
And you have to go through, I think it's the VSU. You're gonna have to fill out some paperwork with them and pay some fees, I think, and send them a copy of the certified order. And I think then it's through them at that point. It's not through the court. This is the court's part.
It's through what, VSU?
Do you know what, is it VSU, Ms. Simone? Vital
I
statistics.
believe vital statistic. I believe it's vital. I believe
Okay.
so.
They keep changing their name. used to be PBS.
If you search that on the internet, it'll come up probably with the right thing.
Okay.
And so, yeah, you are free to go. Thank you so much, sir, for coming in.
When did you stop living in the same household as Mr. Robles?
March 12th, when he had me arrested.
I've been kept away from my child and alienated from her. She has a drug problem. She has a problem with just taking care of herself. I mean,
Objection, Your
her whole
Honor.
entire family-
Speculation assumes facts, not in evidence.
Okay, there was no speculation whenever she said that I went to
Hold
her
on, Mr.
home,
Robles.
knocked on
Mr.
her
Robles.
window.
Mr. Robles, did you personally see Miss Sierra consume any drugs?
Yes.
When we first split up, she just took off and moved out of town 7 hours away. Wouldn't tell me where she was, who she was around, or anything.
You had another dependent, another child, correct?
Yes, sir.
And your rights were terminated to that child. That's also correct?
Yes, sir.
Did you do that through voluntary agreement with Child Protective Services?
No, sir. They had me doing parenting classes towards the end, and I didn't complete the last two due to work, and they said that's why they terminated my rights.
Where do you currently work?
I work at Walmart.
And in that 4-year span, Mr. Dana, you said that Ms. Schaus has only seen the child one time that you know of?
Yes, sir.
Yeah, she was born into a person.
I'm sorry, Ms. Schaus, I can't hear you when you're crying.
Mr. Dana, your daughter Delilah, lives with you now?
Yes, ma'am.
How long has she been in your possession?
Close to 4 years now, I'd say.
And how did she come to live with you?
There was some things that went on in her mom when she was in her mom's custody that led to me getting pretty much full custody of her.
Okay. How often has Miss Schaus visited with Delilah since you had her?
One time.
Okay. Do you have concerns about her being alone with the child?
Yes.
And what's the nature of those concerns?
Mainly just like I don't know who she would be around with because of the last incident.
Okay. And basically, Miss Schaus has another child, and there was some abuse or some harm to that child, and your daughter Delilah was present at the time as well.
Yes, I believe so.
David, do you have concerns for Delilah's safety, sir?
Yeah.
Do you have any personal knowledge of whether or not Miss Schaus has physically harmed the child?
Not any personal knowledge of her harming the child, just people she is around.
Okay, what can you tell the court what happened or what you know to have happened?
Not unless he has personal knowledge of it, he can't.
Do you know what happened or your own personal knowledge, sir, of why the child was placed with you?
So a few years ago, apparently Heaven met this guy, and I believe it was a couple months into her knowing him or meeting him or something. I was told she moved into an apartment.
Mr. Dana, I got it, Ms. Penister. Mr. Dana, how do you know this information? Where did you learn it from?
The CPS workers.
Did she tell you this information?
Yes.
Yeah, that's hearsay. Go ahead, Ms. Penister. Mr. Dana, you're not allowed to give me information that somebody else told you, okay? Because that doesn't give Ms. Schaus the right to cross-examine it.
Okay.
There's rules in the court, in my court, about evidence and civil procedure. You just can't come in and tell me what somebody else told you, because I don't have any way to verify whether or not that information is true.
I mean, if I look in my documents and stuff, I can find the paperwork that says what the actual reason was.
Okay, so you have documentation then from Child Protective Services about allegations of abuse.
Yes.
What is the allegation of abuse?
The guy Tristan Turk, I believe his name was, burnt and put Delilah and Liberty in in hot water in the
Okay.
bathtub.
And did Child Protective Services investigate this allegation?
Yes.
And did they make a final finding as far as what they found?
Yes.
And what was the finding?
That he was guilty to doing it, and
Okay. And did they
tested
press
his water.
did they press criminal charges against this man for doing that? I mean, that's clearly abuse.
I'm not 100% sure how far they went into it. They just told me that stuff and said that they were seeing what they could do all about it, and then
Mr.
told me
Dan,
I needed to get
Mr.
my
Dan,
daughter.
Mr. Dan, I didn't ask you what they told you, okay? I asked you what your the official findings were from Child Protective Services. Do you know? If you don't know whether or not they filed criminal charges against him, then that's fine too. If you don't know, you don't know. Okay.
Yeah, I don't know. I'd have to look because it's been years since it's happened.
All right. And then Child Protective Services asked Ms. Schaus to place Delilah with you.
Yes, I believe so.
Did Ms. Schaus agree to place Delilah with you?
I believe so. Yes.
Okay. Did they create something called the safety plan for you and Ms. Schaus to sign?
Not 100% sure.
Did Child Protective Services actually file a lawsuit and remove Delilah from Ms. Schaus legally in court?
Like we didn't, I don't believe we went to court over it, no.
Okay. So Child Protective Services took no legal action in regards to this case, as far as you know.
I think, like, I really can't remember. I can't remember.
Okay. Well, for the record, Mr. Dana, for Child Protective Services to actually do something like that, they would have to file a lawsuit. And then the police would come to Ms. Schaus's house and physically remove Delilah from Ms. Schaus and put the child in foster care. And then Child Protective Services would reach out to you, Mr. Dana. Hold on, Ms. Schaus.
I'm sorry.
Yeah, don't interrupt me, please.
Yes, sir.
This is the problem when Child Protective Services gets in the middle of cases involving children. They have a rule, and the rule is we just want the children to be safe. And once the child is safe, then Child Protective Services gets out of the case. But they don't give the parents any further direction on what they're supposed to do. So I'm assuming that Child Protective Services has never filed a lawsuit. Ms. Pinister, did Child Protective Services file a removal of this child from Ms. Schaus?
From my understanding, no, Your Honor.
Okay. So no legal action has ever been taken in regards to this Child Protective Services case, as far as you know, Ms. Pinister.
That's correct, Your Honor. None was taken.
This is very important to me, Mr. Dan, because it makes a big difference on how I can rule on a case, all right?
Yes, sir.
All right. So go ahead, Ms. Pinister. I think I've got to the bottom of that part of the case. Thank you.
And Mr. Dana, so you're asking for the court to appoint you sole managing conservator and to order supervised visitations for Ms. Schaus.
Yes.
Based on your concerns. Does Ms. Schaus know where you and the child reside?
Yes.
Okay. Do you have any concerns with her coming to pick up the child from your home?
Yes.
And what are those concerns, sir?
Well, from last experience that happened, didn't get to see my daughter or hear from my daughter, get pictures from my daughter or anything. Last time when we first split up, she just took off and moved out of town 7 hours away. Wouldn't tell me where she was, who she was around or anything. And I don't want that to happen again.
Okay. Has there been any threats of harm or threats that she would take the child and not return her as agreed? Well, when she saw the child a year or so ago, did she take the child from your home?
I let her go to her mother. Yes.
And this is the maternal grandmother. When you say her mother, the maternal grandmother?
Yes, ma'am. Heaven Charles.
Um,
And yes, she has threatened me with seeing Delilah several times.
okay.
But this was this was before, you know, all this happened, and I ended up getting full custody, or like Delilah coming to live with me.
Well, I'm only talking from the time that she came to live with you.
Yeah.
Has there been any threats or physical harm to yourself or the child?
No.
Do you have medical or dental coverage for the child currently, sir?
No.
And the prior order would also modify an obligation of yours. You were ordered in the prior order from 2017 to pay cash medical of $115 a month. You would want the court to give you some possession credit because the child has been with you. Is that correct?
Yes, that'd be nice.
You do understand that there is an amount of money that we'd ask the court to grant a judgment for of $613.66.
Yes.
Okay. Pass the witness, Your Honor.
Okay, you call your next witness.
I'll call Ms. Schaus. You're on mute, Ms. Schaus. Okay. To your knowledge, when did Delilah, can you hear me, Ms. Schaus?
Yes, ma'am. Can you hear me?
Yes, yes. When did, to your recollection, did Miss or Delilah go to live with Mr. Dana?
So I'm sorry to backtrack a little bit. Before the CPS thing happened, she was already down there visiting him.
Okay. So she was there at the time.
Yes, visiting him. And then like it was the day after that she had left that the accident had happened.
Okay. And you acknowledge there was an incident bathing a child that's not before the court.
Yes, ma'am.
And is that child live with you now, Ms. Schaus?
No, ma'am.
Were your rights terminated to that child?
Yes, ma'am.
Okay. Are you employed, ma'am?
Yes, ma'am.
Where do you currently work?
I work at Walmart.
And how much do you make an hour?
$17.11.
You working full time, 40 hours a week?
Yes, ma'am.
Do you have health insurance through your employer?
Myself, no.
Okay. Will you be able to add this child to your health insurance?
Yes, ma'am, I will.
To a health insurance plan provided by your employer?
Yes, ma'am.
Do you know the cost of it?
$68.
Okay.
Every 2 weeks.
$68 every 2 weeks?
Yes, ma'am.
And what about dental coverage? Is that available?
Yes. And that's about $6 every 2 weeks as well.
$6 every 2 weeks for the dental. Do you, and when's the last time you saw Delilah?
It was probably, when was it? About a year ago.
And you want to have a relationship with your daughter, Ms. Schaus?
Yes, I do.
Prior to her being with Mr. Dana, were you the primary caretaker?
Yes, I was.
Do you have you tried to attend any school activities or, find out about medical appointments and things like that? Do you communicate with Mr. Dana about those issues?
No, ma'am. With the school stuff, I live quite a bit of ways away. I had actually planned on moving down there once I had gotten like a vehicle and everything. That way I could be closer to her.
You would want the court to order you guys joint managing servitors and that you have a standard possession order.
Anything as long as I can see my kid.
Okay. Pass the witness, Your Honor.
Call your next witness.
State has no others, Your Honor.
Did you calculate child support based on the income, Ms. Penister? Because I can't in Orange County. I don't have the bandwidth to do it.
I did, Your Honor, but it was some different numbers. I'll go back through it. I did at $66 and $5. The testimony was 68 and 6. So I'll go back.
I do. The medical should be 125 because that's every 2 weeks. And then the dental should be 15 because that's also every 2 weeks.
Okay.
And I think Ms. Shaw said that she makes $17 and some change an hour.
That's $29.65 gross monthly. Came up with $477, Your Honor. Or $478, $477.
Thank you. And lastly, Ms. Penister, I was confused about the judgment. So according to the prior court order, the only support that Mr. Dana was ordered to pay was medical support.
Yes, Your Honor. There was no child support ordered in that order.
And you're asking me to grant a judgment for how much and as of what dates?
$613.67 as of April 16th.
Give me the figures one more time.
Yes, sir. $613.67 as of April 16th.
Okay. Ms. Schaus, so you had another dependent, another child, correct?
Yes, sir.
And your rights were terminated to that child. That's also correct?
Yes, sir.
Did you do that through voluntary agreement with Child Protective Services?
No, sir. They had me doing parenting classes towards the end, and I didn't complete the last 2 due to work, and they said that's why they terminated my rights.
Okay, well, they can't terminate your rights without a trial, so you didn't show up for court when you were supposed to?
We did have the whole entire trial. It was the parenting classes is what they said that got me because I didn't finish them, so that.
And where do you live, Ms. Schaus? What county?
Brown.
And where is that?
Brownwood, Texas.
Oh, Brownwood. So you live way down south.
Yes, sir.
That's a long way from here. And you don't have a vehicle?
No, sir. When me and my ex broke up, he kept everything, so I'm kind of starting back over.
Okay.
My dad, he'll bring me down there until I can get being situation figured out, though.
Okay. I mean, that's what you're gonna have to do, right? I mean, Mr. Dan, the child Delilah is currently living in Orange County. Is that correct?
We currently live in Jefferson County, but we're about to we're looking for another house back in Orange County because we'd rather be over there.
Have you always lived in this area, Mr. Dana?
Yes, sir. I moved to Orange County in 2009 and stayed there pretty much my whole life.
And Delilah has been back in at least this area ever since you took possession from Child Protective Services?
Yes, sir.
And how long ago was that again, Mr. Dana?
I believe it was 2017.
Okay, so you said it was 4 years, but it's actually been 7 years.
Or no. 2017 was our court stuff when all the CPS stuff got involved with Delilah and me and Heaven. So it's been about 2020.
Okay, so it's
somewhere
between 3 and 4 years Delilah's been back in my area.
Yes.
All right. And in that 4-year span, Mr. Dana, you said that Ms. Schaus has only seen the child one time that you know of?
Yes, sir.
And that was last year?
Yes, sir.
And did the child go to Ms. Schaus's parents' home somewhere and they exercised visitation that way, or what happened?
They came to my house under my supervision because I didn't want anything to happen or anything to go wrong.
Okay. Well, but that's been the only time she's had any contact with Delilah since Child Protective Services put Delilah in her house?
No, she does video call Delilah every now and then.
Okay.
So whenever she gets a chance, like I let her talk to her daughter, whenever.
You understand, Mr. Dana, that I have to get visitation started again.
Yeah.
Okay. Oh my God, this child was born on New Year's Eve.
Yeah, she was born at 12:13 in the morning.
I'm sorry, Miss Shouse, I can't hear you when you're crying.
So sorry. She
Did
was
you
born at 12:13 in the morning on New Year's Day.
Okay, well, that's not what this says. This says she was born on 12/31, so that would have been New Year's Eve. But either way,
She was born on 12/31 at 12:13 a.m.
okay,
I'm sorry, that part cracks me up because it's such a funny number.
yeah. But she's also 8 years old, almost 9.
Yes.
I'm not talking about a baby here. I'm talking about a child that can talk and tell stuff. Right, Mr. Dana?
Yeah.
Right. All right. Mr. Dana, is there anything else that you think I need to know about this case before I make a ruling?
I mean, I don't think there was anything other than when I got when I got Delilah, because she was there when the stuff happened with that guy.
It's
And
okay,
then
Mr. Dana. I can't go back 4 years and
yeah,
make things right.
yeah.
I
Well,
mean,
okay, yeah, you asked.
I'm going to give a phased-in visitation schedule, Mr. Dana. If you can't figure out that the child's going to be safe in the next year and a half, then you're probably going to have to hire an attorney and try to fix the visitation. Okay.
Okay, I know she's safe with me, so.
Well, I understand that, Mr. Dana, but you're not the only parent.
Oh yeah, I know. That's why I want her mom to be involved, because I want my kids to have what I didn't have.
Right.
So.
Well, I'm going to give Ms. Shouse the opportunity to be a parent. Now, whether or not she's able to exercise, it's another story. But I am going to give her the rights.
Yeah.
In the last 4 years, before this court child support was ordered, did you receive any monies from Mr. Welch for support?
No, ma'am.
Were you living with Mr. Welch at any of the time during that 4-year period?
No.
All right. Ms. Shouse, is there anything else that you think I need to know about this case before I make a ruling?
No, sir.
All right. The court's going to find the court has jurisdiction. The court's going to find that there has certainly been a material substantial change of circumstance. And Delilah is no longer living in the home of the mother. Delilah is living in the home of the father. And therefore custody has to be changed. Due to the findings in this course, I'm going to find that it is not in Delilah's best interest to name the parties as joint managing conservators. Mr. Dana will be named as the sole managing conservator. Ms. Shouse will be named as the possessory conservator. There are facts that have been agreed to in this case that require that I name the parties as sole and possessory. I'm going to order Mr. Dana to maintain or at least get some health insurance on. Oh, wait, I think the mother says she has it through her employer. I'm going to order the mother to carry the health insurance through her employer. I gave her credit for $125 for the health insurance and $15 for the dental. I'm going to set child support based on the information that she gave at $450 a month, $450 a month, Ms. Pennister, beginning May 1st of 2024. 1 second, I need to make a note. I'm going to order the visitation is going to be a phased-in visitation schedule. There's going to be 6 visits at each phase, Mr. Pennister. That'll be 6 visits supervised by the father or someone that the father elects. That'll be followed by 6 unsupervised visits for a half a day. That'll be followed by 6 unsupervised visits for the day. That'll be followed by 6 one-night overnight visits starting at Saturday at 6 and ending at Sunday at 6. When that last set of phased-in visitation schedule is completed, then Ms. Shouse may have standard possession. If Ms. Shouse does all of the visitations the way I've defined them, then it will take her approximately 3 months to do each phase, which would be 12 months for Mr. Dana to be able to watch and maintain and make sure that Delilah is going to be safe when the child that goes off unfettered with Miss Dana, with Miss Shouse, I'm sorry. And that way it'll give Mr. Dana an opportunity to hire an attorney and change my visitation schedule if he thinks that's in Delilah's best interest. But if the visitations are going well and Miss Shouse is doing what I've asked her to do, then she will be able to exponentially increase her visitation over the next 12 months and be back in Delilah's life full time. Court costs in this case are due by Ms. Shouse, but I'll give her till October 31st of 2024 to pay the court cost. I will make a finding that Mr. Dan is behind in the medical support, and find that as of April the 16th of 2024, you owe $613.67. That'll be paid back at a rate of $20 a month, beginning May the 1st of 2024. Does that take care of all the issues in this case before me today, Ms. Pinister?
It does, Your Honor. Oh, well, and the was a request for non-disclosure.
No, that's denied. You don't have any evidence of anything in 2 years.
Okay.
I think that's still the law, isn't it, Ms. Pinister?
That is, Your Honor.
Okay. So the non-disclosure has to be denied. Mr. Dana, I'm required by law to put your address in my court order. It's an order involving a child. And so all parents are required to put their addresses in my court order, unless there is a history of family violence or domestic abuse in the last 24 months, okay?
Okay.
And you said that there hadn't been any issues in the last 24 months. You've had very little contact with Ms. Shouse during that period of time, correct?
Yes.
All right, so I'm required, by law, I'm required to put your address in my court order, okay?
Okay.
All right. Now, Mr. Dana, I have given you the right to elect someone else to supervise the visits for you if you wish to do so. So if you feel comfortable with someone that's a member of Ms. Shouse's family that's local to you, doing the supervising, feel free to do that. If not, then you supervise them yourself, okay?
Okay.
All right. Mr. Dana, do you have any questions about my ruling today?
No, sir.
All right. Ms. Shouse, do you have any questions about my ruling today?
No, sir.
All right, y'all, what's going to happen now is Ms. Pinister's office is going to prepare a court order for me. If it matches what I said here today, I'm going to sign it and get it back to them. Then they're going to make a copy of it and send it to each of you, okay?
Yes, sir.
Yes, sir.
All right, I wish you both the best of luck.
Giving my client, the father, primary legal custody. You ordered that he was allowed to give the mother visitation at his discretion and ordered that the mother pay child support.
I'm sorry, and this case started with me? Was it ever before another judge?
Not to my knowledge.
It just feels like he's been manipulated and manipulative.
We're here today on our motion to dismiss plaintiff's motion for, I believe it's now a petition for modification of parenting time. It's also a citation for contempt, motion for attorney's fees, and also I believe there was a amended petition filed requesting a modification of child support. Just briefly, I think you said you just looked over your notes. You've, I believe, been on this case since the initial divorce took place back in 2010 between the parties. Subsequently, in 2019, my client, Mr. Barnes, filed a petition to modify custody, and the parties reached an agreement. They executed a modified parenting plan in December of 2020. And then following that, Mr. Barnes filed another petition in 2022 requesting to modify custody in the Superior Court of DeKalb County. At that time, he attempted to have Miss Eldridge served by special process server. He attempted service by publication. At the final hearing, Miss Eldridge did not appear. And the minor child who is subject to this action presented the court with an affidavit of election stating that he wished to be placed with his father as the primary custodian. Your final order you entered in this matter noted that the mother did not appear for the hearing. You also took notice that the minor child had suffered mental abuse at the hands of the mother and her spouse.
I'm sorry, when was that order? What case number?
That was April 17th of 2023. That's,
2023. Okay, hold on. I'm looking. I just pulled up the.
I have the case number if you'd like it.
No, I see them all. So I pulled up the first final order in the 19 FM case. It's not too old, so I should have some memory, but right now it's just not pulling up. But usually as you talk, maybe it'll come up. Usually I put my little notes in here so I can have some recall. And it normally works, but for some reason I'm putting up blanks right now. And this case started with me. Was it ever before another judge?
Not to my knowledge.
So another judge didn't handle it and send it to me that you're aware of?
Not from all of the paperwork I've been able to pull. Your signature has been on everything.
Okay. All right then. So, all right. I don't have actual recall, but probably as we go along, I will. All right. So your position is, go ahead and tell me what your position is again.
Yes, Your Honor. So you entered an order on the 17th, April 17th of 2023, giving my client, the father, primary legal custody. You ordered that he was allowed to give the mother visitation at his discretion, and ordered that the mother pay child support in the amount of $519 per month. Following that hearing, just barely, I think it was 2 months later, Ms. Eldridge filed her petition for modification of parenting time against my client, which is what we are here asking to be dismissed at this time. According to the statute 1993B, the modification of an entry of visitation rights is subject to review and modification every 2 years, unless there is some showing that there has been some change in any material condition or circumstances of either party or the child. We do not believe that that showing has been made. Even today, we are still, I believe, just past 1 year since the order was entered. And so it is still, we still do not believe that the plaintiff has made any showing that there has been any material change in the conditions or circumstances that make modification of your order from April 17th of 2023 necessary at this point. We also request that plaintiff's request to hold defendant in contempt be dismissed. The amounts that are pled in plaintiff's petitions are varying and unclear. At one point, they are in separate amounts based on what the contempt action is for. Then in another petition, it claims to be well over $12,000 plus interest, which is a number I do not know how that amount came up from any of the numbers that I have received so far. And then finally, plaintiff requests to modify child support. We request that that be dismissed as well. Just prior to a brief hearing we had on this issue in Gwinnett County before the case was transferred to DeKalb, I was presented with a letter saying that plaintiff had been released from her job at the time, the Friday before the hearing that we had. Since that time, I have been unable to verify that plaintiff is no longer working. I have also been unable to verify the amount of income or the finances of the plaintiff since that hearing. So I cannot consent and believe that any request to have her child support modified should be dismissed until I can verify that information.
Good morning, Your Honor.
Good morning.
I represent Ms. Jasmine Eldridge, and I think the court probably was referring to another judge having dealt with the case because it was transferred to DeKalb County from Gwinnett.
Okay.
My client, when she initially filed her modification, she had to file it where the defendant lives, and he lives in Gwinnett. He does not live in DeKalb. The prior actions is where he had always filed against her, and she is a resident of DeKalb County. When we had a hearing on this matter in November of 2023, the judge in Gwinnett indicated because this court had did the initial divorce and the court had signed the order on the first modification that Mr. Barnes filed, as well as signed the second order that was actually filed, that it would be better for this court to hear these issues as opposed to Gwinnett. The parties then consented to change venue from Gwinnett County back to DeKalb County. So that order was transferred, I believe, in December, and then we got a case number towards either the end of December or early January. I then immediately filed for a motion to have the court to hear all of the matters that were pending before the court in Gwinnett County, which was the petition to modify visitation and parenting time, which, by the way, my client has none, because the defendant in this case has chosen not to allow her any access to the child. Very limited phone contact, if any, and no visitation at all. In fact, I don't believe she's seen this child since early 2023. But anyway, so she's had no access because it appears that his position is, I can decide whether or not you see the child, so you don't get to see the child. He did bring the child to court last time in Gwinnett County. I'm not sure if he's there with them today, but he took him out of school when we were in Gwinnett in November for him to come to court to say that I don't know what he wanted to say, but he was there. So she is not arguing this issue about whether or not his election was his election. If he wanted to live with dad, that's fine. She does disagree with this allegation that she and her husband mentally abused this child. As Ms. Verheyen has indicated, when this case was actually filed in DeKalb County, I don't think she was properly served, but even if she was, she did not appear at the final hearing. She had complications from a pregnancy that caused her not to be able to appear in court. So she provided no defense to the allegations that were made in the original petition to modify that was filed by Mr. Barnes in 2022. And then the final hearing was held, I believe, in March or either April of 23. And a final order was entered April 17th.
I think the hearing is in March, and I kind of feel like now that things are coming back to me, I think I interviewed him.
I think you did.
I think I interviewed the child because of the allegations, and I think of his age.
Right.
I kind of want to think he may have indicated he was at Lithonia High School or going to Lithonia High School. So now I do have recall. I actually interviewed him, and the reason I think it has mental abuse on there was that was the court's finding at the time based upon the statements. Based upon the statements that he made,
right,
and how he felt about his circumstances at the time. So I don't think, I think the court was very mindful, even though she wasn't present. I didn't make the decision, just kind of like what he said. I actually did interview the child,
And I believe that's in the order. It states that the court interviewed the child.
Okay, it does say that. Okay, good. All right.
The court made a determination that dad would have, it says joint legal, but dad has to file.
Yeah, I think the thing is that dad would exercise discretion how he would allow visitation. So he was supposed to, it wasn't that she doesn't have visitation. It's just that the court will, because the child was 14 and he could tell, kind of dad what's going on. Dad would then be able to use that in his discretion of how the mother would visit. That's how it's set up, because of his age, and because if anybody is emotionally abusing him, you can come home and tell dad, and then dad can change the parameters. But I don't think I indicated that mom is not to have any visitation.
Well, the language doesn't say that. The language specifically says that the dad will determine what the visitation would be. And so far, there'd be none.
No,
And
I didn't say it would not. Where are you reading? Where are you reading none?
let me go back to the language. Because there was a schedule. There was actually an order that had a schedule attached.
All visitation terms.
If I can find the actual language. Because there was a parenting plan, but in the parenting plan, it gave dad discretion. It just says, as dad agrees that the child will have visitation with mom.
Mother shall have parenting time with the child as agreed by father.
Right. Which means he has to decide that it's okay for her to visit, the way I interpret that. And I'm presuming that's how he interpreted it too, because he has decided that she has none. She's had no visitation.
Well, I don't think well, how do you have parenting time if you have none? I think it's supposed to be in his, that's basically, it is supposed to be in his discretion, but it's not, it wasn't supposed to be none.
The effect of the order, Your Honor, I guess is what I'm saying, is that he has not allowed any visitation at all.
Okay, your position isn't that I said she's not to have visitation.
No, no.
Okay,
But
your position is that he interprets that, your argument is he interprets that to say no visitation.
Yeah, I obviously I can't speak for him, but the net effect of the order is that no visitation has been allowed, even with my client reaching out asking for parenting time, even
Okay.
for
I
phone
should say, and your position is that it shapes the modification, that is the material change, is that mother has not seen the child since the order.
Well, at this point, that's what it is. When we filed initially, what were you initially indicating? Because the way I read it looked like you were saying she had not seen him, and that was only 2 months later. Right. Because she well, let me back up. Before he even filed the petition, he just kept the child in his care after one visit. This is on the prior order. And the child never came back to mom's house.
Okay.
And he subsequently then filed a petition to modify while still having the child in his care. We know under the statute, you're not supposed to be able to ask for custody while you are withholding custody. But because my client did not present any defense to move to dismiss his petition because he was withholding custody, that wasn't brought up, that wasn't even looked at in this case because she wasn't there and it wasn't presented. But the reality of it was that when he went to visit, and I believe this would have been in sometime in December of, the latter part of 2022, I went to visit with dad and never came back to mom. He then subsequently filed a petition to modify in early 2023. And then a final order was entered in this case that gives him custody and the right to have his discretion on when the child can see mom. That's what the order basically says as far as my client is interpreting it, because there's no schedule that says she gets first and third or any of that.
Right.
It's based upon when dad decides. And every time she's asked, it's been denied. She has not had any access to this child. So at this point, there is material change because he has not allowed her any access. We asked that we at least have phone calls. And so my client was attempting to do phone calls after we left court in November. Then the number was changed. I did contact counsel and let her know, hey, she can't even get in touch with the child now because the number has changed.
Has mom and dad have discussions, like is dad putting parameters that mom can't meet?
No, none of that has occurred. They don't talk. And his
Miss Marine, tell me where we are with that concept, because what Miss Banks Ware has presented to the court is that father is rejecting all communications, and that could be a material change in circumstances, even though I believe at the time it was filed, those things may not have been as egregious as she's claiming them now. But particularly at this point, if in fact it's been a year and he has found no space for a visitation, that is alarming to the court.
That's just not true.
Okay. All right. Let me hear what you got to say.
Okay.
My client has, and their son has had contact with his mother, and she does have a way to reach him. So I just I don't really know how to address what is just not true, other than to tell you that it's just not true.
You can tell me that when he visit with his mother, can you give me the dates, places, times?
So, my client's son has tried to reconnect with his mother. He's currently in counseling, and he's, working to get to a place where he can really reestablish the relationship that he wants to have with his mom. However, unfortunately, when he or his father try to talk to Miss Eldridge, it inevitably leads to a very volatile situation. And so, it's not that Mr. Barnes is keeping his son from Miss Eldridge. The child is making a choice to not have face-to-face contact because the situation, even over the phone, becomes volatile. So he is actively saying that he is not ready to do that. They are definitely reestablishing a relationship with the grandparents, Miss Eldridge's parents. That is definitely a very positive step, and they are having very productive conversations and interactions with the grandparents, which has not always been the case, but even Mr. Barnes is having positive interactions with them. But the child is actually still having very volatile interactions with his mother, but she does have a way to get in touch with him, and they do have a way to communicate.
What was the volatile response, and when was that?
Yeah. Yes.
I'll let my client address that.
Yeah, so I think right before.
I'm sorry, I need to come in if he's gonna address something.
Yeah. Can you raise your hand?
Do you solemnly swear or affirm that the testimony you're about to give to the court is the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely, I do.
Tell me start with the date.
I think 2 months before the filing, Miss Eldridge that she had seen Cameron. And again, he can kind of specify a lot of this as well, more so. And I think we had constant communication with the grandparents because that was the positive. He would spend more time. I didn't know this until he got with.
No. I like to stay focused. You said that she had a volatile situation.
Right.
And when was it?
So the volatile situation, and the most recent one I can remember, I was at a.
No, I don't want about the recent one. I want the one that started your position or your son's position, that they had a first exchange and it was volatile. When was that first exchange and how was it volatile?
And are we speaking in terms of visitation, Your Honor?
What else were you considering?
So what prompted this again was
no, the question was, you asked me, was we consider a visitation? And I said, yes. Is there something else? What's the answer to that question?
Well, the reason why, because it's a lot of different moments where, again, he'll be on the phone. And again, this has happened numerous times. I would just have to go in my call log and look in when he was speaking to her. Because he has.
So you're talking about a phone call versus an actual personal interaction.
Right, those personal interactions he's had recent ones and ones prior.
Not recent ones. I want to focus on point one, okay? Point one was what happened volatile. Was that an in-person volatile situation or by phone volatile situation? That the first thing that you said, the first time they had an interaction, you said it was volatile. What was it?
Chili's, we were at Chili's.
You met her at Chili's.
Right, we met at Chili's.
When was that?
Like I would say April of last year.
Okay, April of 2023. That was after the order or before the order?
I think after the order.
After the order, you all met at Chili's.
Right.
All right, tell me what happened.
So we got there. I obviously was there because I was kind of uncomfortable with what happened to him. So obviously I wanted to be there to make sure it went well for him. And I did want to have a conversation with her at the time too, to kind of find out what really happened. We got into Chili's. I was sitting there waiting with my son. I get there, she comes in. She's like, well, you're not supposed to be here. This is our time. And then she commences to pretty much in the little, the doorway of that, she starts cussing and fussing in front of him at me for being there and being present. And because I wouldn't leave him by himself after what I found out what happened. So I said, okay, well, for his sake, I got to be there in my mind, just being present to make sure nothing said that's out of order, that they can have a common conversation, but it just wasn't going to happen because she got irate. So then I went to my truck after it kind of calmed down, and I agreed to say, okay, I'm not gonna leave, but I'm gonna let you guys speak. So they spoke on the bench because we didn't have a lot of time to speak and to stay, but I wanted to make sure she had time with him, right?
She didn't have a lot of time to stay.
No, we did not. I can't remember what it was at the time, and I'm sure my son can probably explain a little bit better than I can on this. But again, when we were there, that was the first volatile, cussing, fussing, mad. It's the typical type interaction I get, whether it's on the phone or doesn't matter. That's what I get every time. We had to have a conversation when I'm present.
Okay, so you went to Chili's for not really for lunch or dinner. You actually just intended to meet there since you didn't have time.
Just for them to meet, yes, to see each other after the incident, right? After I found out all those things, we had the court issued stuff. Then I said, okay, well, let's try to start building some type of, relationship. And I don't want her to not see him, right? In whatever fashion it may be. But if he wasn't ready, because I kept asking, are you ready? He's like, no, he didn't want to. So the issue is that it's being presented like I'm withholding him, but I'm not. It's just he's pushing back on me. If I'm talking to him, hey, you want to see? He's like, no, I'm not ready. I don't want to have a conversation. If I got for calls during the week, he doesn't want to make these calls because he's still affected by what happened. And I still don't even know the full story.
Okay, so that was the first volatile, and that was in person. Was there a second one in person?
Definitely Mother's Day. That one was over the phone. I know it was something.
My question though, in person.
It was in person for that was via phone, I would say. And it was more in person with the grandparents per se, because it kind of all meshed into one. We were trying to drop off her a Mother's Day gift because I'm like, son, you're still your mom. Let's try to get her something nice, right? Long story short, it was short notice, like, hey, can we come drop it by? I don't think she was at the house at the time. So we just left it because it was kind of like arguing on the phone again. And so he felt like, he was like, well, why are we even doing this, Dad? Why are we even pushing this envelope? Why am I going over here when she's angry and this, that, and the third? And I said, well, we still have to do this. So all we did was just leave it out on the driveway and we drove. And I talked to the grandparents saying, hey, can we at least bring it to you? When we were trying to get through the gate, she was present at the gate, right? And then, but we were hearing cussing and fussing through the phone, and we just decided, nope, I'm not gonna put him nor myself in that space again. Then with more cussing and fussing, I said, let me pull back, and we just dropped, again, we had dropped that gift off. That was the reason why we dropped it off, because we couldn't bring it for her without the cussing and fussing and fighting between her mom and dad, and vice versa for me even being present, having him there to drop the gift off. Like, it's a Mother's Day. It should have been simple. Hey.
Okay, I'm confused. You saying you're fighting with her mother?
No, she was over the phone. Like, we were hearing it in the background when we were coming through the gate of the neighborhood. So we were hearing them arguing over the phone. Her mom was screaming over the phone, arguing. It was just a lot of drama in the back.
Arguing about what?
About, I guess me coming there to drop a gift off for her, from him. So we just ended up having, they were like, no, don't, the dad was like, don't even show up. We got too much going on here. So we had turned around and we dropped that gift off at her home. So that's what happened that day. It was just a lot of chaos. And we had to wait
Why were you trying to drop the gift off at her mother's home in the first place?
Because we had been he had been seeing them little by little, one, because she was going like through cancer treatment. So she was like, hey, can I see him? So when I had jobs out in that area and stuff like that, I would let him drop in for 10 minutes, 15 minutes. And I would sit there, let them talk, let them have interactions. That way they would at least have some type of relationship. So you can kind of talk it through. Hey, this is what happened, grandma, blah, 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 blah. I don't know what they talked about, but I just wanted to make sure that interaction was happening to where he didn't lose. I didn't want to feel like he lost everything is my main thing. I didn't want to feel like he lost his world, because that's what he felt like. you know, and it was rough to see that he didn't have an interaction with anybody in the family. So I would still keep up with the father, with
So
her.
why were you on the phone with her if your intent was to silently drop off the gift?
Say that again, Your Honor.
Why were you on the phone with her if your intent was to silently drop off the gift?
So we weren't on the phone with her, y'all. I think I got it just to be sure. I was hearing them in the background, right? And then when I did call her, it was arguing. Like we were
I don't know how you can hear somebody in the background if you're not on the phone with them.
We're in two different places. When I was at the edible arrangements, we called her. That was the cussing and fussing in from her specifically. But when we got trying to get to the gate to drop the gift off first, after the edible arrangements, right? That's where we kept hearing the arguing in the background with her and her parents, when, you know, via whatever.
Okay, let me just back up. You call her at edible arrangements because you wanted what?
Letting her know that, hey, we're, you know, can we bring a gift by, whatever. She's like, I'm not home. And she got irate then.
Okay.
Right.
I'm not home. I thought your intent was to always drop it off at the grandparents' house so that you wouldn't have interaction with her.
Right. But I felt it also, because this is a torn moment right here where I wanted to make sure that he could have some type of interaction with his mom. But if we couldn't, I knew the grandparents was the next best thing, because that's who I have the positive interaction with. Right. So if I can't bring it to mom, then we can at least drop it off, son, because I was picking up more than one gift. So I wanted to.
So why would she be at her mom's house if you told her the gift was coming to her house?
We didn't know she was going to be there. We had no clue because we were coming through the gate to drop the gift off.
Okay.
So her truck was there.
Okay.
We were right behind her. Couldn't have made it up. It was right, boom. She's right there coming through the gate. But over the phone, because we were on the phone.
So you never did drop the gift off?
We ended up we couldn't get to the grandparents to drop the gift off to them. So we ended up circling back.
So she's cussing at what?
Say that again?
What is she cussing about?
She was cussing about the fact that, if I'm not mistaken, let me let my son kind of clarify.
No, you know.
I can't remember everything.
What was she fussing about?
She was just fussing about us trying to get to her and the last minute, not really being able to see him. My recollection. So that's what I do. I remember.
So she's fussing about it being last minute and her not being able to see it.
Right.
Okay. And at the time, your intent was for her to see it.
At least have somebody to drop the gift off and just be kind to his mom, to try to break the ice.
So why was she angry if you were letting her see it? Do you know?
Just short term, that's her to specify.
Okay.
I honestly don't.
All right. Okay, so that was the second time.
Third interaction.
Physical, in person.
Physical, in person. I think, I'm thinking, yes, he came home and told me after he was with his grandparents, where they went to like a restaurant, I think, where I didn't know the mom was going to be there in the first place, but okay, fine, whatever, right? They went out to eat. And then he came back and told me, yeah, Dad, it was good, but I could feel the tension. And then I think it was talks about like the court case he was telling me about. Like he kept being talks about the court cases and things like that about what was going on. And he felt uncomfortable. Then he was put in the position to be around the stepfather, which he was uncomfortable with, who participated in the alleged abuse, I would say, right? Because all I know is my son knows that. He knows what happened. So that's why we're here in the first place. So he was uncomfortable trying to speak with them. He knew it didn't feel right. He's like, Dad, something's wrong. It just kept being talks. And then the grandparents again were participating in these negative talks every car ride. And this has been happening. Those type of interactions have been happening ever since. And I kept thinking in my head it would stop, but even to the most recent stuff, it kept happening. They continue to want to talk.
When was the eating situation?
I think it was July, something like that.
Okay. Now, was there any other physical interactions?
Not that I can remember myself. It's just like I said, it's been a lot.
And the phone call interactions, tell me about those.
Usually the phone calls are, she usually does like a check-in with him, and then what he tells me is in about 10 minutes, it usually kind of goes off the deep end. After about 5 to 10 minutes is what he specifies to me.
Deep end how?
more talking about, well, your dad doing this, your dad not letting me talk to you, your dad's not this, and you know, that's the kind of stuff that he come back and tell me. And I'm like, son, just try to eliminate that. Just worry about, and if it starts to happen, tell her you got to go. Because I don't want to keep having to hear about how bad his dad is every 5 seconds, or a lie about how I'm not letting him see her and all these type of things. So he really tries to have the interaction, but again, it just boils down to the hatred toward me, is what usually happens on that phone, whether it's him talking to the grandparents or vice versa with her. So it's just a constant barrage of the anger toward me that he has to keep receiving. And when they try to talk about just themselves and their relationship, what he comes back and tells me is that, hey, that it's just, she's not listening. She's not listening to what I want her to hear from me, right? Then that's one of the biggest things. And then it's because it's so angry. Well, you're not a man. You don't talk to me this way. You know, X, Y, and Z. And if he's disrespectful to her, I think he only did that one time we were at the park. And I said, you can't talk to your mom crazy, son. You know, just because you're angry with her. I said, you can't be, you know, it's just constant toxicity, just head bumping over and over again. And I'm like, I just want the peace, because I'm not even in it now. And it's still crazy.
Okay.
You know.
All right, thank you so much. Let me swear Ms. Eldridge in. Raise your right hand. Do you solemnly swear or affirm the testimony about to give to the court is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, can you recount to me your situation, the situation on April at Chili's?
Sure. So Chris had texted me and told me that Cameron had a little bit of time and wanted to see me, and that we could spend some time together at Chili's. I get to Chili's. I was under the impression that it was going to be Cameron and I having dinner together, or early dinner together. Cameron had a menu sitting right there in front of him. And so if Cameron is sitting in a booth, basically like if you and I are looking at each other, he's sitting where you are, I'm sitting where I am. Chris is sitting in a booth, or the defendant is sitting in a booth 2 booths behind, staring at Cameron. So I'm like, I'm not understanding like why you're even here. Like, this is the very first time that I'm able to see Cam. Like, it needs to be about he and I, and it just felt very intimidating. So I told Cameron, I said, well, why don't we just step outside and you and I can sit on a bench and just kind of have our own time to talk, since you don't really have that much time. He is correct. When he approached me in the corridor of the restaurant and was like, well, I'm just trying to talk to you. Now, Judge Barry, this is the first time that I've spoken to Chris since he took Cameron out of the household in October 2022 and told me that I would not see Cameron again until we were in front of a judge. And they have all of these text messages to show that. So this is my very first time. I had no clue about court. I don't know if this was prior court to court or after court, but that was the only physical interaction that I was given time to spend with Cameron. But he is right. I told him, I was like, this isn't even about you. This is my time with Cameron. You shouldn't even be here. Like, why can't you just allow us to have time to spend with each other and then not make it about you? That was that situation. We sat outside for probably about 35, 40 minutes. And then Chris is texting me, telling me, you got 5 minutes left. Okay, your time is up. Cameron needs to come to the car. And Cameron leaves. There was no negative interaction between Cameron and I. It was the only brief disagreement between his father and I, just because you're literally sitting here a booth away, staring at the back of my head and looking at Cameron. Of course, that's going to seem intimidating. That I don't know if you're telling him what to say or if you're reading his mouth the entire time. It was just an uncomfortable situation for everybody, and he shouldn't have been a part of it.
Okay, and what about the Mother's Day incident?
So Mother's Day, I had been asking to see Cameron for Mother's Day, no response. And then they called me at about 2 something, and I had just got done having brunch with my husband. He took me out for Mother's Day, and we were on our way to go and pick up the kids from my parents' house. Chris calls me and he's like, hey, are you going to be home in, I need you to be home in 10 minutes so that I can drop this gift off to you from Cameron. I said, well, is Cameron in the car? I'm not going to tell you that. I said, it's Mother's Day, Chris. Like, I'm trying to see Cameron. I don't want you. I'm not trying to see you. And he basically hangs up the phone after that situation. He wouldn't tell me if Cam was in the car. And he said, well, fine, we're just going to drop it off at your house. So I happened to be pulling up to my parents' house, going inside to pick up my other two children. And I guess he's behind me. I don't know. I actually didn't even pay attention. I didn't know that they were behind me. There was no arguing between me or my parents. I'm not sure where any of that came up. But by the time I got home, there was already a gift sitting outside on the driveway. So I don't, it was my understanding that they dropped the gift off to me at my house first, and then they were going to my parents' house to drop the gift off, drop their gift off to them. I don't know the order of things, but when I got home after I picked my other two children up from my parents' house, there was a gift in the driveway.
Okay, and the July dinner for July dinner?
So to preface that, there has not been any, again, that Mother's Day incident was over the phone. That wasn't physical. I never saw Cameron. And again, it's Mother's Day. You would have thought that he would have made an attempt to allow me to actually spend time with Cameron on Mother's Day. And that never happened. They called me last minute saying, you need to be home in 10 minutes. We're about to go drop a gift off. When it came to July, there was no visitation extended to me. That was extended to my parents. It just so happened, and like he said, that I didn't even know that she was going to be there at brunch because there was no visitation for me. Of course, when my parents had him, they're like, Jasmine, let's go out to eat, bring the kids. That was Cameron's first time meeting his little sister. He had not met his sibling before. So it was a positive experience. I have tons of pictures. We had a great time. There was no negativity. He hugged me. He hugged all of our family members. I have pictures of him standing right next to my husband with his arm wrapped around him. And we're just one, at the time, happy family. And so we saw Cameron, and that was it. That was the last official time that I saw Cameron, but that was through him granting visitation to my parents, not to me. And since then, in July, literally the weekend after Cameron visited, Chris reached out to me and asked if I wanted to spend time with Cameron for his 15th birthday. He said he's only available from 9 to 12, and he was going to go get his driver's permit. I said, sure, if 9 to 12 is all we're going to get for Cameron's birthday, I'll take it. Chris ends up getting served 2 days prior to Cameron's birthday, and then he sends me a text message, which the opposing counsel has, stating that you're a threat to Cameron, and for his safety, you won't have any contact with him until we go back to court. And from then on out, Judge Barry, I have been blocked. The attorneys had an understanding in, I believe, August or September, that we would establish phone call visitations with Cameron every Tuesday and Thursday at 8 p.m. Not one telephone conversation to date has been completed. With the opposing counsel, I have sent text messages every single Tuesday, every single Thursday at 8:00 p.m. telling him that I just called Cameron, no one answered, and it became very obvious that I was blocked. By December of last year, prior to me having my daughter, I realized that the telephone was completely disconnected.
When was Cameron's birthday?
Cameron's birthday was August 2nd. Chris was served July, I want to say 29th, if I'm not mistaken. And then he took away that visitation and said that I was a threat to Cameron, and for his safety, he was no longer going to allow Cameron to see us for his 15th birthday. I continued to call that day, send text messages that day. We were blocked, and we've been blocked ever since, Your Honor. So then in December, I realized that the telephone line disconnected completely. I reached back out to my attorney, to let her know, hey, I have no way of getting in touch with Cameron. The phone has been disconnected completely, and Cameron doesn't have his own cell phone. Then in in March, my attorney reaches back out to the opposing counsel's attorney and says, this is a clear-cut case of alienation. You have to provide my client with some type of feasible contact information for the minor child. This is inappropriate. I never received anything. And then my last thing, and I promise I'm wrapping it up, is when I finally did speak to Cameron. He happens to call me, first, Chris calls me from his new cell phone.
What date?
On April 1st of this year, so less than a month ago. We're almost a month out. Chris calls me from his new telephone number, and I hear birds chirping in the background, and he says, hey, this is my new cell phone number. I'm going to give Cameron your number, but you all have a lot of things that you all have to work out and discuss. Cameron is, not very happy, but, it is what it is. And I said, well, I wonder why, Chris. And he's like, I'm not going to argue with you, and hangs up in my face. 45 seconds later, I get another telephone call from a different number, and this is Cameron now calling me. Same birds chirping in the background, which I'm assuming this is the park situation that he was referring to. I don't know. Birds chirping in the background, and Cameron is calling me. Cameron is pumped up. He is disrespecting. He is being very rude. He says, the first thing that comes out of his mouth is, this whole situation is quite honestly just foolish. I don't even know why you're even bothering to reach out and call. Like, this is all just dumb. And I said, what are you talking about? He was like, you're taking my dad to court. I don't understand. I chose the parent that I wanted to live with, and you just need to accept that. And if I don't have to have a relationship with you. And I said, Cameron, I've tried to reach out to you for months now, every Tuesday and Thursday, to have a telephone conversation with you, and I have been denied. I've been blocked the entire time. Throughout that conversation, Cameron is very angry. He's very irate. He's just an unrecognizable child, Father God. It just feels like he's been manipulated and manipulative. I kind of continue to lead with love in that conversation, letting Cameron know that, hey, you are so missed. We love you. We haven't seen you. You haven't asked about your brothers and sisters. When am I going to be able to see you? Well, I don't know. It's up to my dad. I would have to talk to him. And I said, okay, well, I would love for this to be a good starting point for us to try to rebuild a relationship and talk on a routine basis now that you have a telephone. He said, well, that's fine. And I told him, I said, Cameron, but why are you so angry? You haven't seen me in a year and a half. I'm sorry, you haven't been back to this house in a year and a half. You haven't spoken to me in 7 months. This is the first time I'm hearing from you in 6 months. And why are you so upset with me? Like, there's nothing that I have done. In this conversation, Cameron has called me manipulative.
Miss Eldridge,
liar.
so
Yes,
some of the concerns that your son mentioned to the court when the court made this order, you're saying no one's ever indicated to you, Cameron has never said to you, Mr. Barnes has never indicated to you what son's name's Cameron, right?
Cameron, you're correct.
Yeah. What Cameron is angry about or what he's concerned. So you have no clue what his allegations against you and your husband are?
Yeah, no, now I do, yes. But again, Your Honor, when all you're talking about with the child.
How did you find out?
The way that I found out that, well, the way that I found out that Cameron was angry was, again, on my 1-year wedding anniversary, October 2022. Cameron was there with his dad for a regular routine visitation. And the day that Chris was supposed to return Cameron, he texts me and says that he's not bringing Cameron back because I'm physically and mentally abusive to Cameron. And he said that he already had everything in line with an attorney or a judge, that he did not legally have to bring him back. And so he did not bring him back. During that time, I had a high-risk pregnancy.
Specifics other than mental and physical abuse. Has anyone said, this is a particular incident where he said you touched him or said something abusive towards or against him? Has anyone said to you what those allegations are?
No. Oh, yes. Okay. So I understand what you're saying. The first time that I heard anything about the allegations as far as me being abusive was in a week after he did not bring him back. DFACS called me and said that the reason why they weren't bringing him back was because I was physically abusive to Cameron, that I punched him in his face and nose 12 times. Now, ironically, Judge, I have pictures of that weekend that they're referring to. Cameron is in the swimming pool. Cameron went to a Braves game with us. We were sitting there and like one happy family. So these were all, I hate to say it this way, but these are lies and fabrications. I've never abused my child. In 14 years, I have never abused that child. I don't spank him or anything. The incident that took place was in his 8th grade graduation in May of 2022. Cameron stole money out of the house, and he took a gaming laptop that we purchased for him out of the house, as well as some clothes, and he was going to sell them at school in exchange for a BB gun. Cameron did get the BB gun from the other child, and he took his book bag to my parents' house. The book bag, the BB gun falls out of the book bag, and my mother happens to see it. She goes in all out panic. She calls me and lets me know. And Cameron is like, I gotta call my dad. I gotta call my dad. I told Chris ends up calling me saying, hey, I understand there's a BB gun. I'm just gonna come pick it up. It's no big deal. It's okay. I said, no, don't worry about it. I'll handle it with Cameron. And I'm also going to figure out where he got it from and get in touch with the other parent. So during that time, Your Honor, he was disciplined. He was disciplined, and he was put on punishment because we had a conversation about guns, about young Black boys with guns, about that you aren't allowed to have one.
During that incident?
No, ma'am. My husband has never put his hands on Cameron ever. Ever. And I would like to just add some background to that if I could.
No, not right now. Okay.
Okay.
So, all right then, thank you.
Sure.
One more thing, let me go back to Mr. Barnes. Mr. Barnes, you said that he was in counseling. What's the counseling schedule and how long has he been in it?
We actually couldn't get in there early enough, but we just he had his first meeting yesterday.
He just had counseling.
Right, with a pastor. So when he's been with me, he had been baptized. I had been counseling him biblically. So he's been kind of turning over a new leaf at the school that he's currently at. So he's been talking to teachers, but the personal counseling session has happened yesterday. Was the first one that we've had, which helped him get to this point where
why did you wait? Why, if you see your son is angry, not visiting a mother, have brothers and sisters he's not interacting with, why would you?
Well, this is the biggest thing, Your Honor. Every time I tried to push it, he fought back against it.
Well, he's 14.
And he didn't, and every time he's like, I'm just gonna run away, Dad. I'm gonna run away. I don't want to see them. But they're thinking it's me telling him, hey, don't go see her. No, it's not.
I don't know if they're necessarily thinking it's you, but you're the adult, you're the parent. And when you see your children going through mental health crisis where they are rejecting people, including people who are innocent, like their brothers and sisters, there's an issue. And you have.
I think the issue is that he keeps feeling like his mom is continually lying to him. And in some of these stories,
well, here's the thing, Mr. Barnes, since you're not at the table when they're seated and you're not in the home when they're having those issues, since you're not there, the only thing that comes up is what he's seeing. What if what he's seeing is skewed by the fact that he's 14? Mm-hmm. Or what if what he's skewed is by a fact that he's depressed or some other situations?
I think it is that, Your Honor. I think
he's still a kid. And so what I'm asking you to do is that when you have a situation wherein there's a complete alienation of a parent, that should alarm you. Now, there might be reasons for it, obviously, and I can't remember specifically what he said to me. And I was trying to look for my notes or recording so I can remember. But I kind of get the feeling that what he said to me was that it was mostly mental, like the things that they were saying to him. I didn't get the feeling it was a lot of physical stuff. There might have been one incident where he recalled something physical to me. But I think by and large, because if it was a lot of physical, I probably would have put in here like some type of supervision or something like that. So I think it was mostly mental. Kind of growing up in that situation. And so I'm not necessarily saying that's good. I don't know either. But I do know that when you have a situation wherein you have a kid who's completely refusing to be around a whole group of people, grandparents and siblings, that's alarming. You should be worried about that. That means something is going on that you can't get through to him. And then if the first thing you're doing is you're going to a pastor who may or may not have the ability to address his concerns, I don't like it. I don't like it at all. Give me one quick second. I apologize. Let me allow any proffering that the attorneys wish to make regarding the motion. So I'll start with you, Ms. Verheen, if there is any additional proffer you want to make to the court.
Yeah, Your Honor, I would just say again that I do not think that according to the order that you entered in April of 2023, 23, I believe it was. I think I have my date right.
Yeah, you
I
got it.
I do not think that the plaintiff has met the burden of showing that there's been any material change in condition or circumstances that would warrant modification of your order from that date. So I do believe that her motion to modify custody should be dismissed along with the other petitions to modify child support and for contempt. Based upon the testimony that you've heard today, my client has shown that Cameron is not in any shape or form, willing to or wanting to have, a lot of contact with his mother. And by the court's own order, you found that there was mental abuse present and had previously ordered that visitation should be at the discretion of the father. And I believe that that was mostly based upon what you heard from Cameron at that hearing. The mother was not present at that hearing for whatever reason she wants to claim that was. We tried to give her notice both by a private process server and publication, but she did not appear, and she had her chance to appear at that hearing and have her say. So I feel like the court had enough evidence at that hearing from Cameron to make the order that it made, and that order should stay in place.
All right, thank you, Ms. Banksworth.
Your Honor, I would proffer to the court that the party's testimony alone is sufficient for the court to make a determination that there has been a material change in circumstance, namely that Mr. Barnes has utilized this order as a weapon in a way to preclude my client from ever having any relationship with this child. Why do I say that? By his own testimony, he admitted that even when he reached out to mom, because the child indicated he wanted to see mom, he put her on a time clock. Her testimony was that he gave me 30 minutes.
I'm sorry, Your Honor. Please forgive me, but we lost Miss Eldridge.
Oh, you're right. We did. Let me text her.
Okay, how long has she been gone, Miss Marsha? Have you noticed?
Maybe about 2 minutes. I was just trying to catch Miss Banksware on a quick breath.
Paying attention, okay.
Okay.
Maybe about 2 minutes, Your Honor. I was trying to catch Miss Banksware on a short breath.
Okay, let's just pause real quick. On the Ekman case, it'll clearly be after lunch. I'm just going to ask you guys just to return at 1:30. So on the Ekman case,
understood.
Going to ask you guys to return at 1:30.
Okay, Your Honor.
Ms. Kissay? Okay, great. Thank you. Make sure you let your clients know. I'll see you back here at 1:30.
Thank you, Judge.
Okay.
She said she's logging back in now.
Okay.
I'm not sure how much she missed, but what I was trying to say, Your Honor, is that by the party's own testimony, because it sounds like Ms. Verheyen and I heard two different things. What I heard from Mr. Barnes is that he reached out to my client in April. He did tell her that her own testimony, I'm giving you 30 minutes. He sat so that he could, as she said, she felt like it was intimidating to the child because he was looking right at the child while she was trying to have a conversation. She moved them to the bench so that they can talk. And even then, even when he said, I left them alone, he's out in his truck or wherever he's at, and he's texting her saying, you got 5 minutes. So she didn't have time to even have a real conversation with her son. The other times, because you specifically asked him, when did she have face-to-face interaction with this child where she could visit with him? And I think it was one time other than accidentally seeing him in July, which he allowed the grandparents to have visitation. And he mentioned the grandparents over and over, even though they're not parties. He mentioned the grandparents to say, well, I think it should have a relationship with somebody on her side. So he's decided that it should be her parents and not the mother of this child. He's the one that's facilitating visitation between the grandparents and their son. They're not parties. They don't have any custodial rights. But because he has authority under this order to do as it appears to me as he sees fit, then the only access he's allowed to this child is through my client's parents. When she indicated that she reached out to him on Mother's Day and he took the time to go buy something for Mother's Day, her testimony is, she even asked, well, is Cameron with you? You don't need to know. It's Mother's Day. Why would she not want to see her child? Because dad has all the power and he's using it in such a negative way, such that my client, if it continues, will not have any relationship with this child whatsoever, because dad has deemed that it's not fit for her to have access to this child. And even if Cameron decided, okay, well, I'm feeling a little uneasy, the answer is not keep him away from mom. The answer is to let them work through whatever the issues are. And that hasn't occurred. That has been suggested though. Real therapy, reunification therapy, that has been suggested. And the response to that suggestion is, we're moving to dismiss. We don't think you have a case. We don't think you should have filed. That's been the response. The response is, we don't care about your relationship with this child because this child says he don't want to have a relationship. And that's okay with dad, apparently, because he's fighting this tooth and nail for my client to have no access to this child. And as the court said, that should be alarming to dad, but apparently it's not, because we're here today arguing a motion to dismiss as opposed to trying to figure out a way to reunite these two parties. She's going to always be his mother. That's never going to change. But he's 15 now, and as he gets older, if he's allowed to not have any access with his mom, she may not be able to repair it once he turns 18. She feels like he should be able to interact with her, his brothers and sisters that he's got from her other relationship with her husband. She's expecting now, have another baby on the way. She wants him to be a part of the family, as he was since the original order. Mom had primary custody of this child from October 2010 until dad decided in October of 2022 that this child couldn't go back to visit. She had primary custody. And at no point in time did she ever try to alienate this child from dad. And as soon as dad gets custody, what does he decide to do? To alienate this child from mom, who's been his primary custodian most of his life. And that should not be okay. So we're asking the court to deny this motion to dismiss. My client provided evidence in court in November to show that she was actually terminated from her position. The statute clearly says when someone has involuntary loss of income, once the petition is filed, the court is to try to have a hearing as soon as possible. But not only that, any amount of money that's attributable that's to determine the support that's been lost, there should actually be no child support from that date forward. There is an arrears that's out there now because the motion to modify the child support, but based on her not having a job, has not been heard. They're moving to dismiss that. Counsel is saying, well, you know, I don't have any evidence she's not working again. But we showed you evidence that she was unemployed. She can't show you, other than her saying, I'm not working, that she is not working. She can tell you what she's tried to do to find work, but she would testify today that since she's found out she was pregnant, she has a high-risk pregnancy and she's been on bed rest. So she hadn't been able to go out and get a job. But so the petition to modify the child support needs to be heard. And not only that, Mr. Barnes is coming to this court asking for relief when he knows he's in contempt for the 2020 order. I can tell you that he owes the $3,800 and let me get the exact amount for my attorney's fees that he has not paid. Like, he has not paid it to me. He has not paid it to my client. I think I listed it out in my order. $3,812. That was ordered. He was supposed to pay it over time. Not one dime. He didn't pay my legal fees. He was supposed to pay past due child support to my client, $1,485.55. Not one dime. He hasn't paid it. Even when I responded to her motion to dismiss, I even pointed out to the court, it would be one thing to ask to dismiss if he had evidence that he had paid and we were just being frivolous and filing and knowing that there was evidence of him paying. That wasn't their position. Their position was, we don't quite know exactly what he owes, so then we're going to dismiss your contempt. By the way, there is a contempt that they filed too. because there was an order that was put in place. So when they filed an answer to the modification that we filed, they did a counterclaim for contempt against my client, saying that she was in arrears for not paying child support, which she was. That's not in dispute, because he owed her so much money that he didn't pay from the 2020 order. It didn't make sense for her to start giving him $519 a month when he owed her almost $12,000. But I got the specific amounts in my motion. So I say that to say, and I know the court is not hearing all this today.
Right.
Everything needs to be heard. If he's got proof that he paid my attorney's fees, show it to me. I dismiss it. He can't do it because he never paid them. If he's got proof that he paid her the $1,465 for the past due child support, show it to us. We'll dismiss it. If he's got proof that he paid for the past due medical premiums, show it to us and we'll dismiss it. We haven't dismissed it because he's provided no proof that he ever paid. So he does have some nerve coming to this court, asking for any relief when he comes to the court with unclean hands. So we're asking the court to dismiss their motion or deny their motion to dismiss this case. And I put this down for a hearing so we can have all these issues heard. But specifically, my client wants contact with her son. That's what's most important to her. She wants a relationship with Cameron. Whatever we need to do to get that facilitated, she wants that to be done. What we do know from this past history is that if the order stays the way it is, she will not have any contact with this child, because the efforts that she's made have not been successful. Whether it's trying to reach, she said, she testified herself, I try every Tuesday and Thursday, because I had a conversation with counsel at the very beginning of the case. It's like, let's try to set up something so she can at least have phone contact. Hadn't happened. No phone contact, no visitation, other than, like she said, she bumped into her parents with the child in July. But there's been no regular visitation. No every other weekend, not even one time every other week. There's been none of that because of the way this order has been utilized by Mr. Barnes. And we do not believe that that's in this child's best interest.
All right. So the child initially presented to Mr. Barnes that there was either some physical, but certainly mental concerns that he had living with his mom. I think in his affidavit, or I don't know if it was verified or not, but he put some things down there. And I think initially he was saying he may have said something about threats. Let me see. Let's see exactly what he said. I think he said threats. So I think he indicated that there were threats that he was concerned about. He said he had a lot of mental stress on him. I do remember him talking heavily about just a lot of mental stress on him when he's dealing with his mother and her husband. So he was under an extreme amount of stress. Are the other children that you have, Miss Eldridge, are they all from the husband that you are currently with now? You're on mute.
Yes, Your Honor. My other two children and the expecting child is with my husband.
Yeah.
And I helped raise Cameron for 8 years prior to this situation. He's not new.
Okay. Yeah, I don't think he's necessarily new, but I don't know. I just remember it could have been something dealing with the dynamics of how those children are handled. I don't know. I can't recall directly. I do have some flashes of that conversation, and I don't have a recording of it that I can.
Well, they're toddlers, so they are handled differently than
right, but a 12-year-old won't know that, though. Sometimes children don't get that, and so they feel it's a difference. You just have those dynamics.
Yeah.
You have children, so I can't remember exactly what it was, but those are some of the dynamics that I kind of tangentially remember being brought up. But what I'm trying to say is that he then went to his father's house, and his father provided him some mental relief. I remember him talking about that, and that was really important, that his father provided him some mental relief. So I think Mr. Barnes is protecting his son. He believes that what he's doing is giving his son what he wants, and that is protecting his son. I don't believe necessarily that Ms. Barnes is doing things just to be a hell raiser, or just to to make things go awry. I think Mr. Barnes is doing what he thinks helps his son. The problem that the court has is that, and this happens plenty of times, is that parents will believe that they're helping their child by giving them what they want. And that is not always the proper way of handling your circumstances when you have kids who are alienating a parent. And you think, Mr. Barnes might be thinking, and I'm not a psychiatrist, so some of this might be completely wrong, but that's just the problem. The problem is neither of us are. And there is a place where this child needs to be, and it is not in counseling, because it's clear he needs some counseling. And so I think your position was, and the court's position was, giving you control, was that so that you could protect your child. But I don't think that necessarily means the protection is giving the child what he wants. Okay, that's not the protection that you should have to be focused on. You should be focused on making sure that the child is mentally healthy. It doesn't necessarily mean giving him what he wants, which is, okay, I just won't deal with mama because that's just simply easier for me. It could be simply easier for him, but that doesn't mean that in the long run it's going to be better for him. And so that is the concern that I have. So I'm not trying to throw you under the bus, but I do want you to recognize that just because your son says, I don't want to see mom, then you go, oh, well, he doesn't want to see mom. I did my part. I asked, because if that were the case, then we would have plenty of alienated kids, because they're 12 and they're 11 and they're 13 and they're acting like children, but you are an adult and you got to understand the importance of having relationship with both parents. And I don't think having one situation where you meet with mom in April is sufficient. It's not. And the reason why it's been so long is because the child hasn't had any type of counseling or therapy to have some type of reunification, or some type of situation where you as a father can then continue to have mom and child have relationships. They can't have a relationship if your first thought is, I'm going to give the kid what he wants. Because if that's your first thought, then counseling would not be important. But you, as the custodial parent, you got to make sure your child is mentally healthy, and having a relationship with his mother is important, to the extent that can be had. Now, I understand there's some situations where that just can't be. But I don't think, from what I remember hearing from this child, that's where we are, because there are certain things that I know that I would have done as a judge that would be different from what's in this order, because I know how I handle things. So I don't have any actual recall, but I know whatever it was, it wouldn't have put me in a situation where I would just say, oh, let dad decide. But I want that to be very clear, because both of you have good points with regard to what's happening with your child. You're just on different pages. Like, for example, on the Chili's, it's a good thing that you wanted mom to have a moment with her son, but it's a bad thing to encroach, because if you're sitting two seats away, that you have a 14-year-old, he can come back and tell you, if he felt uncomfortable. You don't need to literally be in the same atmosphere. You could be, like you said, in your truck waiting for them to come out. So those are just small things, right? And you're saying, well, I'm protecting my kid. Sure, that's exactly what you were doing. But you also have to balance that with regard to what messages you're also sending to the child, because now he thinks his mom is dangerous. So dangerous that you can't even watch that situation. They can't even be in the same room together without you present. So those are messages that you're sending, and they may be subliminal and you may not recognize them. But then after a while, you get what happened at the park, which is, I ain't got to talk to you. I don't have to do nothing you tell me to do. And you know how he knows that? Some message got sent. Okay. What happened in the park is a direct result of what's happening in April and Mother's Day and in July. There are messages and they're being sent. And you may not recognize it because you're doing what? Protecting your son. I'm gonna deny your motion to dismiss, because I do think there is material change of circumstances, not necessarily your behavior, because I think your behavior is exactly what I anticipated it to be, because that's exactly what you presented to the court initially. But his behavior is not. Okay, his behavior is to change, because his behavior is, I don't want to have anything to do with my mom to the extent that I feel free enough to tell her. And feel like he can be disrespectful. And even you recognize that and saw it. So, and I anticipated you to do what you were supposed to do, but I did not necessarily anticipate you to give in to what your son absolutely wanted and not give him the mental health that he needs. So in the interim, I'm going to rule that I'm going to deny your motion, and I'm also going to require you to have him placed in reunification therapy instanter. And then after that, we'll figure out what goes next, because at the time the court is giving you the ability to co-parent and make some good decisions. Let's see what you do. All right, so reunification therapy immediately. The phone calls will start. And additional visitation as you determine right now until we have additional hearings, because I do need to speak with him again, because I just cannot recall what he said to me at this juncture. Okay, so I'm going to put hearing, we're going to have a status in 6 weeks and kind of see where we are. All right. Okay. All right, Ms. Banksworth, if you don't mind writing that up for the court.
I will, Your Honor.
All right.
Judge, can you tell her or explain when you want that, please?
Huh? One more time, Ms. Harris.
Can you explain when you want that order?
Oh, the time frame. Ms. Banksworth, when can you have that to the court?
Give me a deadline. I got you.
Huh?
I said, she said, give me a deadline.
Right. So she don't have to be, yeah, because I'll be bothering her like, when is that Barnes order in? And she'll be like, well, you didn't give him a deadline.
Well, I do have a trial starting on Wednesday in person. It's a 2-day trial. So if I could have at least until probably Friday, I could probably get it by Friday.
All right, I'll have it on Friday.
Okay.
All right, thank you. Y'all are free to leave.
Okay, thank you.
All right.
And how long have you had the children with you?
Since October of 2022.
I believe you've told the court you want no overnights, correct?
Yes.
However, due to my circumstance, I'm currently, again, 7 months pregnant.
Renee Overstreet for Destiny Taylor.
And Ms. Warren?
Mary Ann Warren, Assistant Attorney General for the state of Texas.
You may proceed with your partial agreement.
Okay, Judge, we have agreements on everything except for conservatorship, and that means joint with father having exclusive right to designate residence or sole managing conservator. And visitation is also contested. So with that, I would, if I may announce the agreed proposal first and take testimony. The agreement is the parties agree for there to be a non-disclosure of mother's information against a third party, and that would be Ms. Taylor's mother. The parties agree that Ms. Taylor will pay child support based on minimum wage in the amount of $289 beginning May 1st, 2024. The parties agree that father will maintain health insurance and dental insurance through his employer, but will waive any request for reimbursement. So 0 reimbursement for health insurance and 0 reimbursement for dental insurance. The parties agree that retroactive child support will be 0 as of today's date. Retroactive medical support will be 0 as of today's date. Retroactive dental support will be 0 as of today's date, and court fees will be due by Ms. Taylor by June 17th, 2024 as billed. Okay, with that, I will call Mitchell Jackson. And are you the father of the 2 children, the subject of this suit? And that would be Hazel Taylor Jackson and Mitchell Dwayne Jackson Jr.
Yes.
And did you and Ms. Taylor, Ms. Destiny Monique Taylor, both sign an acknowledgement of paternity?
Yes.
Okay. Has there been family violence between you and Ms. Taylor?
Is that contested?
No.
Okay.
I'm sorry. I just, went to the next question there. Did you hear the terms of the proposed agreed order announced to the court?
Yes.
Is that your agreement? The part that I announced, was that your agreement?
Yes.
Do you believe that's in the child's best interest?
Yes.
I'll pass the witness. Ms.
Counsel,
Overstreet?
any questions only on the agreed portion?
No, we don't have any questions on the agreed portion, and that is our understanding of the agreement.
Okay, Ms. Warren.
So I'll call Destiny Taylor. Please state your name, ma'am.
Destiny Taylor.
And is it correct that you and Mr. Jackson signed acknowledgement of paternity?
Yes.
Have you been married to anyone?
No.
Is there any way anyone else could be the father of these two children?
No.
Did you hear the terms of the proposed agreed order as I announced to the court?
Yes.
Is that your agreement?
Yes.
Do you believe that's in your child's best interest?
I'm sorry, repeat that.
Do you believe the agreement is in your children's best interest?
Yes.
Okay, I will pass the witness.
Counsel, any questions on the agreement?
No questions about the agreement. Thank you, Your Honor.
Court accepts the partial agreement. Now you can proceed on the contested issues.
Okay, I will call Mitchell Jackson again for the contested issue. Mr. Jackson, what kind of conservatorship are you requesting from the court today?
We start with family violence. Sir, has there ever been any family violence at all between you and the mother?
No, ma'am.
Okay, so with that, what type of conservatorship are you requesting?
I'm requesting every other weekend, Friday, Saturday, Sunday, 6 a.m. to 6 p.m. and Tuesday, 6 p.m. to 8 p.m.
You're the custodial parent.
Yes.
So that's your request regarding mother's visitation. Okay,
Yes.
Go ahead, counsel.
Okay, I just want to clarify something, Mr. Jackson. Are you wanting those weekends? You said Saturday and Sunday, is that right?
Yes.
Okay, I believe I'd asked you about conservatorship though, and we were talking about is joint managing conservator versus sole managing conservator.
Oh, yeah, just so.
And do you understand what sole managing conservatorship is?
Yes.
And in your mind, what does that mean?
Make decisions on regarding medical, school.
Okay, and why are you requesting sole and that you would not want mother to have any of those rights? Why are you requesting that, sir?
I don't think it's the best interest in the kids for her to make those decisions, judging by what happened previously in the past.
What has happened previously in the past?
Son has gone to the hospital about 8 different times just by his asthma. And just last Sunday, I had to pick him up early because he was wheezing.
Okay, so it's primarily because of medical decisions?
Are you saying that she is what's causing the child has asthma?
Yes, and when that happens, he has to get on the machine, and that's not. I don't think that's been understood on her end.
Okay, so you're saying she's not treating the asthma and it exacerbates, and you're having to take the child to the doctor or the hospital?
Yes.
Okay. How did the children come to live with you?
Because she wanted to. She felt like it was too much for her at the time, so she ended up going to California, and I told her, I agree, that the kids should be with me all the time, full time.
And how long have you had the children with you?
Since October of 2022.
And does mom see the children on a regular basis?
No.
Does she ever keep them overnight?
No.
She's never kept the children overnight since October 2022?
It was last year. I think the last month, I would say probably was November when she was living with her mother.
Has she asked to keep them overnight and you've denied it?
Yes.
So she's asked, but you've denied it?
Yes.
And tell me specifically why you've denied that.
in the past, when she first moved to her own place, she had moved with a guy. I didn't know him at the time. So, and not only that, before that, didn't really trust I didn't really trust her in terms of my son's his health condition. So I told her we gonna take it time by time, and I have to meet your boyfriend if they're gonna be over there overnight. And then we just agreed that they're gonna start going over there overnight. They're gonna start spending night overnight. And my daughter just told me the other day that it's another roommate that stays with her. I didn't know nothing about that. So
How old
now
are the children? How old are the children?
oh, my daughter is 7, my son is 4.
And does the boyfriend still live there?
Yes.
Okay, and same question is going to be asked of her. Do you know if any other children live there other than those, the roommate and the boyfriend?
I don't think so.
Okay. All right, Ms. Warren.
So Mr. Jackson, you were trying to say your proposal first, and I believe you said Tuesdays, every week from 6 p.m. to 8 p.m. Is that correct? Did I hear you say that? Can you hear me, Mr. Jackson?
I think it's something wrong with the connection.
Okay, so as far as the 1 day a week during the school year, you both have agreed to Tuesday from 6 to 8, correct?
Yes.
Instead of Thursdays.
Yes.
Okay, but you I believe you've told the court you want no overnights, correct?
Yes.
And first, third, and fifth weekends, Saturdays and Sundays. Now you said 6 a.m. to 6 p.m. Did you mean 6 a.m. or a later time?
It can be it could be later than that. It could be 6 a.m. or 8 a.m., whichever works best for her.
Okay. And you wanted this
And I apologize. I didn't ask how much time did you need, and I'm gonna ask Ms. Overstreet. How much time do you need, counsel? For you?
I think we had said it could take 30 minutes, but I don't know how much time we've used so far.
And Ms. Warren?
That's what we had talked about in the breakout, that we would ask for a maximum of 30 minutes.
Okay. So I'm gonna set it for 20 minutes at this point.
Okay, thank you. Okay. So anyway, Mr. Jackson, I'm just trying to make it clear what you're asking for, and you're asking that to continue without holidays or large summer, just that first, third, fifth weekends, daytime visits.
Yes.
Okay. Let's see. I will pass the witness and let Ms. Overstreet.
Okay, counsel.
Mr. Jackson, you said that that the hospital, you talked about your son going to the hospital for asthma. That was 2 years ago, isn't that correct?
Yeah, so the last time that he had to go to the hospital, still a few days later, that's when she went and left. So yes, that's when she was having them.
That was back in 2022?
Yes, ma'am.
Okay, and recently when you picked him up early for the wheezing, did he have to go to the hospital?
Oh, ma'am.
Okay, and is it your testimony that he never has asthma problems when he's with you?
Yes, ma'am.
Okay, so
he has asthma, but he never has to go to the hospital with me.
Okay. Well, if he got severe enough, you would take him to the hospital, right?
Yes, but that
Okay.
only happens when you don't put
I just need you to answer the question, not give any commentary at this time. I'm sorry. Objection as to after no. So you talked about a machine. Does Miss Taylor have a machine, the asthma machine?
No, every time he goes with her, he has a machine with him.
Okay, you give her the machine. Okay, has she been able to talk to the doctors about how to use the machine?
It's been explained to her when she took him to the hospital 2 years ago.
Okay.
Yes.
Okay, so she knows how to use the machine. And the time, so you have denied overnight visits to Miss Taylor since October 2022?
Oh, ma'am. When I was telling the judge, I told her the last time that there was overnight with Destiny, it was November of last year when she was living with her mother.
November 2023. Before November 2023, did you ever deny Destiny overnight visits with the children?
No, I don't believe so, because she was staying with her mother.
And since November 2023, have you denied Destiny overnight visits with the children? Yes or no?
Say yes.
Yes, you have. Okay, pass the witness.
No further questions. I'll call Ms. Taylor. Ms. Taylor, what kind of conservatorship are you requesting the court give you today?
Family violence. Has there ever been any family violence between you and the father ever, ma'am?
No, ma'am, there hasn't.
Okay. Now, what type of conservatorship are you requesting?
Yeah, what kind of conservatorship are you requesting?
Joint conservatorship.
Okay, has your youngest child suffered from asthma?
Yes, he does.
Has he been in the hospital several times?
Yes.
And do you know how to take care of his asthma?
I do. The time is mentioned prior 2 years ago when he was having frequent visits to the ER. At the time, I was living with my mother, which we discovered she had a mold infestation. So the mold was what was triggering his asthma. Anytime he went with his father in the separate residence, he did not have that issue. So I was doing everything in my capability, nebulizer, inhalers, visits. But
okay, where are you living currently? What kind of
currently I live in my own residence in an apartment.
An apartment. How many bedrooms?
Yeah.
How many bedrooms?
A 2-bedroom. 2-bedroom.
Who lives in each of the bedrooms?
My partner and I occupy one room, and my roommate occupies the other at the moment.
Male, females?
The roommate is a female. So
And your partner?
female. Yes, my partner is a male.
Okay. And are there any criminal concerns or anything that would be a legitimate concern with your partner?
No.
Are there any legitimate concerns with your roommates?
No.
How many beds are in that apartment?
I have 4 beds. I have two of the beds are inflatable.
Okay, other than inflatable beds, how many permanent beds are in your house?
Inflatable beds or inflatable mattresses?
Mattress, like an air mattress.
So when they come, they would be on an air mattress?
Yes.
And where would that be at?
I have a study area in my living room. I do have room in my room. We have room for 2 beds in my actual bedroom, the master bedroom. So we wouldn't be co-sleeping, but I do have the room and space. I'm moving in 2 months. I'm 2 months from my lease ending. So we're in the process of really getting things together as far as moving into our next residence. Prior to me getting a roommate, I had my 2nd bedroom that was available for my children. I also had a bed, a permanent bed in there for them. Upon requesting for
this a narrative, she's going to ask questions. Go ahead, Ms. Moore.
Okay, I wanted to ask you about the time you would want visitation to begin, and did you want when school is out and school begins, or would you want your visitation to begin and end at 6 p.m.?
I'm sorry, you said when school begins and ends. At the moment, no. My only visitation request would be for the agreeable Tuesday 6 to 8 and the weekend. So from Friday evening to Sunday evening before they return back to school on Monday.
At 6 p.m.?
Yes.
So you would want the 6 p.m. option in the standard possession order, is that correct?
Correct.
So are you wanting standard possession to start now or in the future?
I would like standard possession to start next month.
Not be in April, but start in May?
Yes. So agreeably, prior to the court today, me and Mitchell had agreed to what we have been doing. They come every other weekend during the day on Saturday. and I want to continue that through April, but come May, I would like the standard agreement.
Okay.
Visitation.
So presently you have daytime visits.
Yes, I have about 3 to 4 hours during the daytime on Saturdays.
Okay.
Every other weekend.
10 minutes. Next question, Ms. Warren.
Okay, I will pass the witness.
And if the judge started the standard possession schedule in May, are you wanting it to start May 1st? Or I'm sorry, the first Friday in May, which is the 3rd of May, or are you wanting it to start May 17th, which is the 3rd Friday in May?
The first.
Okay.
May.
Okay, May 1st, okay. And then are you wanting the standard summer schedule to start as well, which would be, you would basically get the whole month of July?
Yes, however, due to my circumstance, I'm currently, again, 7 months pregnant, and I'm also moving. My lease is up in July, so I'll be birthing my new child, and I'll also be moving during the month of July, early July. And yes, I would like to have that agreement. I just would like to put that on notice.
When's the baby due?
There's a lot. July 15th. My lease is up July 14th.
Well, would it be better for you then to do something like either a week on, week off schedule in July, or keep the standard weekend schedule for July?
Can you elaborate what's week on, week off? That's just every other weekend?
Every other week. You get a week, he gets a week in the summer.
Oh, yes. Yes, that would probably be more ideal for this year, for this July.
And then next year start and then after that it'd be just the standard schedule. So let me reiterate, you're saying that for this year you want to do kind of a step up to standard, and in the summer you want the judge to order something that's either a week on, week off, or keep the first, third, and fifth weekend through the summer. Is that right?
Correct.
And then for the other holidays, you just want the standard holidays. Is that correct?
Yes.
Okay. I think I covered, and as far as joint managing conservatorship, you're asking for a joint managing conservatorship because you want to do your part in parenting and helping make decisions for the children, correct?
Of course.
Okay.
Children need both of their parents.
Okay, and back in the past, whenever you had left, you and Mitchell agreed that he would keep the children when you went to California. Is that because you were dealing with some health issues back then?
Yes. At the time I was living with my mother, who was very abusive, verbally abusive, and mentally abusive, and I was going through a state of...
1 second. The person that's putting things in the chat, don't put anything in the chat. It's for court use. So no commentary in the chat. Go ahead, counsel.
Okay, thank you, Your Honor. I saw that. So you dealt with those health issues back then, correct?
Yes. Yes.
Okay, and you are here. You are doing your best to get stabilized here. Now you said you were moving in July, and that's going to be a move with you and your partner, correct?
Correct. Just me and my partner. We have a temporary short lease roommate until our lease is up. But no, we will not be moving with our roommate. Just me and my partner.
Okay, and your partner is the father of your baby, correct? The baby you're pregnant with, correct?
Yes.
Okay.
Counsel, I would also like to mention
No, Ms. Taylor, she's gonna ask you questions. It's not open-ended where you can just say whatever you would like. Any other questions, Ms. Overstreet?
Let me make sure I went through the list about okay, you said, okay, you already talked about the asthma machine and everything. Okay, and if the court will allow, is there anything else that you want the court to know in making a decision today?
Yes, prior to me agreeing, making the arrangement, before I mentioned that, Mr. Jackson and came to me with a proposal that I'll paraphrase, but this was his concern, that he saw that I had a lot going on mentally, and he would like to take the burden and keep the children until I'm able to get in a more stable position. This is prior to me agreeing, before even mentioning
Destiny, let me cut you off. The court is not really able to talk about previous negotiations. So what we want to do is present to the court where you are now, what are your plans going forward? And so if there's anything to that point, so that the court can know what's going on now, so that the judge can make an order that's in the best interest of the children.
Okay, well, I'll leave it at that. I just wanted to mention that I know this is prior, but I never was able to really express that I created an affidavit upon me leaving. Once I return back to my children, that we would be able to agree to joint custodialship, that Mitchell would not have sole custody over them, and Mitchell refused to sign that affidavit. So
Okay,
I have put in.
Taylor, this is my question for you. This next place that you're going to live, how many bedrooms will it be?
It's gonna be a 3-bedroom.
And you've already signed that lease?
No, I have not signed the lease yet.
Okay, here's the ruling of the court. No family violence, joint managing conservatorship. We're gonna do this as a temp order, come back on August 21st. No overnight visits as of this time. When you come back, I wanna see what you got set up for the children to have a place to stay if I allow the standard visitation. Now, right now for visitation, it'll be 1st, 3rd, and 5th Saturdays and Sundays from 12 p.m. to 6 p.m. until we come back. On Mother's Day, let's make sure that she has the children from 10 a.m. to 6 p.m. on Mother's Day. That's the order of the court. Am I missing anything else? We can revisit visitation when we come back on August 21st, and you give an update on where you're living, how many bedrooms, what's set up, plus the kids are gonna tell dad what's set up. Okay?
What time did you say for August 21st, Your Honor?
For Mother's Day, 10 a.m. to 6 p.m. The other visitations are the 1st, 3rd, and 5th Saturdays and Sundays from 12 to 6 p.m.
She's asking about the next court date, August 21st.
Oh, I'm sorry, August 21st. I apologize.
At 9 a.m. She's asking.
9
the
a.m.
time.
Okay.
Yes. Okay.
Okay, thank you, Judge.
Thank you. You guys are free to go. Have a great day.
Thanks, Judge.
I'm going to disable the chat. It's not for commentary. Ms. Howard, don't send me any direct messages. Everyone else, do not put any messages in the chat. It is not for your use at all.
Medical costs you $400 per month. You're requesting she pay you medical support of $200 per month.
Correct. Like $177 is for like the child support. The medical through my job is like $400 to Jameson. So even her half of it doesn't even cover the medical side of it. I just don't understand if Jameson's with me 100% of the time.
Ms. Jackson, when's the last time you worked?
It's been about 2 years. I'm a stay-at-home mom.
Not much I can do here. Obviously Ms. Jackson is unemployed. There aren't a lot of resources for me to set it at a higher amount.
Notice of change status. We do have a partial agreement, and I will read the agreed terms into the record. So the parties are in agreement that the child is living with Mr. Murphy, and they will be appointed as joint managing conservators with Mr. Murphy to designate the child's primary residence in Dallas and contiguous counties. Mr. Murphy has access to private insurance, medical and dental insurance through his employer, and he's agreed to enroll or keep the child enrolled in that insurance. We have calculated child support for Ms. Jackson based on minimum wage and giving her credit for 2 other minor children. And so she's agreed to pay child support of $177 per month beginning October 1st, 2023. Mr. Murphy was previously ordered to pay support. He does not have any child support arrears, however, and so we're requesting a child support judgment against Mr. Murphy of $0 as of September 12th, 2023. He does have a small medical support arrearage that we're requesting be confirmed of $145.95 as of September 12th, 2023, and he's agreed to pay that balance off fully by November 1st, 2023. We are requesting that Ms. Jackson pay the court costs as billed by Dallas County Parties agree that there's been no family violence in the last 2 years, and neither parent is requesting a non-disclosure. There is an agreement on a visitation schedule. I will read the agreed visitation schedule out. So the parties are in agreement that the mother, Ms. Jackson, will have unsupervised contact with the child, and she'll exercise her right to visitation on weekends, but she'll give 14 days notice in writing prior to picking up the child. The parents are going to agree on a designated exchange location, and Ms. Jackson's period of possession will be Friday at 6 p.m. Or she'll pick up the child from school, and then she will either bring the child back to father on Sunday at 6 p.m. or back to school on Monday morning. The parties also agree that Mr. Murphy will be allowed 2 times per year to decline mother's request to have the child on the weekends. He'll have to provide this denial in writing within 48 hours of her request. They've also come to an agreement on holiday schedule, including Ms. Jackson having possession of the child every spring break, and then as well as 45 days in the summer. She also must provide 14-day written notice to the father, including the address of where the child will be located during these times, and if she and the child will be out of state. If they'll be out of the country, she will get prior approval from the father, and Mr. Murphy will provide the child's passport. They've agreed to alternate possession of the child on holidays. So mom will have possession for Thanksgiving and odd years, and father will have possession on Thanksgiving and even years. Christmas will be the opposite of Thanksgiving break. And the parties are in agreement that the location services on the child's phone be turned on at all times during their periods of possession. And if the child's phone dies or is broken, the party in possession of the child will be responsible for having the phone repaired or recharged within a reasonable time frame. And the contested issues are the medical and dental support amounts. And so I'll take testimony on those issues. I will call the father, Mr. Murphy. Will you please state your name?
John Murphy.
And what's the child's name?
Jameson Murphy.
And how old is he?
7.
All right. And he is currently in your possession, is that correct?
Correct.
Did you hear those agreements I just read into the record?
Yes, ma'am.
And as to those specific terms, are you in agreement?
Yes, ma'am.
And you carry health and dental insurance for the child through your employer, correct?
Yes, ma'am. Well, not currently, because he was currently on medical support through his mom through like Medicaid or something I was paying for monthly. Once we conclude everything with Judge Aguilar or whatnot, then I'll get with my HR department with the paperwork necessary to get insurance to my job.
Okay. And the health insurance premium will cost you $400 per month. Is that correct?
Yes, ma'am. If I'm not mistaken, that's what I submitted to my lawyer. Yes, ma'am.
And is that coverage for you and your son or just for your son's portion?
Ms. Page, Jessica, I forgot how I had that listed out. I believe that's for Jameson's portion of it, I believe. I don't think that includes me whatsoever.
Okay. And then the dental portion will cost you $64 per month for to cover him. Is that correct?
Yes, ma'am.
Okay. And are you requesting that mom be ordered to pay you half of these premium costs?
Yes, ma'am. Yeah, just a reimbursement of 50% of it. Yes, ma'am.
Okay. And so, for example, the medical costs you $400 per month. You're requesting she pay you medical support of $200 per month.
Correct.
Okay. And you're requesting that her dental support be set at $32 per month.
Yes, ma'am.
And based on her income, we've calculated a different amount for medical and dental support. The state's calculated medical support of $37 per month and dental support of $6 per month. But you're still requesting that she pay half of the costs that you incur.
Yes, ma'am. I mean, yes, ma'am. Yeah, long story short, yes.
Okay. I'll pass the witness.
Ms. Page, any questions?
Mr. Murphy, can you give the court some explanation as to why you want Ms. Jackson to pay more than the minimum wage required support?
So from my understanding, what was just stated for Ms. Nutt, like $177 is for like the child support or whatnot that will come back. The medical through my job is like $400 to Jameson. So even her half of it doesn't even cover the medical side of it. So I just don't understand if Jameson's with me 100% of the time, you know, what's the understanding of that? I don't grasp it.
Okay, and how long has Jameson been living in your household?
At least the last 16 to 18 months or so, if I'm not mistaken.
Okay, and during those 16 or 18 months, have you been the primary financial provider for Jameson?
Absolutely, yes, ma'am.
And you covered all of his day-to-day needs, is that correct?
Yes, ma'am. Yes,
And
ma'am.
you've also covered any additional medical expenses for him, is that correct?
Yes, ma'am.
Okay, and so you're not asking that Ms. Jackson pay half of your entire premium, including you and Jameson, but only half of Jameson's premium, is that correct?
Yes, ma'am. And I think we had discussed that with her last time, if I'm not mistaken. Yes, ma'am. Absolutely.
And then lastly, you're not asking that she pay any of the additional medical expenses like co-pays or fees for glasses, only the premium, is that correct?
Absolutely. Yeah, everything else I'll get taken care of as I've been doing.
Okay, no further questions, Your Honor.
Okay.
The state will call the mother, Ms. Jackson. Will you please state your name?
Amanda Jackson.
And Ms. Jackson, did you hear those terms that I read out in the very beginning that you and Mr. Murphy agreed to?
Correct. Yes, I did.
And as to those specific terms, are you still in agreement?
Yes.
Okay. And we calculated support based on minimum wage, which would bring medical support to $37 per month and dental support to $6 per month. Are you in agreement with those amounts?
Yes, I am.
And you heard Mr. Murphy request that you be ordered to reimburse him half the cost of the dental and the medical portion for the child, correct?
Correct.
And is there any reason that you would not be able to pay half of those premium costs?
As of now, I'm unemployed. I've been looking for employment, but I'm not working right now.
Would that cost, if you had to pay that, would it be unreasonable?
It would be reasonable.
And are you a Dallas County resident?
I just relocated to Alabama.
I'll pass the witness.
All right, anything for Ms. Page, any questions?
Yeah, just a few, Your Honor. Ms. Jackson, you and I previously spoke about the medical premiums for your son, Jameson. Is that correct?
Correct.
And you previously agreed that you would pay half of the medical premiums for the child at $200. Is that correct?
At first, correct. At first, I definitely had questions as it's not feasible. But as I just stated, if I was to, go ahead and get employment, it would be feasible for me.
Okay. And tell me, Ms. Jackson, when's the last time you worked?
It's been about 2 years. I'm a stay-at-home mom.
Okay. And what did you do for employment at that time 2 years ago?
I was working for Colorado Department of Public Health. So customer service.
Okay. And what was your income at that time? Your monthly income?
Honestly, I don't remember. I don't remember.
Were you being paid hourly or salary?
It was hourly. So
Okay.
it was, I think I was making about maybe $16, $17 an hour.
Okay. And it's your testimony today that if you did gain employment again, then you would be able to pay the $200 a month for Jameson's premium.
Yes, that's fine.
All right. No further questions, Your Honor.
Okay. Anything further, Ms. Nutt?
Nothing further, Your Honor.
Anything further, Ms. Page?
Nothing further, Your Honor.
Okay, the parts that all are agreed to, those are all fine with me. Those are confirmed as the order of the court. Unfortunately, with the medical, that's a problem, obviously. It's not too fair here. There's not much that can be done because Ms. Jackson doesn't have an income. Because she's a stay-at-home mom, I'm gonna assess that that medical support should be a little higher than what the state assessed. I'm setting it at $100 a month instead of $37. And dental support, I'm gonna leave at $6 a month. There probably haven't been any costs before because Mr. Murphy hasn't carried insurance. Child's been on Medicaid, I guess, in whatever state the child's been in. And as far as the future payments, like as far as like copays and prescriptions, the state's court order they provide to me is 50-50. So y'all are to split those costs 50-50 if you choose to give that to the other party for them to pay. Not much I can do here. Obviously Ms. Jackson is unemployed. There's some argument, of course, that she's intentionally underemployed. So that's why I'm saying a little bit higher than what the state requested. But at the same time, there aren't a lot of resources for me to set it at a higher amount. So that means if the insurance is $400 a month, Mr. Murphy, that's going to be more on your table to pay for. You may look at other options, maybe the Affordable Care Act, to see if there's anything that may be cheaper. But definitely we need to get some insurance somewhere. And hopefully in the meantime, Ms. Jackson will find employment so that she can help share in some of the expenses of the medical care. With the unusual visitation order, I would like Ms. Page for you to receive a proposed order from the state before I sign off on it to make sure that it's all correct. It's a little bit unusual. I'm sure you're going to want to review that before. And so I'm not sure, were you working with Ms. Nutt before or with another attorney?
I was working with Ms. Phillip.
Ms. Phillip, okay. All right, y'all are done with court today and are excused. You can press leave on the Zoom to exit out. Thank you.
Thank you, Your Honor. Thank you.
I had borrowed money to at least put $100 on it just recently, but then ended up having to use it to put food in my home.
Mom can't pay her child support obligation.
Our next call, a matter of Nicole Finch versus David Finch, file number 15-15780DM. You have either party on that matter present.
I am.
In front of the court, what is the status of this matter?
The plaintiff has a support amount of $89 and a balance of $908.50. The last payment was received in November, August, and September in the amount of $100 each. The plaintiff requested friend of the court to contact her as a reminder to pay in November when she made a payment. The office left a message on December 26th, but no additional payments have been made. The friend of the court seeks guidance today on how to proceed.
Thank you. Miss Foster, is it?
Yes, sir.
What would you like to say regarding this matter, ma'am?
Here as of late, I had injury and then had surgery. I'm still recovering from, so I haven't been working as much. And then I had borrowed money to at least put $100 on it just recently, but then ended up having to use it to put food in my home. Just kind of going through the struggle right now. But I do plan on making a couple $100 payment within the next couple of weeks, at least.
Okay. It does look like you're behind then for December, January, and February is almost over, but not quite. So you think you could pay a couple $100 in the next 2 weeks? Is that correct?
Yes, sir.
Okay, what we'll do is adjourn your case to March 20th to monitor if that payment is made and where you are at with the upcoming and ongoing payments. Do you have any questions, ma'am?
No.
All right, we'll see you back here March 20th. Thank you.
All right, thank you.
I have been withheld from visitation. I have been contacting him trying to visit my daughter, and I have not been able to. he has not allowed me to see my daughter. I missed her birthday because I was not allowed to be there. I spent my entire last paycheck on all of her birthday gifts that I still have.
Mom has endangered the minor child multiple times, including a hit-and-run accident.
Your Honor, the state is requesting that the court take note that the party Taylor Lambert is before the court today. The parties agree for the custodial parent, the dad here in this matter, to be named as the sole managing conservator, and for the dad to reside with the child in Dallas and the surrounding counties. The state has used minimum wage for the calculation of support, giving no credit for no additional children. The state has calculated child support in the amount of $209 per month to begin on the 1st of next month, April 1st, 2024. The state is requesting that state medical be paid in the amount of $113 per month. There's been no request for retroactive support or dental support with court costs as billed. That appears to be the extent of the agreement. So at this time, Your Honor, the state would like to call the father here in this matter. Sir, can I get you to state your name for the record?
Hunter Stafford.
Sir, as it relates to family violence, has there been any issue relating to family violence between you and the other parties to this case?
Yes, Taylor has on multiple occasions hit me in front of my child, as well as just gone off the rails in front of her. So yes, there has been.
Has this taken place within the last 2 years?
This would have been in 2022 and or last time around June. So that's, yeah, so within the last 2 years, yes.
And just to confirm, you stated that these issues that you spoke of previously happened in front of the child, is that correct?
Yes, yeah, which is partially the reason why I've been keeping my child away from Taylor per CPS suggestion as well.
And is CPS currently involved in this matter?
CPS cases have been closed. Taylor has not had contact with my child essentially since the cases have been closed. So.
And was that a requirement of CPS or was that your choice, sir?
That was my choice based on the actions of Taylor. So.
And how old is the child here in this matter?
She's 3. She just turned 3.
And when was the last time the mother had any visitation with the child?
It's gotta be since maybe October, November, at least 6 months.
And as it relates to the visitation going forward, are you requesting that the mother has no visitation with the child?
Yes, on one stipulation is I would let her see my kid if she would take a hair follicle test, because I know that she's faked UAs before. So, and if she can pass a hair follicle test and not fail for heroin, I mean, then all right, we'll start talking about it. But until that day comes, I'd like to keep my child away from her.
All right. Would you be in agreement to the mother having visitation with the child if it's conducted via an outside agency to assist in the visitation, to monitor the visitation?
Yes, yeah. I mean, still with that stipulation, as long as she's not actively doing heroin, then yes.
And has the mother ever endangered the child here in this matter in any form or fashion?
Multiple times in multiple ways, yes.
And when was the last issue, sir?
The last issue, the last time that she she got in a car wreck with my child in the car when her and her boyfriend were messed up. So, and then they fled the scene of the car accident. So.
And you say that the parties were messed up. Could you explain to the court what do you mean by messed up, sir?
Intoxicated.
And are you requesting that your information such as your address and telephone number be withheld from the record?
Yes, please.
And is that request being made out of safety concerns?
Yes.
Do you have any additional information you'd like to offer to the court as it relates to this matter?
Other than what all the information I relayed in the first phone call is passed, yeah. And then the only other thing is that the last lady told me that Taylor said she didn't have a job, but she's been telling me for the past 2 months that she's got 2 of them. So I don't know how truthful that is on her end. So that's the only other thing I'd like to pass along.
About this?
Any way your turn?
Yes, I can.
All right, thank you. No further questions for this party, Your Honor. At this time, Your Honor, the state would like to call Ms. Lambert. Ms. Lambert, can I get you to state your name for the record?
Taylor Lambert.
Now, as it relates to the contested issue, which is the issue of family violence and the issue of visitation, has there been any issue relating to family violence between you and the other party to this case within the last 2 years?
Yes, there has. The issue being I was under the influence of alcohol. That was when she was less than a year old. And that's not excusing the behavior, that is inappropriate behavior, but it's something that I never hit him again after that. And I'm not sure why he is saying those things, because there was only one instance where I put my hands on him. I don't understand, but yes, there was that one instance, yes.
And did you hear what the other parties to this case previously testified that you had placed the child into some very dangerous situations? Are you in agreement with that information that he provided to the court previously?
Yes, I am, and those are also in the same time frame. The one about what he said about me being with my partner intoxicated in the car with my daughter, that is false. I was by myself and I was living with my sister. What I had tried to do was only tried to leave the driveway, and I drove into a ditch, and the police were called to the scene, and I was taken to Terrell State Hospital, and I was given a 72-hour hold. My daughter was put in danger, yes, but I did not drive any far. I didn't drive far with her. I didn't go far, and I was under a severe mental breakdown. That doesn't excuse the behavior, but I would like to at least have that be acknowledged.
And as it relates to the involvement in with CPS previously, the other parties provided that CPS was involved in this matter as it relates to the child. Is that correct?
Yes, sir.
Do you know what the findings based off of the investigation from CPS were?
That, I mean, as we could just continue as is. I mean, we would be able to make our own judgment calls. Like, he could be able to make his own judgment calls. I would be able to make my own judgment calls based on visitation rights and custody agreements.
And as it relates to the visitation, ma'am, when was the last time you had any visitation with the child?
I have been withheld from visitation. I have been contacting him trying to visit my daughter, and I have not been able to. He has not allowed me to see my daughter. I missed her birthday because I was not allowed to be there. I spent my entire last paycheck on all of her birthday gifts that I still have. I was not allowed to give any of her gifts to her. I was not allowed to see her for Christmas, even though I asked her. My parents had asked him if I would be able to see, if they would even be able to see my daughter, and he refused. Thanksgiving, same thing. Halloween, I mean, I was still, just freshly clean, and I understand that reasoning. But as far as me not trying to see my daughter, that is absolutely 110% false. I have been trying.
All right. And as it relates to the visitation, what type of visitation are you requesting moving forward with the child?
I want any visitation that is allowed. I am willing to work on his terms as long as I'm able to see my daughter. That is all I care about. I'm willing to take steps. I know it's not going to be a overnight process, but I would be willing to be supervised visitation. I'm not talking about any overnight visits for any length of time. I'm talking about just being able to meet up in a public place, even to be able to see my child.
And you spoke about the supervised visits. You would be in agreement to having supervised visits just to allow you some time to visit with the child. Is that correct?
Absolutely.
All right. And you reside in Dallas. Is that correct?
Yes.
And would you be in agreement to supervised visits to take place at at the family place to allow for supervised visits?
Absolutely. And I was also wondering if there would be any kind of counseling and mediation that we could be doing.
And do you understand that the other party has requested that information such as its address and telephone number be withheld from the record? Are you in agreement to that request?
Sure, yes.
Do you have any additional information you'd like to offer to the court as it relates to this case?
I do want to add that I have been requested by him to seek out psychiatry and mediation and family therapy for our situation, mediation, if you will. I gave him that information, and he was he told me that he would call and make the appointment. However, that never happened, and he asked me to do so. But I actually was working. I was working, and I have proof of that, and I am more than willing to provide proof of that. However, it was placed back on me to be able to make the appointments, and at that moment in time, I was working 40 hours a week, sometimes more. So I was unable to take time out of my day for that. But that's really all I want to add.
All right, and you stated that you was working. What is your current status of your employment? Are you currently employed?
No, I'm currently unemployed.
And when did your employment end, ma'am?
My employment ended sometime last month.
And are you currently looking for work?
Absolutely.
Do you understand that the state has a agency that can assist you in finding employment? Would you like to be placed into that to assist you with looking for work?
Absolutely.
Do you have any additional information you'd like to offer at this time?
No, thank you.
No further questions for this party, Your Honor.
All right, the parts all agreed to at the beginning of the hearing, those are all fine with me. Those we made the order of the court. If there's been family violence, whether it's one time or multiple times, it's family violence. So that's the way it is. I'm gonna make a finding, there's been family violence. I'm granting Mr. Stafford's request for non-disclosure. He's not required to let you know where he lives. I am asking that both y'all are ordered to add an app on your phone called AppClose, AppClose, and that way y'all can communicate on that app. That will be very important, especially since we're doing a non-disclosure. Of course, anything that's on the app that you text over is recorded and can be used against you in court in the future. So make sure that you are keeping yourself with being having a good conversation instead of something negative. Hang on just a second. Okay. All right. As far as what I have to do today, I have to make a decision based on the best interest of this child. And obviously, Ms. Lambert, if you have drug and alcohol issues, that makes me give pause to why I should do visitation on a regular way or things like that. Unfortunately, you have some issues. Maybe you have some mental health issues too. I don't know. But I can't give you regular visitation. I can't even trust that you can be alone with the child at this point until you handle your issues. So I'm gonna do a visitation to be supervised by the Faith and Liberty Place on the second Saturdays of each month from 12 to 2 p.m. for 2 hours. And that will only begin after you provide Mr. Stafford a copy of a hair follicle test. I'll let you go and do a test, and then you need to provide it to him. I think you can provide it to him on AppClose, or you can text it to him or something like that once you get a result. But if you're not clean, there's no reason for you to do visitation. So you'll have to make a choice of whether what's more important, your drug or alcohol or your child. And I think that's what Mr. Stafford's saying as well. He wants you to make a choice. And until you make that choice, there's nothing else that we can really do at this point because you're not safe around the child. You have to be able to supervise. I'm talking. You have to be able to supervise your child. You cannot do that while you're intoxicated or high. A 3-year-old can move pretty fast. And so even if you're not using anything, it's pretty hard to keep up with a 3-year-old. And so you have to understand that you need to take care of your own personal issues. If you need mental health help, you don't have to wait on Mr. Stafford to do that. You can do that on your own. And you may need to do that. It's up to you. But we can't help you with that. So there's some things that you have to fix for yourself before you can take care of somebody else. I'm ordering you into the Choices program, which is a program to help you look for work. I need you to hang around here for a minute after court hearing to talk to the choice representative so they can give you information to enroll you in that program and help you to look for work. After you're done with that, you don't have to come back to see me. Yes, Mr. Tatum?
Yes, Your Honor. I just wanted to confirm, you stated that the visits are to take place on what Saturdays?
Second Saturdays.
On the second. Thank you, Your Honor.
All right. That's the order I've made. I understand y'all may not agree with it, but the Attorney General's office put that in writing for me to sign and email y'all a copy if they have your email addresses. Ms. Lambert, hang around, like I said, for a minute to speak with the choice representative. And Mr. Stafford, you can press leave to leave for the day. Thank you.
In the beginning, I was letting her mother the grandmother have supervised visits. She showed up to my house drinking, right? Her grandmother's got a rap sheet longer than mine, okay? And I got a rap sheet, sir, okay?
If anybody's drunk or high, including the grandmother or Ms. Briggs or Ms. Chapman, Visitation doesn't happen.
I called the police. They said their hands are tied. I'm gonna have to take him to court. So that's what I did. He left. I had no clue where my child is.
I think there's some disagreement as to where exactly the child lives. I think we just kind of need a determination on who is primary, and then I think we can actually send this back for some more negotiation.
Okay, where does the child live, Ms. Wilson?
He is supposed to be living with me. Since I filed for child support and a custody arrangement, because there's been too many like disagreements between me and his father, he withdrew him from school and has kept him since this case has been pending. He's 5 years old and he did not enroll him in any other school. So now he's gonna have to repeat the grade level.
Okay, so the child is living with you, Ms. Wilson?
He's currently at his.
Ma'am, I need a yes or no. Is the child living with you?
He is not here currently, no.
Okay, how long has he not been living with you?
Since I wanna say January, December.
December or January, okay.
Yeah. And he was
and what did you do to get your child? What did you try to do to get your child back?
I called the police. They said their hands are tied. I'm gonna have to take him to court. So that's what I did.
Okay, so you took him to court. When did you take him to court?
Right now, I filed
Okay,
to.
so you didn't do anything since December or January? You called the police. The police told you
I
that
did not know where he was. He left. I had no clue where my child is.
the police told you it was a civil matter and y'all need to go to court, right?
Yes, so I was trying to get an attorney and I reached out to legal aid and then I filed for child support and
So what did legal aid do when you talked to them?
they kind of messed up my paperwork because I did not know where his address was, so they could not serve him. I recently found out where his address is. So now that he's been served, they finally said that they don't know if they can represent me until the end of the week because they've been messing my paper, basically.
Okay. All right, Mr. Navarro, how did you come into possession of the child?
About December, it was December 19th, the day of my son's birthday. I made the decision of just taking my son and moving out of my
Why did
parents'
you
house.
make that decision to just take your son, Mr. Navarro?
Just because of a number of things that had already been piling up. But the final
Number of
straw
what
was,
things? What things?
well, the final straw was she had just gone to jail for assault or attempted assault with a knife on her boyfriend or her mother's boyfriend. And she did that while my son was present and her other son as well, her newborn. And then,
So did she go to jail?
yes, she did. And she
So
went
then-
back as soon as she got back out for another altercation that I guess went on.
So you rescued the child. That's how you came into possession of the child.
Yes, sir. And it's also a number of things if you are okay with me listing all of that.
I'm listening to you, sir.
Well, since we had our she was around his first few months of life, but then we ended up splitting up. And right after that, she just was in and out. She was dumping him on me on days I was supposed to have him so she could go out. And then it slowly found its way to, she just left. I guess she had stuff going on with her family. She was the main cause of a lot of the problems that she was having within her household. So I guess her mom gave her the option.
Let me say this, Mr. Navarro. I have problems with people who blame everything on the other person. Everybody is at fault. So she couldn't have done everything.
At that point, it pretty much was just that, just her not wanting to be around and her problems that she had within her family. And she ended up leaving to Kansas. There was I don't believe that I did anything to make that happen at all.
So the child's been with you since January.
Yes, sir.
All right, I'm going to leave the child with Mr. Navarro. Now you can send them back to work out anything else they want to do.
Okay, thank you.
May I speak?
Sure.
I have not abandoned my child. I have always been in my child's life.
No one said you abandoned your child, Ms. Wilson. The problem is that the child has been with him for 6 months. Because the child, the family code says if the child has been with him for 6 months, then you are going to have, I'm gonna have to leave the child with him. Then y'all can go to the district court and work out whatever conservatorship things you need to do, but both of you are gonna have to have attorneys for that.
Okay, and can I request for a temporary order?
Sure, I'm sure that's what they're gonna do anyway when they go back and talk to you guys.
Okay, thank you.
Okay. Okay, you can put them back in the breakout room. Okay, you may continue.
So Mr. Navarro, do you believe that there's a risk that Miss Wilson might harass you or somebody who lives with you, that there might be some danger if she has access to your address and contact information?
Yes.
Why do you believe that?
There was an incident with my mother. She fist fought, kicked and scratched and bit her a few years ago. And she's also harassed my mother since I've had Ezekiel through phone calls, going to her house. And she's also harassed my wife through messaging. And they've also had a couple of altercations.
Okay. And so I guess you said there's been an incident with your wife and your wife lives with you, I assume?
Yes. And
does your mother live with you?
no.
Okay. So what exactly happened when you say there was an altercation between her and your wife?
We're just 2 years of just back and forth, and it turned into her coming at my wife about fighting, and them just having, and then my wife blocked her, and she's made a fake account, and since then she's been lurking on her social media pages, and that's about all of that.
Okay. I apologize. There's someone in my house right now. If I could just close the door to reduce the noise a little bit. Okay, sorry about that.
Yes. She's also had other altercations with her mother that led her to be arrested, and an altercation with her other son's father that also got her arrested.
And do you have any sort of reason to believe that she might try to show up at your house uninvited if she knows where you live?
Yes.
Has she ever done that before?
Yeah, when I was living with my mother, yes.
Are you asking that she have a non-expanded standard possession order?
Yes, just the regular standard.
Okay. And why is it that you don't want her to have the expanded?
I just would rather, it's just really just preference.
Okay. Do you understand that with the normal extended possession order that that you and her wouldn't have to interact as much, that if
yeah.
Most days she'd pick her up from school?
I would just rather be the one to pick him up and drop him off to school, just to kind of keep that standard and routine for him.
State has calculated a proposed child support amount of $294 per month with medical support at $96 per month. Would you be in agreement with those amounts?
Yes.
Okay. Are you in agreement? Do you have any insurance available through your employment?
No.
Are you in agreement to an order which provides that you would apply for government health insurance?
Yes, definitely.
Okay. And I don't know if the judge is going to end up doing a temporary or a final order today, but if the judge does do a final order, would you be in agreement with our the state's calculation of retroactive child support at $11,760, which accounts for that's basically the last 4 years minus 12 months where y'all had a 50-50 possession schedule?
Yes.
Then would you be in agreement to have that amount paid off at $109 per month?
Yes.
Okay. Is there anything else you want to bring to the court's attention?
I would really much prefer it to be a final court date right now, just because of so many things that have already happened, and I feel like for us to just make it temporary, it just costs us a lot of money to probably most likely be the same result of me maintaining custody. She's tried to commit suicide on multiple occasions of Ezekiel's life. The assault has always been a big thing. That's why I made the decision of taking my son away from that lifestyle, just because all these things were going on in front of him since he was 2 years old. I had to go pick him up because her and her mom just got into it. There's broken glass all over around my toddler. He's in right next to it, and I just didn't want my son to have to grow up in such a toxic household. And and then it's just been a number of things. We haven't been able to at all come to any sorts of agreements, not even all the way down to tax money. For the first couple of years of my son's life, her mother was claiming him without letting us know anything. And then while Ashante was gone in Kansas, she left for, I think it was a little over 6 months. And when she did return, we didn't even know. And I can have my mom back that up. And when she did come back around, she slowly made her way into Ezekiel's life again. And I understand that she had a lot going on, but it is a lot of bridges that she burned herself. And I know that with everything that I've had going on in my life, I've never once left my son. He's been with me since the day he was born. It's 5 years, almost 6 now.
And I think there's one agreement that the two of y'all reached, and that's to have communications about your child take place on app close. Is that correct?
On what did you say? Sorry.
App close. It's a co-parenting app that
Oh, I guess they told her that. I haven't heard anything of that.
Okay. Well, I mean, so I guess if you're asking that your contact information be left out, would you also be asking? I guess that's kind of an alternate way that you would have of being able to communicate with Miss Wilson.
Mm-hmm. Well, if this were to be a final hearing, I'd be fine disclosing my information to her and just contacting through cell phone. But if it is going to be a temporary, I'd rather do that and have the non-disclosure.
Okay. I'll pass the witness.
All right.
Say we call the mother, Miss Wilson.
Yes.
Miss Wilson, do you believe that you and the father can work together to make decisions regarding the child?
I don't know. I've been co-parenting basically with his mother the past 5 years. Ever since he's turned 18, it's been a terrible experience since me and him have communicated on our own. He's very aggressive. He's constantly calling me out my name, cussing me out. Like the reason why he took him recently is because I was out with COVID and over a backpack that I forgot to drop off to him that I said I would bring to his school. That's what this is all about, over a backpack. The incident he's speaking of, I called the police because somebody put their hands on me, and this is in October. This has nothing to do with recently.
And that was kind of going to be my next series of questions. So has there been family violence between you and Mr. Navarro?
There has. And then his mother put his hands on me. There's a police statement with him as a witness telling the police that she hit me first when I was
specifically what I'm asking is if he's ever tried to harm you, and we can talk about those other issues here in a second, but I just want.
Yes, he's tried to put me in front of the car on the sidewalk. He's choked me, he slammed me. He's never actually like slapped me or punched me, but it's just like little stuff like that. I don't know if you consider that little, but stuff like that. And it was like, wasn't all the time because we were young. We were in his parents' house. So obviously we can't just be wilding out in there. But yeah, there has been, but that hasn't been in the past 4 years. That was the first year of my son's life.
Based on that, are you also asking that your address be kept out of the court's out of the court record and that you not have to provide your address to him?
Yes, and also with the altercation with his girlfriend, she attacked me twice, and the second time was in front of an officer. So y'all can pull up those records if y'all need to.
Are you currently employed making about $100 a day, 5 days a week?
Yes.
State calculated guideline child support at $294 per month and medical support at $96. Would you be in agreement with that?
No, I want to have my son solely, or either we can share him half and half. I don't want to do that. I feel like it should be a fair agreement.
I guess, was there a time in the past that the two of you shared 50-50?
Yes, the first 3 years, the last 3 years, I've had him majority of the time just for the fact that he was in school and he was still underage, which is understandable. When we were both still in school, I had him 1 week and then he had him 1 week.
Okay. And state calculated retroactive child support, taking off 12 months out of the last 4 years at $11,760. Would you be in agreement with that amount?
No.
And why is that?
Because I have always supported my child. I have been working because my family owned a business around that time. I have been working since I've been 12 years old. I've solely supported my child since day one. He hasn't even had a job since then. I can't blame him because at the end of the day, we were underage when we had our child, but I have always supported my child. So no, I'm not in agreement of that.
All right.
Also, I wanted, if this is a temporary order for now, I do want the expanded custody for now until we have a next hearing for the actual permanent order.
Is there anything else you want to bring to the court's attention?
Yes. The only reason he's been over there for 6 months is because I seen them in Oklahoma. He took him out of state without my permission. Also, it's been a long process for y'all to process this case. So that also racked up months on there as well. I did not wait 6 months to act on to get my child back. I took immediate action. I called the police. I've been trying to find where he lives. I already know where he lives. Like I didn't even go out of I've seen my child over there. I watch him from a distance because there's domestic abuse in his household where he's beating his girlfriend. I don't know if he's doing it while my child is there or not, but I don't want that around my child either. He has a history of abuse. So does his parents while I was present. I've also had to help his mom pick up glass the next day from his father beating her. So his life is not perfect. I don't know why they try to make it seem like that, but.
I'll pass the witness.
All right, thank you. I need both of you. I need you to unmute yourself, Mr. Navarro, because I need both of you. Okay, I'm entering a temporary order. I am finding that I'm granting the non-disclosure. You don't have to give your addresses, but I am going to order that Ms. Wilson pay child support in the amount of $294 a month beginning on September the 1st, and that she pay cash medical of $96 a month beginning September the 1st. I am not going to rule on the retroactive child support. I'll leave that for the district court. I am going to grant the visitation standard. But both of you need to do, you can do this 3-day and get a new hearing. You can appeal, but you can do it within the next 3 days, and you'll get a trial de novo, and that court will tell you, will make a decision that is independent of the decision that I'm making today. This is out of the 256th court. You have 3 days to appeal to that court. Now, having said that, let me say this. Both of you, if you're going to contest custody, need to hire attorneys so that they can put forth your claim or what you think should happen. And both of you seem to have had a lot of underlying issues. So you're probably going to need somebody who's going to be able to tell your story a lot more clearly than the two of you have told it so far. Now, Mr. Wright is going to email you a copy of this order. It's going to find that Mr. Navarro is going to be the primary caregiver of the child. Both of you are going to share that information, share that jointly. This is going to be joint managing conservatorship. I'm going to grant the non-disclosure. I'm going to order the child support and the cash medical support. But both of you need to appeal if you want to get custody of the child, okay?
I do have one more question.
Yes, ma'am.
To appeal, do I need to go down to the courthouse and do that, or do I do it online?
I'm not sure about the online, but I'm pretty sure you could do it without going down to the courthouse. Mr. Wright, would you make sure that they get a copy of the information on how to appeal?
I'm not sure we have like an official publication on that, but I can just make sure that that's included with
All right,
with this
send it to both of them. Send it to both of them.
And real quick, Your Honor, if I can say, there is no domestic violence going on within my household. Within my parents, that wasn't ongoing.
Sir, that's the reason why this is a temporary order. You get to tell your whole story. You get
Yes,
to tell
sir.
it the way you want to tell it. Okay?
Also, so on you said the standard, so that's not expanded.
No,
So
that's not expanded. That
I
is
don't-
regular child support from 6 o'clock on Friday till 6 o'clock on Sunday.
Okay, and I get him on Thursday from 6 to 8.
That's correct.
So are you putting this in order today in order for me to go pick him up today?
I don't know. Mr. Wright, are you going to be able to get this order out today?
I don't know if it'll be today, but yeah, it'll be soon. So I mean, if we need it today, I can try to get it today.
Okay,
Okay.
can y'all, I mean, is it okay for me to come pick him up from the Chick-fil-A today? From
Not
him?
unless you have the order. I want you to have the order, so in the event something goes wrong, you can show the police that you have the right to have possession of the child.
Okay, so I'll meet you there at 6 if we do receive the order today in time.
Right. I'm sure it's an email, so it shouldn't take but a few clicks for him to be able to get that to you. Okay. What all right. If you guys don't have anything else, you can press leave and you're free to go.
I was unable to pay him child support for a child that I was caring for. I was the one taking care of his daily stuff on top of having to pay a man child support that he's not staying with. You ain't getting shit.
Mom uses inappropriate language in court.
Your Honor, at this time, Your Honor, the state would like to call the father here in this matter. Sir, can I get you to state your name for the record?
Luis Mendoza Jr.
And Mr. Mendoza, the 3 children that are here in this matter are all emancipated, is that correct?
Yes, they've all hit 18.
All right. The state would like to offer into evidence what will be marked as State's Exhibit 1, which is a copy of the financial report in this matter. Your Honor, this state would like to share the screen at this time.
Yes.
And Mr. Mendoza, can you see the screen at this time?
I can see it.
You need to zoom out, zoom in. So.
I'm zooming in right now. I can see it.
And do you see that this is the pay record associated with this matter?
Yes, it's a lot of numbers to.
I'm scrolling down to the bottom of the pay record. And are you able to see the amounts that are currently owed in this matter?
Yes.
All right. Your Honor, the state would like to offer into evidence what would be marked as State's Exhibit 1, which is the pay record in this matter.
So noted.
Thank you, Your Honor. As it relates to the child support that is owed here in this matter, the state has calculated that the mother owes a total of $2,367.20. And that is as of March 31st, 2024. Are you in agreement to that amount, sir?
Yes.
And the state has also calculated that the mother currently owes a amount of $849.32 as of March 31st, 2024, as it relates to the medical support, and requesting that the mother pays that back at $50 per month. Are you in agreement to that amount?
Yes.
And Your Honor, may I stop sharing my screen at this time?
Yes.
All right, thank you.
I'm sorry, was that exhibit admitted?
I didn't. You want me to admit it?
Yes, Your Honor, we admit this as State's Exhibit 1.
All right, State's Exhibit 1 is admitted.
Thank you, Your Honor. And as it relates to the current child support, I'm sorry, the arrears in this matter as it relates to the child support, has the mother made any direct payments to you for the support of the children?
No, sir.
All right. And as it relates to the, sorry, give me just 1 second here. As the prior order, there was a prior order in which the parties both requested or were granted a non-disclosure. Are you in agreement to that continuing into this matter?
Yes.
Do you understand that the state is requesting that the mother pays the court costs associated with this matter today?
Yes.
All right. Do you have any additional information you'd like to offer to the court as it relates to this case?
No extra information. Well, you know what? She did. My son did run away when he was in the summer of before he turned 18, and then he went to go live with his brother. So that would that's what he did, and so he's lived with his brother for I'd say about 7-8 months. I can't remember the exact time. It's been a long time.
It's been a year.
And did you agree during that time frame for the child to live with someone else?
Yeah,
No.
to live with his brother.
No.
Ms. Hagwood, no one's asking you a question right now.
And just to confirm, sir, about how long did the child live with the other sibling?
It's about 7 or 8 months, I believe. I am kind of off. Like I said, it's been a very long time.
However, during that time frame, there was no change as it relates to the child support. Is that correct?
No, there was no changes or no court orders made.
All right. No further question for this party, Your Honor. At this time, Your Honor, the state would like to call the mother in this matter. Ma'am, can I get you to state your name for the record?
Sherry Ann Baldwin.
And Miss, I'm sorry, is your last name also Hagwood?
That's my maiden name, and it's Haygood.
Hey, good. Okay, thank you, ma'am. As it relates to the child support judgment, the state has calculated that you owe a total of $2,367.20 as of March 31st, 2024. I'm requesting that you pay that back at $150 per month. Are you in agreement to that amount, ma'am?
No, sir.
Explain to the court why you're not in agreement to the amount that you owe.
Well, I got a phone call February 1st of 2022 from my oldest son, who is, Lewis isn't the father, Dylan Haygood. And he told me that my son Lewis is there. He's been thrown out. And he doesn't know what to do. So I start helping. Lewis comes over here and he's staying with me for a few weeks. He's staying with his brother. And then finally he moves in with me April 1st of 22. And he's been away from his father ever since. Me and his brother's been caring for him, his eyeglasses, his doctor's appointments, getting him to court. I have documentation from the court stating that he was with me and his brother, probation officers that are willing to whatever y'all need them to write up. But I was unable to pay him child support for a child that I was caring for.
And during that time, thank
That's
you,
the
ma'am.
state.
Thank you, ma'am. And during that time frame, when the child started to reside with you, did you petition the court to change the child support to reflect
Yes,
that
sir.
the child was living with you?
Yes, sir. I called y'all immediately and I emailed the court paper that I had stating that he was living with his brother. And then I went and got the lady told me to do this.
Ms. Haygood?
The whatever child support officer I spoke with told me to go file this with the courts. And it's my name is Sherry Ann Baldwin. I am the mother and the child of Luis Mendoza. He has resided with me since April 1st, 2022, and is currently residing in Johnson County. And it's signed and dated.
Again,
And
Ms.
then,
Haygood, Ms.
pardon
Haygood,
me.
the question that was asked is, did you petition the court to change the child support amount? Now, did you file a paperwork stating that the child was living with you? My question was, did you petition the court to request that the child support be changed to reflect that the child was residing with you?
Yes, sir, I did.
What's their case number, ma'am?
Well, I called y'all and told you that he was living with me and not the father. She told me to send in the paperwork that I had, so I did. And then she said she had 190 days to contact the father and that y'all would get a hold of me. And then she said that they froze the funds. And so I don't know.
All right, and as it relates to the medical support, ma'am, the state has calculated that you owe a total of $849.32 as of March 31st, 2024, and requesting that you pay that back at $50 per month. Are you in agreement to that amount, ma'am?
No, sir.
And could you explain to the court why you're not in agreement to paying that amount?
Because I feel like I was the one caring for his needs. I was the one taking care of his daily stuff on top of having to pay a man child support that he's not staying with. I don't have extra money like that. I can't be taking him to the eye doctor and to appointments and feeding him and clothing him and paying him his father child support.
And just to confirm, ma'am, when you say that you're paying the father child support for a child that's residing with you, when exactly did you pay those amounts to the father?
I have documentation of every child support payment I ever made, and I have documentation of it.
And ma'am, were you able to review the
Pardon?
Were you able to review the report that was provided on the screen as it relates to
I
the
couldn't
child
really
support payment?
see. I couldn't really see. But
And
I
would you like
stopped
me to
paying
show that
after April
April of what year, ma'am?
22. I stopped paying, and that's when I went and got the documentation that he was living with me full time.
All right. And as it relates to the sorry, just one second. The non-disclosure, there was a prior non-disclosure in the prior order. Are you requesting that the non-disclosure continue into this matter?
Yes.
And do you understand that the state is requesting that you pay the court costs associated with this matter today?
Yes, sir.
Nothing further from this party.
All right, we have to understand one thing. The Attorney General's office is not the court. You can ask the AG's office to do a lot of stuff, You can ask them questions. You can ask them to file something for you that might help you, but they're not the court. If you don't file anything with the court, then it's almost like nothing ever happened because the AG has discretion to do what they like, which means they could file something or they could not file something. They didn't file anything. Separately, what you're supposed to do is file something with the court, and nothing was ever filed with the court. I don't work for the AG's office. The judges in the courthouse don't work for the AG's office. So you can tell me all day long that you talk to the AG's office, but that's not the court. So I can't modify your order. You were responsible to modify your own order if the AG didn't want to help you, or if you wanted to do it on your own. It's very simple to do, and that hasn't happened. So you owe these arrears. It's a very small amount. You owe the full amounts that are owed. You decided not to make payments. So you owe $2,367.20, payable at $150 a month, and medical support arrears of $849.32, payable at $50 a month. If there's money on hold, then they will try to forward that towards those amounts. And then if there's any remaining balance, then those are the monthly payments until those two amounts get paid off. If you want to pay it all off, you can. That'll end your case. Then the child support office can close their case. Since the children are emancipated, there's really nothing else for them to collect. But I can't do anything else besides that. Court cost is billed to Ms. Haygood. The Attorney General's office will put all that into a court order for me to sign and email you all a copy. And they'll, if there's money on hold, it may take a couple weeks for that to process after they enter the order. All right, y'all are done with court. You can press leave on the Zoom to exit out. Thank you.
All right, thank you, Judge.
You ain't getting shit. You
Hey,
ain't
good.
getting
You want me to find you in contempt of court? Ms. Haygood, I can fine you $50 for contempt of court for cussing in my court. So please, don't act like a child. We don't need
I
to.
thought I was off. I thought I hit the button. I'm sorry.
Okay, be respectful. All right, y'all can press leave to exit out, please.
So they started living with me. This was a couple of months before she moved to Hawaii. That's when they moved with me. Then I had them in school for a year.
And anytime between December 2019 and July 2021, did you contact the courts or the OAG to inform either that the children were residing with you?
I did not. Probably the biggest mistake of my life.
The Attorney General's office states that you overpaid child support by $13,476.88. And after your son graduated high school, did you continue to receive those child support payments?
I did.
Have you returned any of the excess money since your son graduated high school to Mr. Guy?
No, I have not, sir.
What are the reasons why you didn't return the money?
Emotional, physical needs. I mean, he was never there for my child. It's more to take raising a child than finance.
So is it a hardship for you to repay the $13,000?
It's not, sir, but why should I be obligated to pay something that I feel like I didn't take?
All right, you're both officially under oath. I'm gonna go ahead and let Mr. Starr call you both as witnesses. The state will have the opportunity to cross-examine. And again, at the end of the hearing, ma'am, if you have anything else you think I need to know that didn't come out during your general testimony because you're a pro se litigant, I will allow you to testify to it in a narrative form, so long as it's relevant. So at this time, Mr. Starr, you can call your first witness, please. Thank you.
I'd like to call my client, Mr. Guy, please.
Yes, sir.
Okay,
All right,
Mr.
Mr.
Guy.
Guy, state your full name for the record, sir.
Stanley Allen Guy.
All right, you may proceed.
All right, and Mr. Guy, will you state your son's name in this case?
LeZabrion DeJour Williams.
Okay, and did he turn 18 years of age on December 13th, 2020?
Yes, he did.
And did he graduate high school in May of 2021?
Yes, sir.
And to your knowledge, since your son graduated high school, have you continued to have your wages garnished for the purposes of child support?
Yes.
Okay, and was the last child support payment you made, did that occur in September of 2022?
Yes.
Okay. Now, do you remember uploading to our case management software a document called a financial activity report that you received from the Attorney General's office?
Yes, sir.
All right, to your knowledge, did you alter that document in any way?
Not at all, sir.
Okay. Your Honor, I'd like to submit that document into evidence. I emailed it to you and I believe the Attorney General, but they should have it as well.
You emailed it to Belinda?
Yes, I did.
All right.
State has no objection, Your Honor.
Okay, I must have left it on the bench. Can you go grab it for me, please? Yeah, I'm sorry, I had to move off of the bench and move over here, so.
There's
Oh,
also
here it is. It was underneath. me, so
okay,
I
there's
got it.
also the
Never mind.
state disbursement record. We're going to just enter that into the evidence as well. It
All
should
right, I've
just
got it here.
confirm.
Just a
Okay.
second here. All right, here we go. And so I'm remarking this as respondent fathers number 1. All right, folks, I know you can't see it very well, but this is the respondent fathers number 1. It is the accounting of the child support that was paid to the state disbursement unit in this case. Is there any reason this should not come into evidence at this time, Mr. Diamond?
No, Your Honor.
All right, Ms. Williams, there a legal reason this shouldn't come into evidence, ma'am?
No, Your Honor.
All right, respondent fathers 1 is admitted. You may proceed.
All right, Mr. Guy, did you see at the end of that document, the Attorney General's office states that you overpaid child support by $13,476.88?
Yes, sir.
Does that amount seem accurate to you?
Yes, sir.
Okay. Do you also remember submitting to our office a document titled Texas Child Support Disbursement Unit Payment Record?
Yes, sir.
Okay, and to your knowledge and belief, was that document altered in any way?
Not at all, sir.
And do you believe the information on that document is correct as well?
Yes, sir.
All right, I'd like to submit that as Petitioner's Exhibit 2, Your Honor.
All right, I'm marking this as respondent fathers, RF2.
All right, Mr.
All right,
Go ahead.
any objection to RF2 coming in evidence at this time, Mr. Diamond?
No, Your Honor.
All right, Ms. Williams, is there a legal reason that this information should not come before the court this time?
No, sir.
All right, RF2 is admitted. You may proceed, Mr. Starr.
Okay. Since your son graduated high school, Mr. Guy, has Ms. Williams paid you back any of the overage amount of child support?
No, sir.
Okay, would you like the court to award you a judgment, $13,476.88, to make up for the excess amount of child support that has been garnished from your check?
Yes, sir.
All right, and would you like the court to award you attorney's fees since you had to hire me to get this money back?
Yes, sir.
Is there anything else you think the court should hear today, Mr. Guy?
No, sir.
I have no further questions with this witness.
All right, Mr. Diamond.
No questions, Your Honor.
All right, at this time, Ms. Williams, technically you're your own lawyer. I always have pro se litigants, if they have questions, they have to run them through me because I want to make sure that they're relevant. So at this time, ma'am, as your own legal representative, do you have any questions, Mr. Guy?
No, I don't have any questions, sir, but I do have a statement.
All right, well, that's at the very end, ma'am. Thank you.
Okay.
All right, so Mr. Starr, you can call your next witness, please.
All right, I'll call Ms. Williams, please.
All right, Ms. Williams, state your full name for the record.
Bertina Levette Williams.
All right, thank you, Ms. Williams.
Starr.
Okay. How old is your son now, Ms. Williams?
He's 20 years old.
All right, and when did he turn 18?
He turned 18 and I think it was 2020 of December 13th.
Okay, and did he graduate high school of May of 2021?
Yes, he did.
Okay, now from September 17th, or excuse me, from September 7th, 2011 to September 27th, 2022, did you receive child support payments for your son?
I did, sir.
Okay, and after your son graduated high school, did you continue to receive those child support payments?
I did.
All right, have you returned any of the excess money since your son graduated high school to Mr. Guy?
No, I have not, sir.
No further questions, Your Honor.
All right, Mr. Diamond.
Yeah, what are the reasons why you didn't return the money, Ms. Williams?
The reason I didn't return them, sir, in December of 2020, I was notified by the Texas Child Support, and they told me that my case was no longer a court-ordered case. And they also told me that my son's father was always also notified. So how did I know he wasn't doing that on his own to rectify or compensate for what he wasn't doing for my child?
I'm sorry. So the point you're trying to make is that his contribution to your son growing up was insufficient, and this was maybe a way of trying to make things right?
Absolutely, sir. Child support only started in 2011. From 2011 before, I was doing that on my own. He chose when to take care of my child.
So it sounds like it's an equitable argument that child support didn't go back far enough when it was initiated?
It did not. We have 9 years where I did this solely on my own. I mean,
Objection, non-responsive. This is
All right.
narrative.
All right, here's the deal, ma'am. Yeah, that's not gonna fly. Again, this is kind of straightforward. Is there any other reason, I'm sorry, I can't go behind the order of 2011, ma'am. So is there any other reason that you're alleging that happened after 2011 that you should be granted some type of credit for as far as the overpayment is concerned, ma'am?
absolutely, sir.
All right, what's the reason, ma'am?
Emotional, physical needs. I mean, he was never there for my child. It's more to take raising a child than finances.
Yes, ma'am.
I mean, the medical bills, the dental, and all of these things.
Okay, ma'am.
May I ask the witness a few more questions, Your Honor?
Go right ahead.
Are you in good health currently, Miss Williams?
I am, sir.
And do you have other family members who have health issues?
I do, sir.
Are they close family members?
Sir, I do. We just lost an auntie just Saturday. Yes,
So I take it you help pay for some of the funeral costs?
I do. I have custody of my nephew as well. I lost my sister. I'm raising him as well.
How old's your nephew?
He's 11.
Okay, here's what I'm getting at. You would have to show that it's a hardship for you to repay this $13,000. So is it a hardship for you to repay the $13,000?
It's not, sir, but why should I be obligated to pay something that I feel like I didn't take?
Okay, here's the deal, ma'am. That you feel is not going to meet the legal standards for me to not order this, ma'am. Again, I've got to have some reason at law. I know you're not a lawyer, but you didn't retain counsel. I gave you the opportunity to do so, and I've got to hold you to the same standard. And right now, I'm not hearing anything that's going to get you to a legal standard of giving some type of forgiveness. I'm gonna let the states continue to ask questions, but again, you can't. I've known people for years who they don't do it. They don't have a darn thing to do with their kids. All they do is pay the child support. And I've been saying for years, the only thing I can order is child support. I can order it based on what the law says I'm supposed to do, but I can't make somebody be a parent. That's not within my purview. So unless there's a legal reason, ma'am, that the money, and again, I know you're not a lawyer, but I got to hold you to that standard. Unless there's a legal reason for me not to order it, ma'am, then I'm probably having to look at orders. So is there a legal reason that you know of, ma'am?
It's not, sir.
Okay. All right, you may proceed, Mr. Diamond.
I don't know if there's much more I can add at this point, Your Honor.
All right, then.
A pass witness, sir.
Okay, anything on redirect, Mr. Starr?
No further questions, Your Honor.
All right, first off, I got to ask, obviously, we all sitting in here. I don't think, does the state have any witnesses that the state wishes to call at this time?
No, Your Honor.
All right, Ms. Williams, do you have any witnesses you wish to call at this time, ma'am?
No, Your Honor.
All right, at this time, I'll listen to closing arguments, and I'll start with you, Ms. Williams, again. Why shouldn't the court do what the court has been requested to do by the Christian firm in this matter? So, ma'am, thank you. This is your time to make a statement, another statement on the record, ma'am. Thank you.
No further comments, sir.
All right, Mr. Starr?
Yes, Your Honor. I just want to reiterate the law I stated in my opening remarks. 154.012 of the Family Code states that if you make a finding that someone has paid in excess of child support, not only can we bring suit to collect for the overage, but Section B states that if the obligee has not repaid the overage, the court shall order attorney's fees and court costs be paid in addition to the overage. You heard testimony from my client saying that there is an overage. The OAG confirms that there is an overage. He said my numbers were correct. And Mr. Guy has said he's not been paid back. And Ms. Williams has agreed with that assessment that there is an overage and she has not paid it back as well. The overage is $13,476.88. And attorney's fees before this hearing began are $5,808. That would make the total judgment, if my math is correct, $19,284.88. And we would just like to request that amount in our favor, Your Honor.
Okay. All right, folks, again, this is kind of a straight out accounting one. What I'm going to go ahead and do, I'm looking at having to find, obviously based under the Texas Family Code, that the money that it appears to be uncontroverted, that the funds were paid to Ms. Williams, and they were in excess of the child support amount after the date of graduation, and the child turned 18. So the court will reduce the judgment, that unpaid amount. I am going to do a 48-hour return on this one, where I can actually see. I need to look up what if it was child support. I know what I would have to do as far as the repayments are concerned, but I'm not sure how this sets up. It's just a straight out judgment, how much I've got to order the repayments to be as far as the monthly amount is. There's still going to be judgment interest on this, and I've got to double check what the standard judgment interest is, because I know the Attorney General and this court has its own interest amount. So I'll have to double check that to see what that is, and that way I can give the make a ruling on what that repayment would be to try to do it over a certain amount of time, if that's also provided for under a normal civil action, and what that amount needs to be as far as covering the interest. And I got to see what the court has to do as far as attorney fees and getting that set up. Is that part of the judgment, or that's something separate? Mr. Starr, do you know off the top of your head, sir?
Off the top of my head, no, I'd have to look it up as well, Your Honor.
All right, here's what I'm going to do. I'm going to go ahead and reset this. Let's see, I think I already got a 1045 on Thursday, and I was going to use this Zoom code, but I'll either do it at 1035 or 1130 on Thursday to see what to get these amounts down pat and see what we're looking at. Okay, no, I do not have a 1045 on this Thursday at the general docket. So what I'm going to go ahead and do is move this Zoom code to that 1045 time slot, and everyone can check in without having to go in through the main docket on that day, which, with the 40 or 50 cases we have at that time. So anyway, folks, I'm looking at doing the judgment, but I got to figure out what the repayment amount is, and I've got to figure out what the interest is, and obviously that will be placed in your order, Mr. Starr. And if you can double check that and find that out, I'll allow you to present that to the court at the time, and I'll make the ruling as far as attorney fees going forward. So anyway, I'm taking this under advisement, and I'll see you, and I'm resetting this for Thursday, Wednesday, November the 30th at 1045, same Zoom code, to make the final rulings on everything in this matter. Is there anything else at this time, Mr. Starr?
I don't believe so, sir.
Anything else, Mr. Diamond?
No, Your Honor.
Anything else, Ms. Williams?
No, Your Honor.
All right, thank you all very much, and we're off the record. Everybody's free to go.
The child support calculation that was giving her so much child support had her income at $15,000 per year. When we recalculated child support, the child support was at $50,000 per year for Ms. Chilton's income. And that was what it was recalculated on. Client's kind of stuck where he's overpaid child support for years, essentially.
I was not trying to be deceiving in any way.
It would be inequitable to charge the plaintiff an amount, and again, it would in essence have him paying over $7,000 that he should not have had to have paid had it been calculated at that correct amount at that particular time. So the court is going to grant the motion for the repayment. Screenly Court, what I'm going to do is order that the amount of $6,891 would be repaid over the same term that it was collected. So if it was collected over, I think you said over 12 months, then that would be repaid over 12 months. Matters before the court on the defendant's motion to enforce and modify child support.
I never received any support, nor I can even dig my stuff. So life is just like a nightmare with two young kids.
So are you saying that there is no support order at the current time?
The children live with me full time. Miss Parr only sees the children for an hour a week. She pays me child support.
As Mr. Spring states, there's an order for requiring you to pay child support. So it wouldn't be appropriate for you to enforce the order because all you have to do is pay the support. I've read all the pleadings in this matter. Ms. Parr, I don't quite understand. You said that this order was entered back in 2017. And I don't understand why it would take 4 to 5 years for you to correct any inaccuracies that you stated occurred, basically 5 years ago. And again, the allegations that you make as it relates to the referee do appear to be fantastic. So I'm at a loss as to what you're alleging.
Your Honor, I was very weak after threatening like some kind of narcissistic abuse that for so long, and I was afraid to bring things up. And every time I have a attorney, they told me not to, and now I was alone, and I think that's the only way that the court can see things clearly.
Okay, so what's the basis for your motion?
As the law says, when there's an exiting case, everything has to be filed on the exiting case. Instead of this case, they just come out with a new case without the court involvement and take over the old case. And when I was suffering financially to taking care of my kid.
Okay, well, this case was consolidated back on February 5th, 2018. And that's not unusual that if you got, a support case and a different, like in this case, the DC case, the cases were consolidated. That shouldn't impact the case at all because you can still make any corrections that need to be made. So again, I'm still not understanding what you're asking for.
I am asking for Your Honor because of all 2 years unpaid child support. That's what I wasn't able to come up with money to hire an attorney to presenting me until everything went downhill.
Okay, that still doesn't tell me what's the basis for your motion. You're saying you didn't have money to be able to fight it at that time. That's understandable, but it doesn't tell me why we're here today and what the basis is for enforcement or modification.
Well, they consolidated without the court involvement of February 5, 2018, but does not include the support order. I attack the attachment. They cross out with a pen. And because of that, I never received any support, nor I can even dig my stuff. So life is just like a nightmare with 2 young kids. And to still affect the case today.
So are you saying that there is no support order at the current time?
No, Your Honor. That order has been finalized on December 2017, but I does not receive a penny since the day you entered the final order, Your Honor.
Well, maybe I can get Mr. Spring. Maybe you can enlighten me. What's happening if you know?
He probably know because I am not aware of.
Okay, I've turned it over to him. I want to hear from him. So, Mr. Spring, enlighten me what's happening.
We've gone through several evidentiary hearings with the front of the court, and this is a support order that was put in place by front of the court, not by any agreements or anything like that. So this is just the state putting this order in place. The children live with me full time. Ms. Parr only sees the children for an hour a week supervised. So she pays me child support, and that's it. There's nothing other than that.
Ms. Parr, is that your understanding that the support order basically obligates you to pay support? You are the support payer?
In the DC case, yes, Your Honor. But in the DS case, you awarded me full custody of both the minor children until the DC case come out in 2018. And then Mr. Spring just start setting a trap with me, all witnessed by the minor children. I attack all the police report as well. He against me in PPR with false police report. And then that's how the DC case come out with the court without the court involvement. And also in May 2023, 2018, they told me we have meditation at your courthouse. And I was there witness with Marco from the said place. They told me if I did not sign a halfway cut down the child support amount on the DS case, on the DC case, I will never receive a penny. And that time I already took 10,000 personal loan just to buy everything needs for my kids and
Okay,
this
ma'am,
keeps going on.
try to focus on the motion. You filed a motion for enforcement and modification of child support. I don't need to get into all that extraneous stuff. I just want to know what's the basis for your motion.
Everyone should obey the court order, Your Honor, and this is the order still alive because they did not conciliate with the DHC case. They only consolidated the custody case. You can see that they cross out with a pen.
Well, in this particular matter, the only thing I could suggest, Ms. Parr, is that you proceed through this matter with the front of the court and see if you can't straighten out, again, the consolidation and the other, because quite frankly, as I look at this matter, as Mr. Spring states, there's an order for requiring you to pay child support, so it wouldn't be appropriate for you to enforce the order because all you have to do is pay the support. There'd be no issue in that regard. And apparently the front of the court has not pursued any action in this matter as well to enforce the order. So I'm really, as I stated, I'm at a loss as to what the situation is in this particular matter. So all I can say is you might want to proceed with the front of the court, as they have obviously involvement in both cases, the DS and the DC case in this particular matter. So the court just doesn't find a basis for the motion at this particular time. So I'm going to deny that motion. Mr. Spring, I'll ask in this matter that you would prepare an order denying the motion. And you can submit, if you submit that within 7 days, you can do it without having a hearing. And if you don't, then you're going to have a hearing to get the order entered, okay?
Okay.
Thank you. The court will end this matter at 10:49 a.m. You're free to go. Have a good day.
The plaintiff, he is alcoholic and there's ongoing sustained alcohol abuse to the minor children, and he don't take them to counselor once or ever. So this can affect their mental seriously. It can be like a long time.
Court will note the appearance of Ms. McIntyre on behalf of the defendant. We have two matters before the court. The first is Ms. McIntyre's motion to withdraw as counsel for defendant, and thereafter defendant's motion to modify custody, parenting time, and support. We'll take Ms. McIntyre will take your motion first. It's my understanding, based upon the pleadings, that the defendant is not opposed to your withdrawal. Is that correct?
That is correct, Your Honor. And this court previously actually ordered that I was to withdraw. And I think that there was a delay, or the paperwork got lost when I submitted the order under 7-day. And so that's why I had to renotice it out. But the court has already granted that request.
Okay. Ms. Power, are you opposed to the motion to withdraw?
Yes, she just don't do anything, so there's no point her in the case. I just need to refund at least a couple thousand.
Okay, well, that's not before the court. Her motion is to withdraw is before the court. All that other stuff is stuff you'll have to take care of separately. It doesn't involve the motion to withdraw. So the court will grant the motion to withdraw. And Ms. McIntyre, do we have an order in the file now?
Yes,
Okay.
you do.
We will get that entered, and then you are able to withdraw at this point. And if you wish to leave, we'll proceed with the defendant's motion.
Okay, thank you, Your Honor.
Okay, thank you. Have a good day.
Thank you, you too.
Ms. Power, we'll proceed now with your motion for modification of custody, parenting time, and support. Go ahead.
Well, the kids are basically is in a very, very bad situation right now. So they really need to come home. The court need to look into the deeper how everything went just some kind of upside down. And they need to be a loving home. They need to be cared. They deserve everything. So there's a lot of allegation like sexual abuse, physical abuse. They all are attached with the motion.
Okay.
And also the plaintiff, he is alcoholic, and there's ongoing sustained alcohol abuse to the minor children, and he don't take them to counselor once or ever. So this can affect their mental seriously. It can be like a long time.
Anything else that you want me to consider?
Can they come home, my kid?
Well, I'll ask Mr. Spring, do you have any response to the motion?
I would like this to be rejected. The situation with their mother has not changed, so I don't think that there should be any change in the custody order. Ms. Parr only sees the children for an hour a week, supervised, and I think it should stay that way.
Okay, thank you. Anything else, Ms. Parr?
Yes, Your Honor. I really wish you grant my motion, because nothing is a lie on that motion. Everything is based on the truth. That the court does misunderstand this all year long.
Well, the court notes that Ms. Parr has filed multiple motions in the past, and her motion now simply reiterates the same allegations that she's previously repeatedly asserted. The motion basically throws everything, no matter how old, against the wall, hoping that some of it will stick. And in this matter, if and when the defendant has new allegations that satisfy the holding of Barker versus Grassmeyer, which means proper cause or change in circumstance, which is the threshold for having an evidentiary hearing, the court will then consider the motion at that time. Ms. Parr, what I've stated is, as you look through your motion, you just keep throwing the same thing that you've alleged over the last couple of years in the motion, not setting forth anything new to establish the legal basis for the court to consider. And again, that's the Barker versus Grassmeyer case. And as a result, the court, at the time that you provide new allegations that satisfy that threshold, the court will consider it. But at this point, the court will deny the motion at this time. Mr. Spring, you're going to have to do an order, submit under 7-day notice of entry, denying the motion. Okay, sir?
Okay, sir.
Okay. Thank you. We'll conclude the matter at 10:37 a.m. You're free to go. Have a good day.
Last order of the court says that you have physical custody of the child.
Yes, I have full physical and full legal custody of him.
But he's living with the father.
But his dad has completely alienated him from me, and there's nothing nobody can do about it. He's a complete drug addict. So where's that money really going for my son? Well, he's wearing dirty shoes to school, so I have to pay child support, and on top of supporting him so he looks nice and presentable going to church on Sundays.
Mom requests a review of her $125 a month child support obligation.
Well, let's go on the record of the matter of Ryan currently Hitzman versus Ryan, case number 0808502DM. Which meeting did you miss, ma'am?
I for the child support review, yeah. Was like 2 or 3 days late. I want to say
when was
within
that?
A year, long time ago.
That's what I was wondering. Okay, yeah. I'm sitting here going, you should have brought this sooner.
I know. I just kind of figured that because you know how when I had the court date and right. I got custody of Ethan,
right?
You had mentioned that it might be hard him being 16 coming back home and everything. So I'm just like, what the heck? I might as well keep paying child support so at least I can support him in some aspect.
Right.
I most recently, over the last 2 months, started having a relationship with Ethan, and we go to church, and he's opened up a lot more. And I'm giving him personal money as he's coming over to my house, clothing, shoes. He's like had some nasty old shoes on his feet. And like I feel
So wait, is he living with Mr. Ryan or is he living with you?
he lives with his dad.
Okay. And you're paying the 125, right?
Yeah.
Okay, because the last order says that he lives with you.
He's well, by court order, it's supposed to be him, and that's what legal aid told me to put on the paperwork. By court order.
Well, it should be changed back to him, but the last order of the court says that you have physical custody of the child.
Yes, I have full physical and full legal custody of him.
But he's living with the father.
But his dad has completely alienated him from me, and there's nothing nobody can do about it.
Okay, then Miss Hitzman, you would be the one paying child support. So
he's not following through with the court order on even my son living with me, and there's nothing. What am I supposed to do about that?
Like I warned you, a 16-year-old's hard to control. They vote with their feet one way or the other.
And my son like openly admits that his dad is like does nothing for him, and he's
well, you have a court order that he can move in with you.
He's a complete drug addict. So where's that money really going for my son? Well, he's wearing dirty shoes to school, so I have to pay child support, and on top of supporting him so he looks nice and presentable going to church on Sundays.
Who's the drug addict?
His dad.
Okay. So why doesn't the child want to live with you when there's a court order having the child live with you?
Because he's used to living with his dad. That's just that's what
Okay.
Ethan said.
Because child support will always then be paid to where the child is spending the predominant amount of time. Okay.
Yeah. So I just got to keep sucking it up.
My thought is this: current child support is ordered at 125 a month, correct?
Yeah.
I don't think you want it reviewed because it would probably go up.
Well, by the time the review comes, he's going to be 18 and child support's going to stop anyway.
Well, is he in high school still?
He's in 12th grade, just started 9th grade this year.
So in other words, it's unlikely that he's going to be able to graduate.
Correct. I'm trying to force him to, he doesn't,
well, then what will happen is you need to present that paperwork to the front of the court and they will stop child support when he turns 18.
I'm here to rule on cases. I am not permitted to give legal advice. It would be a violation of ethical codes and improper.
That's fair.
Right. Even if he's halfway going.
He's got to have an anticipated actual ability to graduate.
He does. It's going to be like 2-3 years before he even does it. And he's not even interested in doing that.
And that's what I mean. Since he's not going to be graduating, you can present that to the front of the court and they should stop child support at 18. And if they don't, you may file a motion to do so.
Okay. All right.
But at this point, I don't want to hurt you.
I know.
Nobody else is requesting any changes. The change that was sent to the front of the court was the fact that you had custody because the child lived with you at that time. Now you're saying the child has voted with his feet.
I was given custody of him at that time.
Okay.
And then it's just been a huge uphill battle from there.
You have the right to file paperwork to enforce that, but at the same time, I'm not going to change anything this morning. All right?
Right. Thank you.
Take care.
Since I have been and will continue to be the child support payer, that income tax dependent, like, is there a way that we can alternate that, or just so there's...
In another hearing on a different day, we have what the judge likes to call another 16-year-old running the show.
He moved back in with me February 3rd.
Okay, so we got another, 16-year-old running the show? Pretty much?
Yep.
Yeah.
Dealing a lot with those lately.
Yeah. Seems like the thing to do nowadays. I don't know.
Well, one of the other cases I have this morning, when she was 15, she moved in with dad last year. Now, about a month and a half ago, 6 weeks ago, she moved in with mom. It typically lasts anywhere from 10 months to 12 months, and they move back to where they were. It's because they realize they're running the show. So I guess I don't think you guys need any relief at this point then, if everything's back to where it was.
And I guess I have one other matter, just so we don't have any issues going forth, and I kind of just want it to be fair. Since I have been and will continue to be the child support payer, that income tax dependent, like, is there a way that we can alternate that, or just so there's, you know, I pay the
Typically,
offset.
the IRS is the one who rules that one. So the
Okay.
federal government in a case like this, because this is a support matter, not a divorce, where it would have been argued as a part of the property settlement or possibly as the child support, but whoever has over 183 days gets the tax exemption by federal law.
Okay.
Absent order.
Okay.
And that one, we would need a change of circumstance to grant that to you. And as Matthew said, well, the court is run by changes of circumstance. Either we have them or we don't.
Right.
And
Okay.
on that, the tax matter, under the case of Fear v. Rogers, we do not have a change of circumstance to look at it. All right. Besides, be careful what you ask for.
No, I mean,
No, I ran one case one time where the IRS won the argument if I changed the tax exemptions. They got more money out of both parties.
Yikes.
So it's like, you don't want to do that. The idea is get as much money out of the IRS as possible, guys.
Right.
And that one I'll support. If you guys ever get, well, I probably have a communication problem, but if you ever figure it out that the IRS would squeeze more money out of the IRS in total, I'm all for that one. even if they are listening.
Yeah.
Always listening.
All right. Take care of yourselves. Take care of the kids, and good luck. And again, we may have this change again. Once you let a 16-year-old drive the bus, they tend to drive. And if the 11-year-old's watching, they'll think their turn comes next. So be careful.
Yeah.
Good luck. Take care of yourselves. All righty.
Thank you.
Thank you, sir.
All righty.
I barely can take care of the 3 kids I do have. So as a father, I got my daughter from her, and she's been with me ever since.
You have a court order to pay Ms. Henderson child support for her money?
Yes. She had a child that she had that died in a fire because she left the baby in there.
Mr. White, I believe the court was asking if you know why Ms. Henderson is not present.
Oh, no, ma'am, Judge. I have no idea. She actually missed the last hearing we had.
Is it possible she's not getting these letters because it's being sent to this Waverly address?
I have no idea, ma'am. Last time I talked to her was 6 months ago. She was in Memphis. So she just travels. You know, I asked her to be in her daughter's life. She probably called her once every 6 months.
So you're getting beyond the scope of, right now we're trying to make sure we have notice to her.
Oh, okay.
Not at the merits of the case yet. I'm trying to make sure we can get to the merits of the case.
Oh, okay. Yeah, I have no idea, ma'am. Sorry.
Okay. So I'm pretty sure this Everton address was where she lived when she signed the waiver. Well, I guess you may proceed.
At this time, the state is asking the court to make appropriate orders regarding conservatorship and possession and access of the child Imani. Mr. White is asking.
Are we getting to the long list of these things that are agreed to, like that you all propose, or is this stuff that's disputed that just needs to be presented anyway?
Probably. Well, here, we have an agreement for asking the court to set child support from Ms. Henderson to Mr. White in the amount of, or based on minimum wage with 1 child before the court.
Why don't you just present this all in testimony and lead it where you want it to go? That might be quicker and less confusing for me.
All right. Mr. White?
Yes, ma'am. Yes.
Where is Imani living right now?
She stayed with me.
Okay. How long has she lived with you?
She have been with me since she was 3 months old.
When was that?
And
month and year?
November of 2016.
What caused her to come reside with you?
Because I mean, I would come from Galveston to go see her in San Antonio. Then I started noticing drugs in the house and things of that nature. And so I asked her mom, you know, if you want to live that life, that's fine. It just let me have my daughter, because she has 3 more other kids. And I didn't want my daughter being raised around this stuff. So I asked her, well, can she just come stay with me? And she applied and said, yes, that's fine, because I'm going through a lot right now. I barely can take care of the 3 kids I do have. So as a father, I got my daughter from her. She told me it was fine. We moved, and she's been with me ever since.
You have a court order to pay Ms. Henderson child support for Imani?
Yes, medical, yes. Mhm.
How is Imani insured right now?
Since she was a baby, I had put her on chips, so that's how she's been medically supported.
Do you have private health insurance available to put her on?
No, not at the moment.
Do you know if Ms. Henderson has private insurance available to put Imani on?
I have no idea, ma'am.
Do you have any information on Ms. Henderson's employment?
No, ma'am, I have no idea.
Do you have any information on Ms. Henderson's current income?
No, ma'am.
All right. To your knowledge, does Ms. Henderson have any disability that would impede her from working full-time 40 hours a week at a minimum wage job?
Not to my knowledge.
Okay. Does Ms. Henderson have any other biological children?
Yes.
How many?
She has 3 more kids.
Are they all under the age of 18?
Yes, I believe so. Yes.
Do they live with her?
Yes.
Do you believe it's in Imani's best interest for the court to appoint you and Ms. Henderson as joint managing conservators of Imani?
No,
Why not?
because I just don't trust her mom. I mean, she hangs around drugs. She does drugs. I mean, she's been in a couple of rehabs. So no, I don't feel comfortable with that.
You know what joint managing conservatorship means? Did the state explain that to you?
No, ma'am.
Mr. Henderson, or I'm sorry, Mr. White, are you able to communicate with Ms. Henderson about Imani's needs?
No, because I don't have a good number for her.
Okay. Are you able to contact her at all?
No.
You and Ms. Henderson able to make decisions together for Imani?
No.
Has Ms. Henderson had any input in decision making for Imani?
No.
Okay. Who's been making the decisions for Imani since she began living with you?
I have her father, Richard Neal White Jr.
Okay. What kind of efforts has Ms. Henderson made to communicate with you about Imani?
Probably twice a year. I mean, if that.
What kind of things does she ask about when she calls?
She just asks her how she's doing and how she doing in school and things of that nature.
Do you believe it's in Imani's best interest for Ms. Henderson to have a standard possession order to visit with Imani for the first, third, and fifth weekend, all weekend long?
Yes.
Okay. So you think she should have unsupervised visits?
Supervised visit where she can do the supervised visit at least 3 times before she can be able to do the standard visits.
Why do you think Ms. Henderson needs to have supervised visits?
She is I don't trust her to be. She sometimes be suicidal and things of that nature. She's always depressed, so no. I don't feel comfortable with that.
When was the last time Ms. Henderson saw Imani?
Last year of July, I want to say July or August.
Has Ms. Henderson made any inquiries or requests to see Imani since then?
No. And that's would be the thing. Like when she do talk to her, she'll say, well, I'm gonna drive down there and see you, and then she don't do it, and then my daughter's sitting up there crying, and then I gotta console on why her mom, didn't come through to come see her or not.
Who do you think should supervise these visits?
Myself, Richard Neal White Jr.
Where do you think they should take place?
They can take place at a mutual agreement.
Do y'all have a place that y'all have been using before?
No, I actually would just meet her on I-10 or something like that near Katy area or something like that. But that was like over 2 or 3 years ago. But that haven't happened in a while, except for last year when I decided to let her see her mom and, try to let them bond together. But it's the same thing. Like we may call her. I might let her call her and it's like once a month her number has changed or she moved, or I mean, like to last year she was in Memphis, so I ain't no telling where she at or what's going on.
How many supervised visits do you think Ms. Henderson should have before she is able to visit with Imani unsupervised?
On a standard visit? Yeah. I think at least 3.
Okay.
I would want her to have 3 sessions. So I guess the first session 3 times, the second session 3 times, the third session 3 times. And then if I'm comfortable with the standard visit after that, I think that'll be fine, because I do want her to bond with her mother.
Okay, so you're asking for 3. So are you asking for 3 periods of visitation in each of the 4 steps?
Yes, ma'am.
To
Yes, ma'am.
standard possession? Okay.
Yes, ma'am.
Ask the witness, Judge.
Is there anything else you'd like to say?
To me, you talking to me, Judge?
Yes.
The last thing I wanted to say, the very thing that I'm just
How old is your child?
Imani's 8.
Okay.
Yeah. And the biggest thing with Forrest, like me not trusting her and Forrest Street, because she had a child that she had that died in a fire because she left the baby in there, her first child. So that always stuck in my head when my daughter goes, I would let my daughter back in the days, be around and stuff. So it was like, that just was devastating to me. So I was like, I always wanted to be there with my daughter when they visit. That's all.
And Ms. Laskowski, do you have any proposals regarding child support or arrears?
Yes, Judge. The state would ask the court to take a no child support previously ordered, so no judgment there.
I don't know that I heard testimony on arrears.
Okay.
I missed it. Did I miss it? I'm sorry if I did.
No, you didn't. May I recall Mr. White very briefly?
You may do so.
Mr. White, are you
Yes, ma'am.
Are you ordered to pay Ms. Henderson medical support for Imani?
Yes. Mm-hmm.
How much are you ordered to pay per month?
I believe it was $44 a month.
Okay. Are you current in that obligation as of the date that Imani came to reside with you?
Yes, I was.
The obligation actually started after he claims the child lived with him.
I understand, Judge. Yes, I know.
I think it just makes that sentence hard to answer, or that question hard to answer.
Hey, Mr. White, I'm sharing my screen with what's been marked as State's Exhibit 3, the pay record in this case. Does this pay record accurately reflect your previously ordered medical support obligation?
Let me take a look. Yes, that's it. Yes.
Okay. All right, the state would offer what's been marked for identification purposes as State's Exhibit 3.
Sir, do you have any objection to me admitting that as State's Exhibit 3? I don't know what 1 and 2 were, but do you have any objection to me admitting State's Exhibit 3?
No.
Okay, I'll admit State's Exhibit 3. I'll have you know, Ms. Laskowski, I don't know what it says exactly. If you're expecting me to base my ruling based on that exhibit, I don't have that in my head.
As of April 28th, Mr. White's medical support arrears balance shows $1,624.09 in arrears. Possession credits of $44 per month from November of 2016 to April of 2017. Principal equal to a principal of $3,960. Interest of $881.10, with a total possession credit for medical support in the amount of $4,841.10. So for that reason, the state would ask the court to take a medical support arrearage judgment against Mr. White in the amount of 0 as of April 28th, 2024.
And does the state have any proposal regarding child support or medical support?
Yes, Judge. The state would ask that the court base Ms. Henderson's current child support and medical support on minimum wage, $1,257 gross monthly resources. 1 child before the court, 3 others. credit for taxes and $28 cash medical support, with the state asking the court to order Mr. White to apply for a government health plan for the child. 14.75% of net resources is $164.47. The net resources are $1,115.06. So the state would ask that the current child support of $164 per month and the current cash medical of $28 per month would both begin on May 1st, 2024.
I'm going to find that Ms. Henderson is in default and find there's been a material and substantial change in circumstance since the last order and that the child is no longer with Ms. Henderson. An order that you're the managing conservator and that Ms. Henderson is the possessory conservator. With no residency restriction, you'll have the right to determine the primary residence of the child, Amani. Sir, I'm going to find that she's in medical support arrears of $0 as of April 28th, 2024. I'm going to order visitation. It'll be a phased-in visitation. The first, third, and fifth Saturday of the month from 1 to 5, supervised by you or a competent adult. And then 3 visits. And then after that, the first, third, and fifth week Saturday of the month from 1 to 5, unsupervised for 3 visits. Those to be held in Galveston County. And then the first, third, and fifth Saturday of the month from 8 a.m. to 5 p.m. for 3 visits to be held in Galveston.
Okay.
And then she'll step up to the first, third, and fifth Saturdays of the month from 6 p.m. on Saturday to 6 p.m. the next Sunday. Also to be held in Galveston. And if she completes all that, she'll move up to the standard possession order.
Thank you, ma'am.
And then I'm ordering that Ms. Henderson pay to you child support of $164 each month beginning May 1st, 2024. And I'm ordering that you apply for or continue with a government medical plan and that Ms. Henderson pay to you, Mr. White, cash medical support of $28 each month beginning May 1st of 2024. And I'm going to order that she pay court costs on or before December 31st of 2024.
Okay.
And the Attorney General's office is going to draft an order based on my ruling today, and they'll be sending it to you through DocuSign now to review and to sign off on. So we're going to have you go back to the breakout room where they'll be able to send that to you so you can look at it. But thank you for coming in today and good luck with everything going forwards.
Right. Thanks a lot, Judge. Thank you.
You have sexual relationships in the state of Texas. You should have realized a child could result from that. And I could even order retroactive for 4 years on someone who doesn't even know the child was born. But the fact that they are the parent, they did have the relationship, that's that.
She's a pretty wily person when it comes to evading paying money.
Are you in agreement with that?
You know, in agreement, I mean, it sounds like I have no choice. My ex, both her parents have died within the last year, and she has over $150,000 in assets. So.
All right, the court take notice that Holly Krantz will serve June 20th, 2023. No answer's been filed.
What are the children's names?
3 children, 2 minors. We have Colin at 13, Amanda at 17, and then Riley is 18. All same last name.
And is it correct that Miss Holly Ann Krantz is currently incarcerated?
To the best of my knowledge, I don't really have access to that information, but that's what I've been told.
And she was previously ordered to pay you child support of $341 per month, correct?
Correct.
And so today we're requesting a child support judgment of $8,354.68 as of August 31st, 2023. Do you believe that amount is accurate?
That sounds accurate, yes.
And because she's incarcerated, we're not requesting any payout on that arrears balance. Are you in agreement with that?
When you say payout of the arrears balance, my understanding is that one of the stipulations of her release is to get that arrears balance taken care of. And I was explaining to the the Attorney General's representative that my ex, both her parents have died within the last year, and she has over $150,000 in assets. So
She'll still owe that money, but we won't set a monthly payment right now because she's incarcerated, but we can set one up once she has been released.
okay.
And what kind of health insurance do the children have?
Part of the court orders of possession of the children was she was to provide health insurance, but she quit paying her Blue Cross Blue Shield premium. I think it expired in July, or not expired.
And do you
but
have them
was-
on insurance currently?
I do not. I'm planning on putting them on the ACA effective January 1st. That's the earliest I can get them in.
All right, so you're in agreement to carry health insurance for them through another source.
I cannot afford health insurance for them through another source. I have an ex who has not paid anything in years, and I'm self-employed, and I'm dealing with paying for the kids fully, and I'm dealing with inflation. So I understand that the kids need health insurance, but I cannot afford to go out and get it on the marketplace without the ACA.
And have you applied for Medicaid or CHIP insurance for them?
I have not, no.
And the order has to state what kind of insurance the children will have. So we can either have it to where you would carry it through another source or where you would apply for government coverage. Is there a preference you have?
I have looked at alternate sources, and that's prohibitively expensive. I've got dental insurance on them now. I got that in place, but I'm happy to apply through. I'm sorry, did you say CHIP or Medicaid?
Yes.
Okay, I can do that.
And because the mother's incarcerated, we're requesting to modify her child support to $0 per month and not request any medical support at this time. Are you in agreement with that?
In agreement, it sounds like I have no choice. If I don't have an alternative, then I'll concede. But no, I'm not in agreement when she has money in the bank that she could make these payments with, and that's frustrating.
And has there been any family violence between you and Ms. Krantz in the last 2 years?
No, not between me and her.
Do you have any safety concerns with her having your address or your phone number?
She already has both.
And if you were to move tomorrow, you'd be required to give her that new information. Are you comfortable with that?
I'd prefer not. There is a violence history with the kids.
And do you
But
know,
I doubt I'll be moving tomorrow.
do you know why she's currently incarcerated?
She's on her third DWI, so I believe it's in connection with non-compliance with her, what do you call it, probation? I believe. Again, that's what I understand.
I will pass the witness.
Okay, all right. So I understand, Mr. Krantz, this probably is kind of frustrating why you're here today. We do these cases when people are incarcerated.
Yes, Your Honor.
To stop the bleeding on a case where child support and medical support are accruing and there's no income. I understand you say she may have inherited the money. If she does, the Attorney General's office will try to reach out for that money to be paid to pay off these arrears. But we're also looking at trying to pay off stop the child support for now. When she's released, we'll need to come back to court to restart child support. So it's very important that I know you don't really care to know much about her life, but it would help so that when she's released, so that you can inform the Attorney General's office or file your own motion to modify to restart the child support. Because otherwise she will not be ordered to pay support until I do a new court order. I'm granting you a non-disclosure as to your address. You're not required to notify her of any new address you may have. I understand you say you may not move, but just in case, since there's been
family
violence issues that you're alleging, I'm not requiring you to do that. Court costs is billed to the mother. The Attorney General's office will draft an order based on all this. They'll still keep, like I said, keep working on collecting the $8,000 plus. And so if they can find that, they will try. And then we'll go from there when she's released. You are done with court, sir. You can press leave on the Zoom to exit out. Thank you.
Your Honor, may I ask you one quick question?
Yes.
There's no way to put in the orders that upon release that the child support kicks back in. I guess that's not an option.
It's not really enforceable. because we don't know when she's going to get released. So when we look at orders, we try to be very specific about begin dates, as it's like when child support is supposed to begin. Like if you're in another case where you're establishing support today, we would say child support begins October 1st. We don't know when that'll be for her because we don't know when she's going to get released. So that's why I said it's very important that someone know that she got out so we can start that process over again. We can't do it based on a vague date that we may not have information on. The Attorney General's office may not know when she gets out. So there's no way for them to put it on the computer that it's supposed to begin on a certain date.
Okay, I'm just curious. Does that mean if I contact the Attorney General's office and then the Attorney General's office has problems serving her, then it could be months and months of her being free and not paying child support. So that's my concern. She's a pretty wily person when it comes to evading paying money to all sorts of folks, myself included.
I understand the frustration, and unfortunately there's not much else I can really do. Okay.
Totally understand. Thank you, Your Honor. I appreciate it. You have a good day, and thanks to all of you.
Thank you. All right, you're excused. Bye-bye.
You've since received all the money you were supposed to receive pursuant to the terms of the judgment of divorce. Isn't that correct?
I have received my funds, yes, but I have
Okay.
not been made whole. I want to be made whole.
Okay.
I had to go through whether I hired a lawyer or not. This is about gender discrimination.
He has not made a child support payment since July of 2023. I have accrued a large amount of debt for not having any child support, and I need to at least be able to, I've been having to put things like utilities on a credit card in order to not drop below zero on my bank account.
Her lawyer at the time called me saying that if I did not pay child support, I would be taking my kids away. So I lived in my car for 4 months and still pay child support.
We are here on a CSRP to confirm arrears and modify support. We do not have an agreement as to the proposed CSRP, so I will take testimony from both parties. The state calls the mother Ms. Craig Hardy. Will you state your name?
My name is Candace Craig Hardy.
And what are the children's names?
Raina Eve Hardy, Eleanor Hardy, and Aaron James Keir Hardy.
And how old are they?
Raina Hardy is 16, Leah is 13, and Aaron is 10.
Okay. And we are proposing that we confirm Mr. Hardy's child support arrears in the amount of $898 as of August 31st, 2023, and that he pay that balance back at $10 per month beginning October 1st, 2023. Are you in agreement with that?
No.
Okay. And what are you not in agreement with?
He has not made a child support payment since July of 2023. And so the arrears amount is greater than that amount. Also, $10, I have accrued a large amount of debt for not having any child support. And I need to at least be able to, I've been having to put things like utilities on a credit card in order to not drop below zero on my bank account. And so I'm asking that I can at least be able to make the payments on those credit cards for the debt that I've accrued for not having child support payments.
Okay, and so you're wanting the payments on his arrears to be more than $10 per month?
Yes.
And how much would you propose?
I would propose $100 a month.
Okay. And we're showing that Mr. Hardy has medical support arrears of $498.20 as of August 31st, 2023. And we have proposed he pay that balance at $5 per month beginning October 1st, 2023. Do you agree or disagree with that?
I agree with that.
Okay. And what kind of health insurance do the children currently have?
They are on children's CHIP Medicaid.
Okay. And we'll talk about the modification of support next. Do you know if Mr. Hardy is employed?
As of Tuesday, I called OAG and they told me he was. And this morning he told me he was not.
Okay. When's the last time you knew him to have a job?
Last week.
Do you know what kind of job he was doing?
Last I knew he was working at Home Depot. He did not inform me of that. My children did.
Okay. And the order from 2020 has child support set at $898 per month and medical support at $403 per month. Are you wanting the court to continue those amounts of child and medical support?
Yeah, yes, for the arrears, but he has a new child, so I'm willing to, you know, adjust it according to him having his new child.
Okay, so since the order,
Could you hold for just one moment? I'll be back in 5 minutes. All right, you may continue.
thank you. So Ms. Craig Hardy, the modification order from 2020 has Mr. Hardy's gross monthly income at $478.36.
Okay.
Giving him credit for his new child. Is that a yes? Let me do a calculation right quick to rerun those numbers. And the 2020 order also deviated from guideline support because Mr. Hardy had the children every Thursday of the week. So he had possession more than the standard possession schedule ordered. Is that still the case currently?
Yes.
He does, yes, but my attorney told me that that wasn't grounds for reducing standard child support.
You have an attorney?
I just consulted one before coming.
Okay, so does has anyone been hired to represent you in this hearing or in this case?
No.
And so today you're wanting the income from the 2020 order to be used to calculate support, giving him credit for one other child, and then not doing any offset for the extra Thursday.
Correct.
Okay, and so based on that information, that would bring us to medical support of $302 per month and child support of $945 per month. Is that what you're requesting?
Yes.
Okay. And do you have any, well, let me ask, has there been any family violence in the last 2 years between you and Mr. Hardy?
No.
Do you have any safety concerns if your address or your phone number is printed in this court order?
No.
And so you believe Mr. Hardy is employed?
I believe he, I believe it's convenient that he's unemployed every time we have a meeting.
And do you remember in 2020 when we did the modification order, what kind of job or where he was working at that time?
He was doing landscaping. I believe it was the same position that he had up until July, although his contracts had been sold to different companies, but it was the same position.
Do you know if he was self-employed?
No, he was working for different companies. The most recent one before his unemployment was Lambert's landscaping company.
And as far as you know, do you believe he still has the ability to earn that same income as he did in February 2020?
Absolutely.
Is there anything else you want to tell the court about this case?
I did want to request a name change if possible. I wanted to drop Hardy from my last name. I didn't know if that would be appropriate to do at this point or at this hearing.
I don't think the court can consider a name change at this point. I think it would have had to been done in your divorce decree.
Okay.
I will pass the witness. The state calls the father Mr. Hardy. Sir, will you state your name?
James Hardy.
And Mr. Hardy, the proposed order we have confirms child support arrears for you of $898 as of August 31st, 2023. Do you agree to pay that balance off at $10 per month?
I would actually commit to $50 a month.
50?
Yes.
Okay. And then the medical support arrears we're showing are $498.20 as of August 31st. Would you agree to pay that off at $5 per month?
I can do 10.
Okay. And are you employed right now?
Actually, I lost my job. Miss Craig doesn't know my life, so she gets information from our children. So sometimes children don't give you the right information.
When's the last time you had employment?
Let me check that date. It was, hold on one second. The 8th, sorry, the 7th.
Of what month?
Of December.
And what job were you working before that one ended? Where were you working?
I worked at Home Depot for a few, I think 2 months. And then I got this job. And because my mother was sick and I was sick, I couldn't work that day. And so part of the thing I did not know at the time is that if I missed one day, I would be released from the training program.
And this is for Home Depot, correct?
No, this is for Home Expo.
And where were you working before Home Expo?
Home Depot. for
Okay.
about 6 weeks, I think.
And then what about before Home Depot?
And before Home Depot, I worked. I took another job. I was looking at Lambert's. I took another job. I was there a week. I had a crash on the highway. It was deemed it was my fault, and I lost my job. Since then.
And
so
when was
since
that
then-
accident with Lambert's?
No, it was with another company. I was there at the other company for 1 week, and then I lost my job.
And when was that accident?
Let me go back and see. That was July 18th.
14.
The accident.
Okay, so you've had on and off jobs since July of this year.
Yes,
Do you live in Dallas County?
Denton County.
Okay. Now, are you requesting the court set your support today on minimum wage?
I mean, right now I have lots of interest today, this afternoon, and tomorrow. So I'm actually looking for jobs, and you know, if I can't pay $100 a month if I'm not working, that's money doesn't come out from the air, you know. So I would like a compromise, but you know, and then when I find a job, redo the terms of because it's on my income. If my income is not, you know, $100,000 or $10,000, it's completely different.
Okay. So would you be in agreement today to do a temporary order to have your child support and medical support based on minimum wage? And then we can come back in a few months to see what your job situation is?
That would be the best situation.
Okay. And so if we did use minimum wage to set support, we're showing medical support of $84 and child support of $292 per month, beginning October 1st. Is that what you're requesting?
Yes, I can do that.
Okay. Has there been any family violence in the last 2 years between you and Ms. Craig Hardy?
No,
Do you have any safety concerns with your address or your phone number being printed in the court order?
no, that's fine.
And it's correct, you have one other child, and that child lives with you?
Yes.
Okay. Is there anything else that you want the court to know about this case?
I mean, this case is, since we've been divorced, I've always had a job and always paid. The first time we first did the decree after we got divorced, I was working, but then I ended up losing my house, living in my car for months because I was told by Miss Craig and her lawyers, actually, I mean, not Miss Craig, but actually her lawyer at the time called me saying that if I did not pay child support, I would be taking my kids away. So I lived in my car for 4 months and still paid child support. I think, you know, sometimes in life things happen, you know, to you, things happen. And sometimes you have to, when you're down, you gotta keep going, you know, I could stay home and not care, but I care about my kids. You know, I give them the best I can give them at this moment, so.
I'll pass the witness.
All right, Mr. Hardy,
Is it okay to ask anything, or is?
I'm sorry?
I was going to ask if there was some more I could add to the discussion.
What do you want to say?
Just wanted to say that he stated that I got my information from the kids about him being employed or not, but I did call OAG and they had told me that he had been employed up until December 13th. Although he is supposed to provide that to me according to our divorce decree, he's supposed to notify me when there's a change of employment, and he has not done that. And the arrears have accrued since then. And that's what I wanted to say.
Okay, now, Mr. Hardy, what type of work do you normally do?
Landscape management.
I'm sorry, I didn't understand you.
Landscape
management. Okay. And you can't job doing that?
Right now, I applied. There's very few right now because it's winter. So I've been applying for jobs that are out of my career, you know, sales jobs, anything, any job that I could get. I would take it. So
I'm not going to issue a final order. I'm going to do a temporary order today. And finding in the temporary order that you're in arrears $898 in child support judgment of that amount payable at the rate of $50 per month beginning October 1st, 2023, and finding you to be medical arrears of $498.20 judgment payable at $5 a month beginning October 1st, 2023. I'm going to temporarily reduce your child support to $292 per month beginning November 1st, 2023, payable on in that amount until we come back. The same thing with the medical. I'm going to reduce it to $84 per month beginning November 1st, 2023. And give me a reset date, Ms. Nutt. I need at least 4 months so that given a good opportunity to find a job. We'll come back on April the 29th, 2024 at 8:30 in the morning. All right. Either one of you have any questions of me?
Yes, how will I be receiving these child support payments? Because we haven't gotten anything.
They're going to come the way they've always come. He's going to pay it through the registry and record it. That way we'll know who paid what and when.
Okay, he hasn't paid anything since July and on either of the child support amounts. So if he's supposed to be paying to the registry, he hasn't been.
Ms. Nutt, in the order, it will say where he's to make those payments and how he's to make those payments. He's to the registry, which is in San Antonio, I think, and he'll just mail it to them, and then they will, in turn, will send it to you. Okay.
Yes.
That way we can keep a record of it. Okay. Yes, sir.
Yes, will I be able to get a copy of this this judgment sent to me, so I have it in a hard copy?
Yes, Ms. Nutt is going to email to both of you a copy of the order that we've set forth today. The things that I told you, that'll be in the order. Okay, so you'll know exactly what's requested of you and what you're to do. All right. Y'all can press leave and you're free to go.
The state is asking me to set child support based on $8,200 a month.
Yes, Your Honor.
Okay. Good luck collecting it. That's not what he makes, Mr. McNulty. You're catching the man in one great quarter of 2023. That's what you're doing. And you actually got lucky and caught him, what, 6 months after you filed your lawsuit?
He called the police on me in October, and I went to jail for it, and I haven't seen my daughter since. I've always had custody of my daughter since she was born. No one can confirm that he has possession of my daughter. LaDiary Jones does not have possession of my daughter. Everything that's coming out his mouth is money, calculations, you know.
The Office of Attorney General filed a notice of change of status with the court. Basically, we had received information that the children may be living with Mr. Robinson. I don't think that that's agreed to, and I think we just need to have a hearing on basically all the issues.
Okay, you would call the parties.
Okay. Ms. Robinson, where are the children in this case currently residing?
My daughter, she's actually residing with his mother.
And how long has that been going on?
It has been going on since October. I haven't seen her since October. And there's he called the police on me in October, and I went to jail for it, and I haven't seen my daughter since.
Were you granted primary custody in the prior order?
I've always had custody of my daughter since she was born. Okay. Until this October thing.
So what happened in October?
So in October, my daughter and I took her phone because she was misbehaving, and during that process, I guess she called her father, and then he came with his girlfriend to our home. Me and him did have a verbal altercation, and my daughter was taking things out of our home that I was like, that's not a weekend thing. I was just thinking it was going to be a weekend visit with her dad. So they left, and then 4 hours later, the police came to my home, and I went to jail for one night. And then ever since then, I have been now I guess I'm a non-custodial parent. I haven't been able to see my daughter, hear from my daughter. And I know for a fact, but one thing I do know for a fact, she stays with his mother.
Okay, Miss Robinson, can I, what was the reason they took your child?
They told me it is family domestic violence.
Okay, so was there some sort of altercation between you and your daughter?
No, it was basically like items, like she was taking items out the house. I was putting items back in the house or hiding them. Like I said, there was no altercation. I did not hit my daughter.
I didn't ask that question right. Let me ask it again.
Okay.
Why did the police arrest you?
At that particular time, I didn't know.
You don't know why they arrested you?
They just told me when they came to my house, they said that they asked for my name, and then they said, can you step outside? And then I was handcuffed. And then I said, what am I being charged for? And they said, family domestic violence.
Okay, so they charged you with domestic violence.
Yes, and I didn't know if it was because I didn't.
All right. Did you go to court?
Oh, and so basically, I haven't actually been to court as of yet regarding that matter.
Okay.
But I was told like to not. I like the bond. I'm not supposed to be anywhere around my daughter Amari. But okay, I haven't been to court yet.
Wait, let me talk a little.
Okay.
So did they do a protective order against you?
No, I think the only thing I have is like from the bond. It was like in order for me to get out of jail, it had like I don't think I have a protective order on me.
Okay, all right, that's fine. Okay, you may continue, Mr. Wright.
Ma'am, are you currently employed making $14.25 an hour, 40 hours a week?
Yes.
Okay. Does Mr. Jones currently provide health insurance for your daughter?
No.
Okay.
She has Medicaid.
Okay.
And he was paying child support, so
okay.
I thought.
So I'm showing that before giving any sort of credits for possession, that child support owed as of yesterday is $9,138.61, and medical support is $3,247.14. Do you think those amounts are accurate?
You talking to me?
No, this question's still for Ms. Robinson.
Okay.
But Ms. Robinson didn't have an order ordering her to pay child support. So
Right.
any of that money should be against Mr. Jones. Is that correct?
Yes, I'm sorry if my question wasn't clear. I'm showing that that's how much that he owes you as of that date. Do you think those amounts are accurate?
I believe so.
State is proposing to take a judgment giving Mr. Jones credit for the time he had possession of the child, which would result in a child support judgment of $2,218.17 as of yesterday, and $3,247.14 in medical support as of yesterday. Would you be in agreement with those amounts?
I'm sorry, would you repeat those numbers?
2,000.
I just need the medical number.
I'm sorry, just the medical?
Yes.
$3,247.14.
Okay. I think his question, Ms. Robinson, was, would you agree that that's the amount giving him possession credit?
Possession, okay. Possession to me means that he is taking care of my daughter, and that is not factual.
Okay.
He does not, and my daughter.
So the answer to my question then, ma'am, is that you don't agree with that, and the reason you don't agree is because you don't believe that he's been the one taking care of her, correct?
That is correct.
Okay. Are you in agreement with him being named as the primary conservator of the child with the right to designate the address?
No.
And why is that?
Why do I, so basically you're asking me, you're asking me if I'm in agreement with him being like the sole provider.
Not even necessarily sole, asked primary. Like, so the one who has the right to designate the address.
No, I do not agree with that.
Okay. And what kind of conservatorship do you believe would be appropriate?
I think it needs to be how it was before. Cause like when he was on child support, I didn't put no visitations on him, restrictions on visitation, none of that stuff. I feel like we should be able to just have a normal communication relationship to where we can both take care of our daughter. And that's never been the issue ever since she's been born. But no, I don't believe that he should be primary. That's basically what that is. And if anything, we need to be joint parenting.
What kind of visitation schedule do you believe would be appropriate?
For me or him?
I guess when I say visitation, possession. So for both of you, who would have the child when?
I would have the child like I've been having her since October, and he could come see her. He could come. I have no issues with him seeing her. But I'm the primary.
So whenever you say since October, you haven't seen her since October, right?
That is correct.
Okay.
Seen her.
So do you mean before October?
Huh?
Do you mean before October?
Okay.
I think both of you are kind of off the track here.
Okay.
Mr. Wright is trying to determine whether or not you should have visitation with the child, Ms. Robinson, and what type of visitation arrangement would you like? Do you want a standard visitation? That means you'd have the right to visit with the child on the first, third, and fifth weekends of each month, or some other arrangement. I understand that you're saying that you want to be primary caregiver for the child, and that Mr. Jones will go back to the arrangement that was in place prior to the child being taken from you. I understand that's what you're saying. Is that correct?
That's correct.
Okay. Now, but that's not going to happen today, okay?
Okay.
Okay. You may continue, Mr. Wright.
So I would like standard visitation.
All right.
Or
standard
more,
visitation.
or more.
Okay.
If this court does order that Mr. Jones is the primary parent, would you be in agreement to the state's calculation of guideline child support at $407 per month?
Yes.
Would you be in agreement to pay medical support of $90 per month and dental support of $15 per month?
Yes.
Is there anything else you want to bring to the court's attention?
No.
I'll pass the witness.
All right.
State we call the father, Mr. Jones.
Yes, sir.
Mr. Jones, what do you believe that you and Miss Robinson can work together to make decisions regarding the child?
I believe, that she's, a good parent, but she needs some, everybody needs some counseling. And so I believe, she needs some counseling.
I guess more what I'm getting at is, do you think that it's appropriate to share decision-making power such as educational, health decisions, things like that?
I think with me being the sole provider, and everything, she's in my household. So I think everything will have to go through me right now.
Can you tell the court about how your daughter initially came into your possession?
Okay, I got a call on October 1st, my daughter date, but prior to October 1st, it's been a lot of back and forth, with her and her mom. It's been kind of heated conversations, arguments, and things, to that manner. And I do have recordings, notion of all this. It's a lot of stuff going on. Let me see, but I was called notion on October 1st, and then when I pulled up to the house, Amari, so was in the street with the next door neighbor, and they was picking up like some change, which is Amari's let me see, her piggy bank. And let me see, it was some clothes sitting outside. It was some clothes sitting outside the house, which was Amari clothes. Her mom throwing Amari clothes out, fussing.
Like for modifying and shit. I don't understand why she just didn't do that right there and there and just send it to the judge and be done with it.
Hello?
Who is this?
It looks like someone
They need to be muted.
Yeah.
Who is these people?
Hello?
Miss
apologize.
Robinson. Miss Robinson.
Yes.
Would you put your
on mute?
thing on mute? Yes, ma'am. Mute yours. Okay, now Mr. Jones.
Okay, cool.
All right.
Okay, so when her and the neighbor was outside picking her clothes up, her change up from her piggy jar or whatnot, I got out the car, and then her mom was fussing that I hope the crackheads pick up your change, all this, et cetera, et cetera, et cetera. Throwing her clothes, like you got to get out of here, get on all this big disrespectful stuff, woo woo, and just on the attack mode, but just and Amari, was very, like quiet, just picking up her stuff and everything. And she seen me, she come to me being all, let me see, agitated, just voicing, and I guess she wanted me to react to the situation, and whatnot. And my girlfriend, she was in the car, and she was, Cameron of all this going on, and when she seen her, you gotta be just being a little extra, whatever case may be. So I was continuing to help Amari get her belongings and bags in the car and etc. And then once we got all that stuff out, we went on and we pulled over at Sock High School and got out and looked at her arms, and I looked all over and just spoke to Amari and just about her concerns, and I seen all the bruises and the knots in her head. So, and that was from a physical altercation that they had prior before I got there, and so I went on to call the police. They did their judgments and took our statements, and then they went to her mom and I guess arrested her mom. And so, but other than that, Amari been with me, since striving ever since.
And so based on that, on that history of violence, you're asking that that you be named as a sole managing conservator. Is that correct?
Yes.
Okay. Do you believe that that visitation is appropriate at this time?
I don't think visitation will be appropriate until she handle her business. Whatever because she's against the state. Whatever that she got going on in her case, like she said, she has she can't see her, or whatnot. And actually, I think she kind of spoke to her, then reached out to her. I know of that. But at the same time, I don't mind them having the relationship, they had before, the first, third, and the fifth, whatever case, and let them flourish. Everybody needs their mom, everybody needs their dad, but she just needs to handle her business.
Are you currently carrying her health and dental insurance through your job?
I can do that on my ADP. I was doing that just a minute ago, but once we get done with all this, I can try to confirm everything doing my ADP and do that. I got to go to work tonight, so.
Okay. Did you hear those amounts I read earlier as the state's
I wrote them
calculation?
down.
I'm sorry.
I got the 90 in the medical. You said 15 in dental and 407 in child support. Now,
Yes.
let me ask you this. I did a guesstimate with them averages. Is there any way, that if it's cost higher, whatever case may be, could I call back and make adjustments about that?
So, I mean, that's what the state is proposing based on the information that you've provided us. In order to modify a court order, that would require another court order. So with that being said, are you in agreement to setting those amounts as current child and medical support?
I'll take that right now. Yeah.
Okay.
Let me make sure I understand, because obviously I guess I'm the only one that's out of the box here. What's happening, Mr. Jones, is that this is what Miss Robinson is going to be paying you. She's going to pay you child support in the amount of $407 a month. She's going to pay cash medical of $90 a month, and she's going to pay cash dental of $15 per month. Now, she is going to have a standard visitation, and both of y'all are going to be joint managing conservators, meaning that both of you have the right to make decisions in the life of the child. Now, this
I
is
ain't hear
what
nothing about no joint.
I know. I'm deciding it should be joint. I know you wanted to be sole managing. She wants you to go back to the way it was previously, but that's not the way it's going to happen. Okay.
Do your thing.
Now, I'm going to give you possession credit so that you're going to have to pay her arrears, $2,218.17. Now, how much should he pay that at, Mr. Wright? What rate?
State is asking for a repayment schedule, repayment of that $75 per month beginning September 1st.
All right. And then on the medical, $3,247.14. How much should he pay that each month?
We're also asking for 75 on that.
All right. Now, Mr. Jones, you're going to be paying, looks like $150 each month to Miss Robinson for your arrearages. You understand?
Okay. That's what you're saying. So I have to understand that that's what you're saying. So my question is, the possession credit, no, so whatever the case may be, what was the total number on that?
All right. Initially, the state said that you owed $9,138.64 in back child support. But as a result of your possession of the child, they credited you so much money, leaving you owing $2,218.17. You understand?
Right.
On the medical, it looks like it didn't change, that you owed $3,247.14, and they're still requesting $3,247.14. You understand that?
And so with the money, no, saying that was paid in.
If you got money, if there's any money in there, they'll credit it and make the appropriate adjustments.
Okay, cause nothing like I did my calculations, nothing as well. I know we going over numbers or whatnot since October 1st, and when I got paid, that's 11 months. So yeah, out of my check, that was $426.92 coming out every 2 weeks, and from
how long did they continue to take that out of your check?
They still taking that out of my check as of today.
Okay, then any monies past that time will be credited back to you.
Okay, well, I just wanted to state that I had brought up the total like $9,392.24.
Okay,
so,
but I'm not privy to the numbers, but I'm telling you what this is going to be, and this is how it's going to work. If there's monies that are owed to you, then you'll get them. Okay. You'll get the money. Okay.
All right.
Mr. Wright, you understand that effective of October, then any payments that he made will be credited back to him, correct?
They first credit towards any arrears that he still owes, but then anything, because we do have a significant amount of money on hold, and
all right,
it's around the 9,000 he was saying, it looks like.
All right. Ms. Robinson, what do you want to tell me? Unmute yourself.
The main reason why they are still taking money out of Mr. Jones, he's paying child support. The main thing is because the last month I had a hearing of this same little thing, and he did not appear. It's because the main thing is possession. They are not sure. No one can confirm that he has possession of my daughter. LaDyron Jones does not have possession of my daughter.
Hold on, Ms. Robinson, for just a moment here. The The issue is that the child left your possession over 6 months ago.
Correct.
Once the child is out of your possession for 6 months, then if Mr. Jones had possession of her or had her in a place where he had placed her, whether or not he actually had the child in his possession is irrelevant. As long as he made sure that the child was cared for, that's all that was necessary in order for him to get possession credits. Okay.
Okay.
All right. All right. Mr. Wright is going to prepare an order that's going to what we call a change of status. We're going to change the child from Miss Robinson being the primary caregiver to Mr. Jones being the primary caregiver. And that Miss Robinson is going to pay child support instead of Mr. Jones paying child support. Now, as it relates to the medical, now, Mr. Jones, once you get medical, you need to let the Attorney General's office know that you have put the medical in place. Otherwise, you're going to be subject to paying cash medical. You understand?
I got no, so I understand that. And as well, listen, I didn't get that when you told me that she will be paying $90 plus the 15, so actually 105 in cash. To whom?
No, that it's all right. Let me make sure you understand that.
Okay.
She's going to pay cash medical of $90 per month. Now, if you, sir, have medical insurance, then that money will come to you.
Oh, okay.
And the same thing with the dental. If you have dental, that $15 a month will come to you as well. Do you have any questions about that?
Nope, not at all.
Okay. She's going to be paying child support to you, $407 a month. You have an issue with that?
No.
Okay.
No, I'm good.
I'm granting her standard visitation, which means that she'll have the right to visit with the child on the first, third, and fifth weekends of each month. Now, the only reason that she will not be able to visit is if the criminal court, which is be dealing with the family violence issue, if they decide something different from that she's not to have visitation, then she will not. But otherwise, she'll have standard visitation.
Okay.
And I said I'm making y'all joint managing conservators, which means both of you will have the right to make decisions in the life of the child. How old is this child?
She's
16,
16,
probably
about to be 17 on the 8th.
next month.
Oh,
And
okay.
sir, my daughter, she goes to SOC. I stay walking distance to SOC.
Okay.
Like I said, this whole thing, like, clearly just don't make sense.
I understand that you don't believe it makes sense, Ms. Robinson. I understand from the very beginning how when you started your statement that you had a problem with it. And the problem is that you should have done something in the last 6 months. In order for you to have retained possession, you should have either hired an attorney or done
I have
something.
an attorney.
Okay, then where is that attorney today?
Okay, again, I did not know that this was going to happen, but I do have an attorney.
Okay. Then have your attorney. You have 3 working days in which to appeal this decision and get what we call a trial de novo, which means you get to tell your side of the story over again. And then the judge, this is out of the 302nd court, will give you what's called a trial de novo. They'll let you tell the story over again. And then that judge will make an independent decision as to what they believe is fair and just. So you might want to tell your attorney so as your attorney can file for a
trial de novo.
Yes, ma'am, for a new trial.
Within 3 days?
3 days.
Okay, because I actually have regarding this family domestic violence, I actually go to court tomorrow.
Okay, well, that judge, I mean, that attorney is probably not representing you in this case. You probably need to make them aware of this case so that they'll know what to do. You just need to tell your attorney, okay?
Okay.
All right. But as for what we're doing today, and what I'm ordering is that Mr. Jones is going to be the primary caregiver of the child, but y'all both are going to be joint managing conservators. You're going to get a standard visitation, meaning you'll get to visit on the first, third, and fifth weekends of each month. You're going to be paying child support of $407 per month, cash medical of $90, and cash dental of $15.
And is that so that 407, is that 90 and that 15 included in that, or that's a
No,
those are other charges?
Those are in addition to the 407.
So I'm gonna be paying like almost $600 something a month.
It won't be quite 600. It looks more like 512. Yeah, something like that.
512. And like I said, I know it may sound funny to you all, but like it seems like he's all about everything that's coming out his mouth is money, calculations, you know.
No, ma'am, he's doing what he should be doing. He should know exactly what he's going to receive, how much it is, and it's just a matter of arithmetic, and he's figuring it out. I don't have my calculator right here, but I would have done the same. I would have told you what it was. But at any rate, Mr. Wright is going to email to both of you a copy of this order. And of course, please tell your attorney they only have 3 days to appeal, okay?
Okay.
All right.
Oh, and when would I first be able to see her? You said the first?
The first, third, and fifth weekends of each month, provided that the criminal court allows it.
So more than likely.
You said you're going to court tomorrow, so just ask your attorney. I mean, your judge.
So let me ask you this.
All right,
Judge.
thank you.
So with the information that now, depending on with her case, because I'm not involved, I don't know any type of information about it. So
all you have to do is rely on this information I'm giving you that she's entitled to visit on the first, third, and fifth weekends.
Yeah, I got you on that. But
okay,
depending on her case,
that's between her attorney and the criminal court.
So, but what if
he's the one that called the police? It wasn't my daughter.
Well, then he's probably going to be there as a witness, then, ma'am.
So, what if she is just like I said before? What if she, goes against the grain and then tries to do the same thing? Do I just reach out to the police?
No, that's you did the first time. You called the police and made a false accusation.
I am assuming that both of you will be very civil. There will be no altercations. There's not going to be any of this.
It wasn't one thing.
Screaming and all of that. That's past. Okay.
All right.
Mr. Wright, would you please do that order? Thank you.
Yes. Yeah.
Press leave. You can press leave and you're free to go.
Supervisor.
Thank you.
It feels like he's just a bitter, jilted ex.
I can't put a belt on my daughter and make her go out there and talk to her mother or be around her mother or go around her mother.
This is my only child. This is his only child. And it's her pivotal moments. I want to be in her life.
She done had 2 years to fix her relationship with her daughter. And I tell Naya, I say, Naya, call your mama, talk to your mother. And then Halima always do something to destroy that. You haven't done nothing for Naya in 2 years. You haven't done nothing. You haven't done nothing. You haven't brought her clothes. You haven't brought her nothing.
This school year, Casey, I took her school shopping.
One second. Miss McCollum.
The 800 you sent, that was money that you did steal from her because now, Halima, you had her card when she was working.
Yes,
Halima, Halima, you took her money. Then you want to return her money when she call you and ask you about the money. This months after she had worked and got this job and got this check.
It's a really odd thing for something like that to almost kill a relationship because it's just money.
That was her money. You didn't go in her job and work with her. But then you want to say, oh, you a mother that you do this and you do that. Halima, you haven't done nothing the last 2 years. You haven't sent no child support.
But Mr. Lovejoy, you're not a good co-parent.
If it was on the other foot around, and like I said, Miss McCallum, she's not providing nothing. She's not helping with nothing, Your Honor.
If you want child support, Mr. Lovejoy, just say you want child support.
She's not going.
Mr. Lovejoy, you want child. Mr. Lovejoy, if you want child support, say it.
Yes, I want child support.
Why you can't call her and ask for 200 or 300, whatever it is that you wanted? Buy some clothes.
Because Your Honor, because it's too confrontational to talk to Halima.
I think a text message is not all of that, Mr. Lovejoy. When you can text her to tell you not to come to Anaya's job. You could text her to tell her to send her $200. Come on, be the co-parent I need you to be. Is this a game? You think Miss McCullough wants to come to court, beg and cry on the Zoom that's recording on YouTube for the world to see?
Yes. Mom got to step up to the plate. She's not stepping up to the plate because she's not taking care of her responsibility.
Tell me why mom is not stepping up to the plate. What should mom be doing?
Providing for her child.
Dad accuses mom of stealing money from their daughter and not providing for her in 2 years.
The purpose of this hearing is really just a status to try to check on where we are with regard to your daughter. So let's start with you, Mr. Lovejoy. Where are we?
Your Honor, we're still at the same point of her and Anaya needing to sit down and talk. I mean, well, not sit down and talk, but they have plenty of times and it's just not going right between them two. And like I said, Your Honor, I can't put a belt on my daughter and make her go out there and talk to her mother or be around her mother or go around her mother. You know, everything is all about Casey doing this, Casey doing that. At this point, my daughter's 17. You guys her mother need to sit down and talk instead of trying to control the situation.
Like I warned you, a 16-year-old's hard to control. They vote with their feet one way or the other.
But aren't they talking? Isn't this the whole point of the?
No, ma'am.
What do you mean? What's the difference? What do you mean they need to sit down and talk?
I mean, ma'am, they not spending no time with each other. I mean, Miss McCallum, she's supposed to come and get her, and she's not coming when she's supposed to. You know, she's just not coming when she's supposed to. Like last time we was talking, she's supposed to come pick her up on Friday after school. She's never done that. They never done that together. And then, like she said, her job is lingering. So she able to come and pick her up like she's supposed to. She always coming to pick her up at like 9. Well, my daughter work on Friday. Where she just started back working. So she worked on Friday from 5 to like 11 o'clock. Her mother, I got camera of her mother always showing up at my house at 9:30 when she know that she get off at 11 o'clock. So some days my daughter be like, well, Dad, I'm not going with my mom because I don't want to go. So I can't make her go. And I have plenty of messages in my phone. I wish I could upload the voice thing of me and my daughter talking where you can hear it. And I'm not telling my daughter not to go with her mother. Like I said, that's on her. Her and her mother, I don't know what's going on.
When she says she doesn't want to go, are you encouraging her to go, or are you just letting her?
I say, now you know it's your weekend to go with your mother. And I tell her on the phone, I mean, if I could upload that stuff and let you hear it, and I'd be like, well, now that's up to you. I can't do nothing but stand behind you, you know, whatever you want to do. But then she'd be like, well, Dad, I don't want to go.
That's opposite of what I was telling you to tell her. Your position was to encourage the relationship, not to say, Anaya, you get to make your own decision, because if you did that, then you're standing behind her making her own decision rather than encouraging the relationship.
Yeah, but Your Honor, I tell her, if I like I said, Your Honor, if I could upload it, I could tell, you know, I can tell, you can hear the message, and I can tell, I say, nah, you know, it's your mother weekend, you need to spend time. But
so the therapy appointments didn't help?
No, I mean, yes, I mean, the therapy, they say they don't see nothing wrong with her. He really wanted to know why was she put into this program. And he was like, he don't see nothing about her. Like they had on medicine, like she trying to commit suicide. He said, this ain't medicine for her. She don't have no visible marks. She don't have, it's nothing wrong with her. So why is he just want to know why was she put into this place? And
was he aware that she had run away from home several times, getting into fights at school?
Yes, he was aware.
And he doesn't think there's any issues with behavior with all of that.
No, as he talked to her and he spoke to me, he don't see no behavior. He didn't see nothing wrong. So he was
You
like,
mean
well,
a teenager is running away from home, fighting at school, and your therapist saw nothing wrong with her behavior?
I mean, that's just what that's what he told me. So I'm just like, was it a better environment with you? Was it this or was it that? So I said, well, sir, he asked me, have she ran away with you? I said, no, she been with me for 1.5 years and she haven't ran away. We haven't had them incidents of her running away or doing this and doing that. So Your Honor, I don't know what's the problem. I mean, I'm talking to her and I don't see no problems with her. I don't see, like I say right now, she's not going through this anymore. I mean, Your Honor, you have to talk to her. I mean, you and Your Honor, I just feel like it's a better environment with me. I mean, that's how I feel. Like
what now?
Like the counselor said, she haven't ran away from me, and at all. We haven't had she working every day.
The counselor that you're with, that's a certified counselor?
Yeah, he's a certified counselor.
And Ms. McCollum, how things going from your perspective?
So Yana, not good. It started off okay. I came over and picked her up. She came with me a weekend. It was the weekend before her birthday. Her birthday is October the 2nd. We talked about different things. I took her, she did a photo shoot for her birthday. Nails, everything was fine. I'm on a video with her. She likes to vlog. Everything was okay. Birthday came up, October 2nd. She wanted to go out to eat. Me and her was going to do that with a couple of my friends and one of her friends. Mr. Lovejoy did not allow her to do that with me. Comes the next weekend up with me and her supposed to now come with each other. She called me that Thursday, asked me if she could. She said birthday plans was changed. We were going to come over. She wanted to go to Six Flags with her friends and do some different things, and then go to the haunted house and everything, go out to eat. She called me that Thursday. Supposed to come over that Friday. Called me that Thursday. Mom, I want to spend a night over a friend's house, but it's gonna be her dad's house. Absolutely not. Not a man's house. No, absolutely not. So here comes Friday. She calls me, she got to school. Oh, we're not going to go over, the young lady name is Asia. We're not going to go over Asia's dad's house. We're going to go over somebody else's house. Who is this person? I don't know her. I never heard you spoke of her. Then I tried to step back, Your Honor, because she hasn't been around me frequently. Does your dad know them? Does he know them? He met them, but does he know them? Does he hang out with them? Have they been around each other? We've always been like that, Your Honor. There's even family members who we don't allow her to go to just because we don't like the scenery or how they dictate with their kids. So you can't go over there. Always been like that. She picked the phone up and said, well, hey, I'm not coming with you then. Hung up on me. I go to try to pick her up. She was supposed to be off that weekend. So that's why when I got off work, because I work from 10 to 8, and yes, my job is lenient. However, if she's mostly working, he takes her to work. And so I pick her up from work there when I go get her. I get off work, have a video, go into the house. The girlfriend opens the door, says she's not here, slams it, and I walk off. I go to her job, go up there. She's not coming with me. I wait for a while. Mr. Lovejoy then pulls up, grabs her, and him and his family go ahead and they go home. I'm sitting outside the car and I have the video of it. I said, Anaya, I'm sitting outside waiting on you. Anaya waits maybe about 20, 30 minutes. And then she says, she texts my phone and said, I'm not coming outside. I said, okay, let me sit back and let me text Mr. Lovejoy. So I text him. I said, hey, Anaya, everything was fine with me and Anaya. She wants to go over someone else's house who I don't know, as well as she already stated to me that you do not know them. I'm not allowing her to go anywhere anything happens, and that's on my heart. So no, she can't do that. You have to fix that with Anaya. Anaya don't feel comfortable going with you. Do I need to call the police on you? The police told me that if she don't feel comfortable with you, she doesn't have to go. So I'm guessing that they called the police to try to see whatever when it was time for her to get off. Every weekend has been my weekend. I have come to try to get my daughter. Mr. Lovejoy pulls up at her job, and I have multiple videos of him grabbing her. She's walking out. He said, Anaya, come to the car and just talk to me. Me and Anaya was just together on Sunday. I saw her aunt and her cousin out. They called her on video. Me and Anaya talked. Anaya was like, I miss you. I love you. I told her the same thing as well. I'm always going to be there for you, but I'm your mom. At this point, I can't be your friend. I would love for us to have a great friendship, but I'm your mom first, and my job is to protect you. She came with me Sunday, nails done, had a little day. We just talked everything else. Brought it back to the house. I said, hey, it's open. You call me. You called me, I'm calling you, I'm answering my text message, answering my phone. Everything was okay. Wednesday, she calls me at the school that she was at. They're not allowed to have their cell phones there. So she called me Wednesday, hey, are you going into the office today? And I said, yeah, you know, my days are Wednesday and Thursday. Okay, well, they took my phone. I don't have my phone. I can't get it back or whatever. I said, okay. So I went to work those Wednesday and Thursday. Friday, y'all, I get up, go all the way out to Lawrenceville to go get her phone for her. They call her, they tell her on the radio, on the speaker, hey, it's not early dismissal, just come to the office. So she comes in there, she just like looking me up and down. I said, hey, good morning, what's wrong with you? Just looking, I said, I came to get your phone for you so you can at least have it over the weekend. Oh, okay. And it's just like, I don't know what the combativeness is. I don't know what it is. When she's with me 1 minute, everything is fine. We can talk. When she go back, just cut off. I brought my cousin. My cousins adore her. She has an 8-year-old cousin and a 4-year-old cousin. The weekend, one weekend was supposed to be my weekend. I'm not going to sit up here and just take you, grab you from your job and do all that stuff. So I brought the cousins. They've been wanting to see her. Brought them up. She wouldn't even speak to them. Now, what has a 4 and 8-year-old done to you, Anaya? Those kids love you. When she was coming over here, she told me to come pick me up from work, so I want to go see them. She come to see them and they talk and they play around and everything. So I don't know what the disconnect is. But if this counselor is sitting up here saying that there's something, that there's nothing's going on, that's ridiculous. I have stuff even before. And yes, they said they'll put her on some medicine or something, but even before that, when she had grief counseling, I put her in before all that stuff started happening. And she was also at Chris Kids. They talked to Anaya. Anaya liked the counseling sessions that she had. She had a therapist and she had a clinician.
I'm sorry. Give me 1 second, Miss McCullum. Miss Marshall, give me a call. All right, thank you. Go ahead, Miss McCullum.
When he says the part about, oh, she's better over there and she's not running away, it's the fact that you're allowing her to do any and everything. That first weekend when I got back, we chilled and everything. That's the weekend that we did the photo shoot. And that Sunday, she asked to go with her friends to the movies. And I took her there and allowed her. Picked her up, Mr. Lovejoy playing games again. She told him, because the movie theater she works at is right down the street. She called him. He said he was going to pick her up. I come back home. When it's time, she calls me, Mom, can you come pick me up because my dad said he's not coming. I mean, Casey, you stay 3 minutes from there, if that the max. Like, come on. So she called me. The guy who she was dating at the time, he wanted to formally meet me. I spoke to him and saw him on FaceTime. We go out to eat. The cousin is there too. Mind you, they're just talking and I'm just sitting back so I can just take in everything. They're telling incidents when they're hanging out, going to parties, staying out till 2 or 3 o'clock in the morning, drinking. And this is literally, I'm sitting here, his cousin Anaya is in front of me, and I'm just looking at her. I'm like, baby girl. After I didn't say anything while we're sitting there, I'm just giving her the eye. But when we get in the car, I'm like, Naya, come on. But they're telling me plenty of incidents when they're just out having fun. So of course you're not running away. You have free range to do what you want to do. So why run away? Why try to leave the situation when you can pretty much come and go as you choose to? And so that's a problem.
She was talking about coming home at 2 a.m., drinking and stuff like that.
But hanging out at, I think it was, I can't remember if it was Waffle House or IHOP, but they were mentioning that hanging out and they were at a party and how she was drunk at Waffle House or IHOP at 2 o'clock in the morning, 2, 3 o'clock in the morning. And I knew it wasn't the same instance that she was like, such party. And he's like, no, the other party. So you get to hang and do what you want to do. So, and for Mr. Lovejoy, that's, ma'am, it feels like he's just a bitter, jilted ex, and you're allowing your daughter to do anything because a parent, a dad would allow their child to just come and go as they choose to. That's ridiculous. I then saw a video somebody sent me, one of her friends. You let her go to school with pink and black hair, pink and black eyelashes, looking like a Nicki Minaj Pink Friday album cover. Lashes all the way here. Your Honor, it's just ridiculous. And then to come to find out that the last tech comes to your house. So it's not that you brought her there that time, took her there. The young lady came to your house. You allowed this lady to walk out your front door with your daughter having pink and black eyelashes.
What? Who came to her house?
The last tech. And did her eyelashes, her last tech. So Ms. Lovejoy allowed her to have pink and black eyelashes. The lashes, black right here, bright pink and black again. To school, Like, I just don't get it. It's like she can do any and everything and he's just allowing her to.
What's your response to that, Mr. Lovejoy? Like,
Okay,
is she going to parties? Is she staying out late? Are you okay with her drinking?
No, ma'am. She is not going to no parties. I can count on 5 hands that Anaya have been out. I can't even count on 5 fingers that Anaya have been out. Anaya does not go to no parties. Anaya, like I say, Your Honor, her mother go play victim because it's all about money. Want me to tell you how it's all about money about her mother?
No, I want you to respond to your position is that Anaya does not go out. So when I hear to Anaya, she's not going to tell me she went to any parties.
Ma'am, she will tell you. She do not. I don't play that. She's not finna go to no parties. That's my daughter.
No parties. And what about her with the dressing, with the eyebrows, eyelashes? What about that?
Ma'am, Halima took her to get her eyelashes with the pink on there. Halima took her. For her birthday.
Yeah,
for her birthday, you took her. You took her for her birthday, Halima.
She didn't have pink lashes for her, Casey.
Can I talk, Your Honor, please?
So did Anaya tell you her mom got her the pink?
Ma'am, her mother took her. Ma'am, her mother took her to the photo shoot.
That's not what I asked you. I asked you, did Anaya tell you that her mom?
Yes, she took her. She took her.
Because you thought her mom gave her the pink eyelashes, you were okay with it?
Yeah, I'm okay. I'm okay with it, ma'am.
No,
it's for a photo shoot. It's for her photo shoot. It's for a photo shoot. It's not like she.
Did you see
Halima.
of the photo shoot?
Your Honor, can I?
The mink lashes.
No, because Mr. Lovejoy, you're changing the subject, and I don't like that. I'd like to stay with one concept so I can get it. So the first concept that I'm going to deal with is the party. You're saying there is no party.
No, ma'am. Ma'am, I don't tolerate no party. My daughter.
So you don't tolerate party and drinking?
No drinking, no nothing.
No drinking. Okay.
No drinking, no nothing.
All right. And you're saying that the eyelashes you tolerate because why? You're okay with
it was for her photo shoot.
For her photo.
So yes, ma'am. It was for her photo shoot.
The photo shoot with mom.
Yes, ma'am.
Have you seen the pictures from the photo shoot?
Yes, ma'am. Yes, ma'am. I got a couple of them in my phone. Well, I just had got another phone yesterday, so I got a couple of them in my phone.
In the photo shoot, in the photo shoot pictures that you have, are her eyelashes pink?
No, they pink and black. And it's like a little strip of pink. It's not like they all pink, and it's like it was for a photo shoot. So,
Mr. Lovejoy, my question was the photos that you have for the photo shoot mom sent her to. Do you have pictures?
Yes, yes, ma'am. I think I have.
Of the pictures that you have, does she have pink eyelashes?
Yes.
Okay.
Yes, please produce that. And ma'am, I just want to say
I'm sorry, I'm talking to him right now. And with regard to picking her up on mom's weekend, why do you pick her up on mom's weekend instead of letting mom pick her up from her job?
Ma'am, because my daughter called me hysterical. She calls me. She say, Daddy, that's why I say, ma'am, if I could send you the messages, you will hear how now you're saying, Daddy, I don't feel comfortable going with her.
All right. She doesn't feel comfortable. Do you know why?
I doesn't know why, but I doesn't know why, but it's an ongoing thing with her and her mother.
What is it, Mr. Lovejoy, that what makes her not want to go with her mother?
She shows up to a job unannounced. I mean, that's just what Naya said. That's what my daughter tell me. My daughter tell me she shows up.
So her mom shows up to the job unannounced.
Unannounced, yes.
But you can show up, and she's okay.
I mean, I show up when she called me. When it's time to pick her up, it's time to pick her up. And I say,
where does your daughter want Miss McCullum to pick her up when she's working from your house?
She usually pick up from her job because my daughter usually have her clothes with her. But the days when my daughter don't have her clothes, her mother come up there and pick up her clothes before it's time for her to get off.
Mr. Lovejoy, what's the unannounced? I'm trying to figure out what causes the issue. Are you saying she's coming on weekends that she's not supposed to have her?
I mean, she's coming. She's not coming. She's not coming when she's supposed to. When she do come, she come like 11 o'clock at night. So
what time is she supposed to come?
she's supposed to pick up on Friday after school. Now you
Okay.
get out of school at 2:00. So, ma'am, now you get out of school at 2:00. Now you got to be at work at 5. So every day I take her to work. And I feel like if it's 2:00, her mother's supposed to come and get her and take her to work because she got to be at work at 5. But I've been doing it ever since you put it in order for her to get her. And then
So I
Halima,
need to change the order to what? To allow mom to pick her up from after.
she can pick her up from work at 11:00.
But didn't you just say Anaya doesn't want her to pick her up at work at 11:00?
I mean, ma'am, yes. Sometimes she pick her up, sometimes she don't. This only happened like once that she picked her up at 11:00 from her job.
So that incident was only once.
Yeah, that was only once.
Okay.
So it'd be like it's like back and forth, and it's like sometimes Halima she'll come to my house and park outside and sit outside. Like one incident when she said she pulled up in the officer. I went and talked to the officer that work out there on campus on the not on campus but at the movie theater. It's an officer that be on duty at all times. So I went out there and talked to him, and I specifically explained what was going on. So he was like,
why were you explaining to an officer that Miss McCullum was waiting for her daughter? Was her daughter weekend?
Yes, that was her daughter weekend. But my daughter, like I said, my daughter called me. She called me. She like, Daddy, my mom out here. So I'm like, okay, well, what's going on? She was like, Dad, I don't want to go with her. I'm like, why you don't want to go? She said, Daddy, because I just don't want to go because how she come to my job and how she do this and how she do that. And then she said,
comes to my job. So Naya doesn't want her to pick her up from the job.
I mean, ma'am, I guess not. I mean, I don't.
Lovejoy, listen to me,
ma'am. I don't.
No, I gotta, because now you're throwing a lot of stuff at me, and I don't like it when it's not making sense. First of all, you told me mom only came to Anaya to get Anaya once.
Right.
Now you're telling me Anaya is telling you I don't want to go because she keeps coming to my job. So which is it?
She keep coming to her job being aggressive.
So she's been to her job more than once.
Yes.
So the incident you're telling me occurred more than once because you just said it only happened once.
Yes. No,
but it happened more than once.
Yeah, she done been to her job more than once.
Okay.
But it's just like she told her daughter that she gonna make her lose her job and make her do this.
Man, sir, I'm trying to figure out one thing at a time. Anaya does want her to come to her job to pick her up or doesn't?
She does. She doesn't. She doesn't. She doesn't want her to come to her job.
She prefers to pick her up from the house.
I guess so. Yes, ma'am.
So
yes,
you're going to pick her up at night, bring her home, and let Miss McCullum grab her from your house.
I mean, I can do that. I can.
Okay. So for some reason, she doesn't mind you picking her up from the job, but she doesn't want Miss McCullum to pick her up from the job.
Yes, ma'am. I guess yes, ma'am.
Because when Miss McCullum gets there, what does Miss McCullum do? Is she yelling, screaming? What is she doing that causes Anaya stress?
Man, I mean, man, when I get there, now y'all already done called me, so I don't know what's going on before I get there. So Your Honor, I mean, I'm not trying to be smart. You probably just need to just talk to Anaya because when I
need you. You're doing the very thing that caused me some concern, which is that you don't try to figure out what's going on. It's like you relving in the idea that something between them is happening, and you are pretending as if you don't have anything to do with it. But you, Mr. Lovejoy, you have something to do with it because you are the parent that the child is living with, and you're the parent that's backing up the needs and wants of the child. So you gotta understand what's going on, and you don't. Every single time we talk about, I ask you why she ran away. I don't know. Did you ask? Why she doesn't like her mom? Do you know? No. Did you ask?
Your Honor.
Why? No, you do that all the time though. Why is she acting this way? I don't know. Did you ask? You keep pretending like you don't need to know what's going on between your daughter and her mother. And to be a co-parent, Mr. Lovejoy, you're supposed to encourage relationships. You're supposed to help them. You're supposed to help them along. You can't put your hand up and go, well, as long as mine is fine, I don't really care what's going on with her and Anaya, because Anaya ultimately needs her mother. She may not need her at 17 because she's in her defiant years, but at some point, a young lady is going to need her mom. And you got to encourage that relationship to show it's fractured to the point, well, it takes too much to repair. So I'm not asking you to do anything special. I'm not asking you to do anything beyond other than why. You don't even ask the question why. Why does her, what is Miss McCullum doing when she's going to pick her up? Is she getting out the car? Is she running, going to her boss and talking to her? What is she doing?
Yes, that's what she's doing right there. Going to her boss, talking to her bosses, and getting the
But
phone
you just
numbers.
said you didn't know. 5 minutes ago, you had no clue.
See, Yana, that's why I say, Yana, she's 7. I mean, Yana, I'm just doing the best I can do with my daughter, provide and do what I'm supposed to do as a man. I said, Yana, mom got to step up to the plate. She's not stepping up to the plate because she's not taking
Tell
care
me
of her
why mom is
responsibility.
not stepping up to the plate. What should mom be doing?
Providing for her child.
Providing how?
Providing. She's not providing nothing. I mean,
I know. What do you want her to provide to step up to the plate? What does she provide?
Clothes, food, and all that accessories. Like for instance, Yana. She's
now, Ms. McCullum is not paying child support, and
she's not doing nothing. She
Mr. Lovejoy.
Yes, ma'am.
How would Anaya know what her mom is not doing to the extent that she doesn't want to hang with her mom? Are you telling her that?
No, ma'am.
Okay, then that is not affecting Anaya because Anaya doesn't know that. I want to know what's affecting Anaya that you are aware of.
Okay. Yana, you have to talk to Anaya, Yana. I mean, we talking.
Have you spoken to Anaya?
Have I spoken to Anaya?
Yes.
I mean, she fine. She okay. She okay.
No, have you spoken to Anaya about her relationship with her mom?
Yes.
And I'm asking you to tell me, but you keep telling me all this stuff. In other words, Mr. Lovejoy, you have generalized so much. There's nothing on my notes. You haven't given me one specific incident of something that's happening so that I can try to fix it. But I can't fix it because you're general. What is Anaya saying? What is specifically Miss McCullum's doing?
Man, now you just tell me she don't want to. Like when I try to talk to Anaya about it, now you say, well, Daddy, you got to let me and my mama fix that. She said, because my mama know what she did to me. My mama know what she did. So I said, well, Naya, y'all need to sit down and talk because
but you
I don't know what's going on.
So you don't know? No,
I don't know.
And you haven't tried to find out?
I mean, I sat down and spoke to Naya plenty of times. Naya, she'll speak to me about some stuff, but it's some stuff that she don't want to speak about. So I say, well, Naya, you got to tell me if I know when I talk to the judge.
Mr. Lovejoy.
Yes, ma'am.
I cannot allow you to be her physical parent if you cannot do the number one thing, which is encourage the relationship. See, you got to look at the statute. I have to do things by the statute, okay? In order for you to keep Anaya, you have to encourage her relationship with her mother. If you don't, I cannot give you Anaya. That's the reason why we're having this status conference.
But man, I tell her, I say, now you need to speak to your mother. Like I said, young, if I can send you the messages, I tell Anaya, I'm not telling, no, don't talk to your mother. No, don't do that. Baby girl, talk to your mother. Talk to your mother. Well, Daddy, Dad, I don't want to talk to her. Now you talk to your mother. I got the messages I got text messages. Now you need to call your mother. She calling me. I said,
okay,
you need to call your mother.
Here's what we're gonna do. I'm gonna try it one more time before I make a final decision. But I'm just telling you, it's very difficult for me to assign a relationship to change, to do a custody where I have a parent who's not encouraging a relationship. And you can't, and if you don't even know why, you guys came in September, it's December, and you can't give me one clue what's wrong with them. Like one incident, one circumstance, one situation. The only thing you know is Anaya says, I don't want to go with my mom. And that's sufficient for you. And that's not sufficient for the court. It's not. So I'll schedule an appointment to talk with Anaya. So maybe I can figure it out. But for right now, we're gonna do visitation. Let me try to change this visitation up so that Ms. McCullum, you're picking Anaya up from the house instead of her job, which to me seems odd. It seems like she would prefer to be picked up from there and just keep going, and then that would prevent Mr. Lovejoy from having to leave the house and pick her up and come
Yes,
back.
ma'am.
I don't know why that is, but whatever it is, to prevent there from being any concerns, I'll just let her pick up. You can just pick her up from her job, bring her home, and then you can pick her up from there. What time does she get off?
I'm supposed to be 11.
All right. So let's say by what time do you think? Maybe 11:30. That's on Friday nights, right?
Correct.
Do you want to do 11:30 on Fridays from his home?
I can.
All right, 11:30 Fridays if his home. We'll change that. And return father's home at 7.
And Your Honor, can I ask you just one question about the pickup?
Yes.
Okay, so if she doesn't come outside, Mr. Lovejoy tells me once again that she doesn't want to come and he's going to call the police. At that time, because a sheriff told me that for DeKalb County, but I'm still trying to be cordial and neutral about the situation. But I was told the last 2 times I was trying to get her that he's not abiding by your ruling so that I can take a contempt of court out. I was going to do that, but I'm thinking about me and Anaya. So this time, if I go pick her up and he calls Gwinnett County and tell them that that she doesn't feel comfortable because Gwinnett County just says, oh, we can't pull her out the house. And I'm not going to force them to do that. So at that point,
the only thing you can do if she doesn't come out is that you can make a police report, and you just make it the police report. The police report is not to drag her out of the house.
Mm-hmm.
Make a record. So when you come back before me, you can say, I was there, I was on time, Anaya did not come out.
Okay.
And then the question becomes, what did Mr. Lovejoy do to get her out of the house? And then we'll deal with that. But I will speak with Anaya to try to get an understanding of what it is that Anaya is trying to create, or what the circumstances might be, and see what we can do to try to encourage your relationship. Like she said, she's 17 years old. I don't know exactly what's happened. Mr. Lovejoy has indicated he's taken her to therapy, and the therapist he doesn't even understand, apparently, that something is wrong. So I don't know. So I'll talk with Anaya and try to understand what was she running away from. So apparently there must be something, but no one has been able to figure it out. So I'll talk with her and try to figure out what it is that she's concerned about. And we'll go from there. So Miss Marshall will give you all a date. It'll be an in-person date, obviously, because I would like for her to come in court. I'll try to do it in like a morning interview so that it won't take away from school for too much of the day. Or we might do it in what time does she normally get out of school?
She get home at 2, Your Honor.
Okay,
She
so
walked
I'm
through the
trying to
door.
get the appointment like at 4, like at the end of the day. That way she won't miss school.
Yes, ma'am. Yes, ma'am.
So it'll be at the top of the year. Okay.
Okay. Thank you, Your Honor. Thank you.
Thank you. Y'all have a good day. Y'all take care. Okay. So on Lovejoy versus McCullum, this case, I think we pretty much have done everything in the case. I had an opportunity to speak with the daughter, and to try to determine what's the best circumstances for her. I don't think anybody is, unless there's some circumstances that change. Her position was, I'm sorry, 1 second. I had an opportunity to speak with her, and her position is that she wishes to reside with her father. And so I think we put, in this case, a temporary order in place, allowing that with some visitation, and try to see how that was going to go. Because I think there was some issues of her running away, and I think Dad's position was she does not take that same disposition when he's in his household. I spoke with her. She seems very adamant about the position to stay with Dad. And I think her which is kind of a little odd, but I guess it is what it is. She feels Miss McCullum has stolen from her and some money that she had maybe was expecting to get back, or some money that was supposed to go to her. I'm not really sure, but that whatever that situation is with the money, I was taken aback that it really kind of shapes her thoughts. It's a really odd thing for something like that to almost kill a relationship, because it's just money, and your parents are taking care of you. But whatever happened to that money, I'm not sure exactly what happened. It really makes a significant difference to her, and she wants an apology regarding that money. She wants that money returned. And it felt like unless she got that, an apology in the return of the money, she was kind of steadfast in her position. So I don't know if I mentioned that to you after the interview or not with her. And I told her that for the most part, what we said, we're going to be private. And I meant that. But there are just a few things that I'll mention to you because I think it's important in redeveloping the relationship. And every children are different. They look at things very differently. But I also say this to you, Mr. Lovejoy, since you're going to be raising her primarily. Money should not move people to that extent. It just shouldn't. But for some reason, for her, it is. It just has made the whole difference. I don't know why. It just seems odd to me. But you got to talk with her about that, because that should not be the parameters that she uses in her life. But that is where we are now. And so, Ms. McCollum, so that you'll know, that is kind of what her position is. She wants an apology. She wants this money returned. And she's kind of holding that hostage to the relationship.
Yeah, and may I speak if I can, just on that part?
Yes.
That was a consequence that I had done after the second time of running away, the getting high at school, almost getting felonies. I had bought her a new iPhone. I bought her a designer bag to go back to school with. That third time that she ran away, me and Mr. Lovejoy both went to her job trying to stop the check or whatever, so we can be able to get in contact with her. So I had them to try to stop the check. It didn't hit her. It was her money. I think it was $600 and something. Was on the run for 2 weeks. She was spending and doing that. When I got her back with the phone and her card, I took it. I gave her the money back and more. Maybe mid-February, I called her, blew her phone up. She finally answered me. And I told her, hey, if you feel that my consequences, my choice of consequences because of your actions were too much, I'm sorry, but I didn't know whichever way to save you. I did counseling, friends and family on both sides. I don't know. But that money had been returned and more. And I explained that to Anaya as well as Mr. Lovejoy. The money part about her holding on and stealing, Mr. Lovejoy, I have text messages. Mr. Lovejoy kind of put that in her head. He texted me numerous occasions saying, you stole. And I'm telling him, Casey, that was a consequence. Yes, she ran and did this and that. I paid for an iPhone, the brand new, her phone was more than what mine was, not a trade-in. So it was just, you want to do this? I'm going to hold this for you. Everything else I've tried to do is not working. But Your Honor, that money was paid back to her, a full $800 in the cash app months ago, almost a year ago.
I'm not sure. And that might be, I'm just telling you that her position is that it hasn't been, but more importantly than that, this is the larger point. She wants you to apologize for it. And she said, not just a regular apology, like a real apology, acknowledging that you stole the money. I just thought it was, like I said, it was kind of an odd position for it. I was really taken aback that she would kind of want that. But I guess the reason I'm taken aback by it was that because most kids generally don't expect like apologies from parents, I guess, and she did. And that was kind of the holdup. So I feel like before you move forward, that's what she wants, to the extent that so you'll be mindful as you move forward with the relationship that is a very important point to her. But your position is what your position is. If you You didn't steal the money, you were using it as a consequence, and you kind of need to explain that to her. But I need both of you on board, Mr. Lovejoy. You know, my criticism, Mr. Lovejoy, to the extent that the court has criticized parenting, is that I've always told Mr. Lovejoy that you have to parent, you know, and that means that you help your child understand various things about parenting and motherhood and all those things. But you're being hands off is not parenting. Like, well, if they have a relationship, they have one. My hands are off. You know, that's not a part of the parenting process. She's going to need her mother. And if you alienate or allow her to alienate her mother, you know, it's going to come back on you. Because I can tell you, after I spoke with her, you will not be far from it. You will find yourself in those clutches too. Because, you know, we have some kids who are very kind of opinionated and very strong willed like she is. You're going to find yourself in that position too. So you guys got to merge together to be able to raise a child who is strong-minded. And so that means letting her know that Ms. McCullum is her mother, and the amount of respect she has to have for her mother has to remain there. You know, otherwise, I'm telling you the best I can. You cannot be hands off. You have to direct her, even though you might think, oh, the way I look at the situation is Ms. McCullum, you know, took the money and never gave it back. But you got to help them in their relationship. Otherwise, like I said, at some point, generally when they get older and they're able to process things, and this is essentially what I told Anaya, I said to her, and I want you to remember this, because my grandmother said all the time, live a little. Live a little. Those things you cannot understand now, your experiences will teach you later, you know. And so right now you might feel one way about your mother, and then until you are a mother and have to make those same decisions. And sometimes you get an opportunity to make amends and sometimes you don't. So, you know, don't be so quick to judge. In any event, I want you, Mr. Lovejoy, to have some hands-on with regard to directing your daughter to develop a better relationship with her mother, even though you may not agree with every single decision Ms. McCullum makes. Allow her to love her mother, you know. But you got so much animosity until it's going to spill over. It's going to spill over. I guess I'm in a position wherein, quite frankly, I don't think that Mr. Lovejoy, if I had to look at co-parenting, I would not choose Mr. Lovejoy. I don't think he has co-parenting skills at all. I just don't. But she's 17 and she has made her decision as to where she wants to go. And she's very strong-willed about it. So she has her reasons or rationales. She can articulate them. I did not find it to be something that was being pushed by Mr. Lovejoy. Of course, I'm not a psychiatrist. But I, spent time talking with her so I could understand how she feels and why she feels that way, so that I can make decisions that I think are beneficial to her. So I didn't necessarily believe, or I didn't see anything that suggested Mr. Lovejoy is pushing her. The only thing that I've always said, and I'm articulating it now, is that I think Mr. Lovejoy is just hands off. He's like, he's not trying to direct the relationship. Mr. Lovejoy, I know, might feel like he's not, but you are. You are hands off. You are not you're not facilitating that relationship. I just hope that you have a change of heart and try to start facilitating that relationship between the two of them. So initially on September 7th, I put into place that it was on a temporary basis that the child will live with father, mother would have those weekend visits. I know they had some rough start to those weekend visits. How are they now?
They're not, Your Honor. I uploaded a video. Mr. Lovejoy sent something to Mrs. Marshall editing the video, but I sent the last video I went to on the 2nd. knocking on the door, ringing the doorbell. The female that he is with now, as I'm leaving out, walking down the steps, comes out and says, get off my property right now before I call the police. And I'm like, I'm here for the judge's order. I have numerous videos. That was the last video. And I said, I'm just not going to go back over there until we come back to court with this. And I just want to tell, I uploaded her school stuff. I can't talk to Mr. Lovejoy, so I just want to talk to him to hear. Casey, I sent her grades. Some are okay, and a lot of them are not. She's in 11th grade. And one thing I did not play about with her school, and everything was set up so that 12th grade, she would get out early. If you look at those grades, the counselor put the grades together.
What are her grades?
Oh, she has a 96, and then it just goes down from there. And I just uploaded to Miss Marshall so that you guys can both all see it on there. They're not good. She has a lot of missing classes, school, and me and Mr. Lovejoy have co-parents together before. We have speaking gracefully to each other and also just only speaking about Anaya. So it's not like that we can't do it. We have done it before. This is my only child. This is his only child. And it's her pivotal moments. I want to be in her life. And I've tried, but it's not even just me, it's my whole family. I have a big family too. She doesn't speak. My grandma, my mom, she's her only grandchild. Anaya doesn't answer or talk to anybody. Everybody didn't do anything to her. Cousin just graduated college. She missed dad, high school, all type of stuff. And it's just, it's more to it than just the relationship between me and her. And I'm begging Casey, like, you know how I am about Anaya. We always had a close relationship, but something needs to happen. I miss my child. This is what's going on 2 years. Seeing her 1 minute did not, then seeing her did not. Like, this is a lot. And Your Honor, we have co-parent for years, great together. He cannot contest to that. And I just want him, like you said, have the same grace. I did the same for him. When her and him multiple times fell out with each other. He called me. I called both of them. Hey, y'all work this out. So I'm asking Casey to do the same thing for me.
And Mr. Lovejoy, what's your intent and plan on?
Okay, Your Honor, Miss McCallum, she done had 2 years to fix her relationship with her daughter. And I tell Naya, I say, Naya, call your mama, talk to your mother. And then Halima always do something to destroy that. They'll go out there and talk, they'll go out there and talk, and she always do something to destroy it. Like go to her job and try to get her fired from her job. Anaya, I have plenty of messages from Anaya saying what you're doing to her.
Naya, Casey,
no, hold on. I gave you your time to talk.
Mm-hmm.
I gave you your time to talk. And another thing, when you dropped her off at Peachford,
mm-hmm.
you sent me a message to pick her up. See, Halima, your whole plan was about your whole no.
I'm sorry, Mr. Lovejoy.
But the thing is that y'all have to sit down and talk about that. I have done that. I have told Naya to call you, and then you want to say your family. Halima, your family don't call Anaya. I have Anaya phone. I have Anaya phone. Halima, your family does not call her. They don't call me or ask me how she's doing. That's just like you. You haven't done nothing for Anaya in 2 years. You haven't done nothing. You haven't done nothing. You haven't brought her clothes. You haven't brought her nothing.
This school year, Casey, I took her school shopping.
One second. Miss McCollum.
Be quiet. The 800 you sent, that was money that you did steal from her, because now, Halima, you had her card when she was working. She was working at Burger King, and she was working across the street at the wing place. Halima, Halima, you took her money. Then you want to return her money when she call you and ask you about the money. This months after she had worked and got this job and got this check. You didn't return her money until a year later. That was her money. You didn't go in her job and work with her.
Your Honor, can I upload the information right now?
No, Ms. McCollum, hold on for a second.
You didn't. But then you want to say, oh, you a mother that you do this and you do that. Halima, you haven't done nothing. The last 2 years, you haven't sent no child support. You haven't done none of this.
Your Honor,
You
that's
don't,
what it's.
you don't supply no roof
McCollum.
over, hold on, you don't supply no roof over her head. You don't put no food in her mouth. You don't even pay medical insurance. She on my insurance. You don't pay none of that. Send the facts in, because I got all that from my job. You don't do nothing, Halima. You don't do nothing. You don't do nothing, and Anaya know that. She's know that. She see what you did. Then they just like, okay, right here on this receipt right here. It's a custody letter. Y'all, they stopped taking child support out my check on 11/14/22. I had Anaya, wait, oh, I got another. I had Anaya on 8/15/22. So why are you still receiving child support after the fact that Anaya is with me? And another thing, I have another paper.
You were behind.
Mr. McCollum, Ms. McCollum, wait.
I have another paper right here, Your Honor. Well, Halima is receiving food stamps and Anaya does not even stay with her.
No, I don't.
Halima, I got it right here. I have the paper right here. I have the paper right here. I have it because you went up to the school.
Ms. McCollum, if you interrupt him one more time, I'm gonna close this hearing.
I'm sorry.
She went to the school and tried to fill out a lunch form because she wanted to take Miss Sophia off the paper. She wanted to be smart and take Sophia off this paper. Now you've been with me. I got this say, dear parents, just because of Anaya go to school out here and live with me at my house. It say, dear parents, the guardian of Anaya Lovejoy. We want to let you know that the children listed above will be receiving free lunch because of the parents receiving SNAP or TANF. Your Honor, I don't get no food. We don't get no EBT, no food stamps in my house. I don't get no. She not on no Medicaid because I got insurance for my job for Anaya. So everything what Halima was doing was all about money. That's just like when you dropped off at Peachford. What it was, me and Naya, we wasn't even talking, Your Honor. Me and Naya, like she said, me and Naya, we was going through it. So guess what? When Halima texted me and told me to go pick up Anaya, I went and picked up Anaya. So it wasn't what it was. It was about the money. And that's all that Halima is about. Because if you wasn't about the money, guess what?
Mr. Lovejoy, how was putting her in Peachford about the money? Can you explain that?
Okay, because she'll be getting a check for Anaya, along with the child support too.
What check?
For the medicine that Anaya supposed to be taking. It was like some medicine.
You think she put her in Peachford for a check?
Yeah, yes, ma'am. That's how I feel. That's how I felt. Because if she would have been diagnosed for all this medicine that Halima referred her to do or to take, she would have been getting a check. And then, hold on, y'all. And then Anaya supposed to be going to military school. Anaya friend goes to military school and she is getting paid. Her mother is getting paid for the military school. So guess what? She wanted to send her to military school. So by me going to get Anaya, I messed up all that. Like I said.
But that doesn't make any sense, Mr. Lovejoy. You said she wanted to keep Anaya in Peachford so she can get a check and send her to military school. So why would she tell you to go get her? Because that would be inconsistent with the plan. She would fight you. She would prevent you from going to get her, and she would fight you. So why would she make if that's her intent?
In my phone, I had messages from Halima saying that she's going to live with you until she go to military school.
Okay, but
if
she wanted her to stay in Peachford so that she can get a check, why would she ask you to go get her?
I don't know, y'all. She, like I said, like hold on, y'all. Like I said, y'all, we was me and Halima, we was arguing. Me and Naya, we wasn't on good terms. So guess what? She knew by me and her not arguing, by me and her arguing and Naya arguing, I wouldn't go get her. So guess what? That's what she would have did. And she just would have sent off to military.
I don't know what to do for your situation, but Mr. Lovejoy, you are not a good co-parent.
You're
so full of conspiracy theories that there's no way you could parent. There isn't. I usually don't even have these situations with a 17-year-old. When a 17-year-old makes a decision, generally I talk to the parent, make sure they're a decent parent to be able to do this job. But you scare me.
How?
Because your rationale, it doesn't make sense. It's off. The things that you say don't make any sense. They don't make a lot of sense to me. They're inconsistent. You'll say one thing and then it doesn't even make sense, which means that those things are generally filtering down to your daughter. And it worries me because I know that there is no way Miss McCollum or her family would be able to be in Anaya's life, because I don't see you cultivating that at all. Because I think you think this is all about money.
Oh,
So
I mean,
let me ask you this.
Yes, ma'am.
When did you and Miss McCollum separate?
Ooh, it's been years. Like,
I think it was 2016.
2016.
Yes,
From
ma'am.
2016, did you pay child support in 2016?
who, me?
Yes,
Yeah,
you.
yes, I paid child support.
Did you pay child support in 2017?
Yes. No,
Did you pay it in 2018? Did you pay it in 2018?
Ma'am, I don't know what year, but I just know I was on child support for 1 year.
Did you pay it in 2019?
Yes, I paid.
When you were paying child support, where did Anaya live?
She lived with her mother.
Did her mom take care of her?
Yes, I mean, yes, she did. She took care of her.
Did she do what mother's supposed to do?
Yes.
Okay. Did she love Anaya?
Yeah, I know she did.
So one day she wakes up, taking care of Anaya for all these years, being a good mother, watching her matriculate through school, doing what good mothers do. One day she woke up and said, Peachford Hospital is the way I'm gonna go.
Ma'am, she would
Answer the question, Mr. Lovejoy. Did one day she wake up and say,
no, ma'am,
I'm going to send my good daughter to Peachford because I want to get a Peachford check? That's what she did. One morning she woke up and that's what she was going to do. All of this time taking care of Anaya, good mother, doing what mothers do. And one morning she decides Peachford is the way she's going to go. Correct?
Man, it conspired of what Anaya was doing, how she was acting. So
right. So she sent Anaya to Peachford because Anaya was running away. Correct.
Right.
Okay. Do you think she made Anaya run away?
Okay, but she had to be.
No, Mr. Lovejoy, just answer the question.
Say it again,
did she make Anaya run away? Like, hey, Anaya.
No, she didn't.
Anaya ran away from home because Anaya wanted to run away from home, correct?
Maybe, but she had to be running away from. Yes.
Yeah, she ran away from something. She clearly ran away
from something, though.
Right, she ran away from something. And then when Miss McCollum was like, look, I've done all I can do. I don't know what else to give Anaya because of her behavior. She tells you to go pick Anaya up so that you can now help her with Anaya, right?
Right.
Is there something wrong with that?
No, I mean, to me, it's not, but it's just how the whole situation
just answer the question. Is there something wrong with that?
No, Your Honor. No, there's not nothing wrong with it.
So why are you angry that she called for your help?
I'm not angry. She called for Your Honor. Like she said in the first continuance that we had back in the day, she told you I was a good father.
Right.
Hold on. She said I was a good father.
She did.
Okay, so
no one questioned your fatherhood. No one even questioned her motherhood. You guys were both saying good things about each other. And then all of a sudden, Anaya starts running away. We don't know why, because she claims her things are going well with you at your household. She didn't tell me there was something wrong with your household. She didn't tell me there was something wrong with Miss McCollum's household. She started hanging with the wrong people, whatever. She started acting out. No one knew why, and she started running away. She could barely articulate why.
Okay.
So she runs away. Then Miss McCollum asks for your help. You go pick Anaya up until I figure out what I can do to manage Anaya, is what she says. And that's what catapulted us here. I just don't understand how. This is what makes me worry. I don't understand how you have parents who were decently at least trying to work together. You were paying the child support as best you could. Okay. She wasn't strong-holding you about it. She was doing the best she could with Anaya. There was an incident that happened. No one understood why she started behaving that way. She asked for your help. You go pick the child up. And now all of a sudden, everything Miss McCollum does is for about money. And it's about a position that doesn't make any sense. It's inconsistent because all the other times she was raising Anaya just fine. And all of a sudden she becomes this money hungry, rubbing evil, sinister mom. It doesn't make sense. And so what I'm saying to you is when she calls you for help, you should go she thought enough of me to want me to help bring Anaya to a point where her behavior is changed, is to change her behavior. So you step in to do that. And then along in that, for some reason, the mixture comes out that Miss McCullum is a bad mother. That doesn't make sense. And then you start pulling out all these things, you make theorizing. Oh, she must have tried to get child support. She tried to get food stamps. That must mean she's about, listen, Mr. Lovejoy, Anaya is 17 years old.
I know.
The child support, if you guys are fighting over child support, let me just stop you. Because you guys will be fighting over child support for another 3 or 4 months. When does she turn 18?
October 2nd.
Y'all got 7 months. So let me just help you guys both out. If you're fighting over child support, it ain't worth it. It's 7 months. It ain't worth it. Let's kill the money. Let's kill the money for a moment. Because it's insignificant. It's insignificant. I'm dealing with relationships. So my question to you, Mr. Lovejoy, is, do you want your daughter to have a relationship with Miss McCullum, and why or why not? Be honest.
Ma'am, yeah, I want them to have a relationship. But if I sit here and tell Anaya, call your mother, I can show text messages in my phone. Now you call your mother. Have anybody reached out to you? Daddy, don't nobody call me. Daddy, don't nobody call me. So then I say, now you call your mother. Daddy, why you keep trying to push something that I don't want to happen?
Right.
I said, well, I can only tell you. That's all I can do.
Right.
I mean, I got plenty of messages in my phone that I'm telling Anaya, call your mother. Have your grandma called you? Have anybody called? Now you say, well, Daddy, don't nobody reach out to me. She said, don't know. She said, my uncle.
Mr. Lovejoy, I want you to pause right there. This is the same girl. This is the same girl who said, Mom, Dad, no one reaches out to me. And Miss McCullum brings her cousins over to see her. And Anaya is outraged.
Anaya, yes, ma'am. She brought Halima brought her niece and nephew to her job. So I said, well, Naya, what you do? She said, my dad, I don't want to see them. Why did she bring them? I said, Naya, that's your family. I said, Naya, that's your family.
What I'm trying to tell you is, Mr. Lovejoy, think about it.
I'm thinking, ma'am, I've been on it. I've been talking to you.
What is causing your daughter to not want to have a relationship with her mother? It doesn't keep you up late at night and you can't figure out why. Something happened.
No, you're right, Your Honor, but something happened between them. Like Anaya said, her and her mother had to fix it. I said, Naya, well, what's going on? I talked to her. I talked to Naya about all this. Naya, if Naya was right here right now, she would tell you, Daddy, that's me, that's between me and my mama.
And that's what you do. And that's my problem. Is that she's very clear.
She said, Daddy, if me and you can sit down and talk about our problem, me and my mama can. So, Daddy, you gotta let me and my mama handle that. I'm the child. She the adult. She need to think about what she did.
Right. That's what. There we go, Mr. Lovejoy.
And that's what Naya's saying. That's what Naya's saying. That's what she need to do. But in 2 years, if you have, in 2 years, if you haven't done that in 2 years, like, come on.
Yes, I'm glad.
What do I supposed to do? I can't put no belt on her and make her go out there and talk to her mother.
What does Anaya want from her mother?
Just to apologize. Just to apologize.
Say it again.
Just to apologize, but
okay.
I don't know.
You know that's what Anaya wanted from her mother.
Yeah, but Halima apologized to her.
Mr. Lovejoy, my question is, Mr. Lovejoy, did you know that's what Anaya wanted from her mother?
Yeah, she told me that.
Did you tell Miss McCullum that?
No.
So for 2 years, let me tell you, so you can make sure you understand. Now, this is the information I got from her sitting down with me for 10 minutes. For 2 years, she's been harboring the idea that she wanted an apology from her mother, but no one told her mother. She didn't know.
Naya have told her mother. Or Naya have told her mother.
She did not tell her mother that. I spoke with Anaya.
Okay, y'all.
I spoke with her and she did not say she told her mother that. Now, I don't know if she did, because I'm trying to figure out what is harboring her, what is causing you raise your child, there's no issues, all of a sudden she gets angry over some money, and for 2 years and 3 years you haven't spoken to your daughter, like you haven't had a real relationship. What is causing that? And so my concern, as I mentioned it to you, Mr. Lovejoy, was you didn't seem to care to figure it out. It was like your position was that's their relationship, and the only thing I'll do is say call your mother. But as far as facilitating that, I'm not going to participate in that. That's the vibe I got from you. When I spoke with Anaya on it, her position was that she was angry about this money, that she felt like her mother is the adult, and that her mother should apologize for stealing the money. And I even asked her, like, did she steal the money? She thinks she did. And I asked her where she had gotten it back. At the time, she told me no, she had not gotten the money back. That she said her mother, she had worked hard for this money. She had gotten a job, she had worked hard for this money, and she wanted it back. I couldn't remember what it was. I knew it was a few $100s at least that she wanted back. My only concern is that if you know that there is something that you can help facilitate their relationship with, help them. Because you're a good facilitator because you're in the middle of them. Help them. Don't hide the information from her. How is she going to apologize to the extent that that's what she wishes to do if she doesn't know that's what Anaya wants? And then you say no one's reaching out to you, Anaya. I don't know what these people are talking about. Yet I have to deal. Well, I tell you what am I doing here? Because Miss McCullum keeps coming to the court and asking for help. And then you'll tell Anaya something like, well, nobody obviously cares. Nobody's calling you. Well, why are we in court? What do you think Miss McCullum is here trying to do? Is this a game? You think Miss McCullum wants to come to court, beg and cry on the Zoom that's recording on YouTube for the world to see, but in actuality, she doesn't want Anaya?
Yes. That's
what I thought you thought.
That's how I feel.
That's a problem because you think Miss McCullum does not want Anaya.
Your Honor, it been 2 years. That just like I said, me and Anaya, we was arguing, we was beefing, we was doing this. And when her mother called me and told me to go and get her, I went and got her. Because I'm gonna put all my whatever we had going on aside to help my child. And that's just like from day one, I've been helping. From day one, I ain't been no
and Miss
absent.
McCullum, your position is she doesn't want the same.
I understand. She don't have to have the same, but you had to fix it with your daughter. I can only tell her, Night, baby girl, talk to your mama. I said, talk to your mama. You got your mama number. She said, no, you can talk to her anytime you want. Now you got your own phone.
How would Anaya talk to a woman who she believes doesn't want her?
I haven't never told Anaya that. I ain't never sat here and said, girl, your mama don't want you.
Now that I think about it, I don't know if that's the case because Amaya specifically told me that she questions whether her mother loves her. And which is really odd that you're saying that now, because that is what she told me. And I said, Anaya, that seems odd. You've been with her all your life. She was a good mother. All of a sudden some money was stolen and now you don't know if your mother loves you? Where is that coming from?
I don't know. Like
but now I see where it's coming from. I'm going to hold on to this case for a little bit longer. I'm gonna try something else instead of finalizing this because I really, it's a very odd position, but I can't trust you, Mr. Lovejoy, in this relationship. I don't. It's not about you trusting you being a good father, i.e. taking care of her, loving her, but I do question what you might be telling Anaya because as I sit here and listen to the things she told me, I do now wonder, because she didn't appear that Mr. Lovejoy was influencing her. But now that I'm hearing the things that are being said, that you're saying that didn't make sense when she was saying them, now I know why they don't make sense. Like, why would she question her mom's love for her? She literally doesn't know if her mom loves her. Wait, where would she get that from?
I say, she's 17. She's not.
But you also think her mother
I don't have to tell her if she sees what's going on.
Right.
I can like I said, she had an age now.
Mr. Lovejoy, that Miss McCullum does not love her daughter. I want a yes or no.
No, I have never told my daughter that. No.
Do you think Miss McCullum loves her daughter? Yes or no?
I know she do. I know she do, but it's just the circumstances that they got going on that they have to resolve. Like I said, I can tell. Like I said, the police have came to my house plenty of time, and they come here and ask Anaya, do you want to go out here with your mother? No. So like I said, I cannot put no bill up to Anaya and make her go out there and talk to her mother. It's been plenty of times that the police have done that. It's been plenty of times, 6, 7, 8 times that the police have been to my house.
In case that's me coming out to try to get her.
But that's
Well,
on Anaya.
that's my point. That's the inconsistent part I'm talking about. It's like you're telling Anaya, your mom doesn't work here. She's not calling you. She's not doing this. And then every time she comes, she gets blocked to see Anaya. It's not even about you, because Anaya will block her at her job, or whenever her mom tries to do something to get Anaya and get blocked, there's some blocking where Anaya won't come with the mom, or etc. And then they go in, then it's this mantra that your mom doesn't want to be with you. It's inconsistent. It doesn't make sense. She's trying to have a relationship and she gets blocked. And then after she gets blocked, the rhetoric becomes she doesn't really want to be with you. This is about money.
But how? I'm not blocking her. I'm not blocking her at all.
Something's not right. Where's the counseling process going in this? What counseling have you set up for Anaya?
She's not going to counseling anymore because of the school that she's at now. But I mean, we're gonna change that. You are required. There's a requirement for reunification counseling that I'm about to require. You all will do counseling once a week. Reunification counseling, it will be once a week. This right here is disturbing.
Thank you, Your Honor.
So, Your Honor.
Yes.
So I'm asking though, I mean, if it was on the other foot around, and like I said, Miss McCallum, she's not providing nothing. She's not helping with nothing, Your Honor.
If you want child support, Mr. Lovejoy, just say you want child support.
She's not going.
Mr. Lovejoy, Mr. Lovejoy, if you want child support, say it.
Yes, I want child support. Like
Tell me, Mr. Lovejoy, why you didn't ask me that a year ago?
Yes. I shouldn't have to. I shouldn't have to, because the mother knows that she's supposed to take care of her child. She's know that.
I would agree. I have a bunch of child support comes through, and that's what I tell everybody. You should know to take care of your kid.
That's just like me, Your Honor. I knew what I had to do for my child.
Right.
I knew what I had to do. So like I said, in 2 years, she haven't done nothing. You haven't supplied nothing.
So when you say done nothing, you want child support, correct?
Yes, I do.
How much do you make per month?
How much I make? Maybe $2,900.
How much do you make per month, Ms. McCullum?
Maybe 40.
40 what?
Okay. I'm sorry. You said a month. 32.
Okay. Do you pay health insurance, Mr. Lovejoy?
Yes, ma'am.
How much do you pay for health insurance?
I pay it's exactly it's exactly $432 a month, but I split it in half because I'm on there and she on there.
You pay $432?
Yes, ma'am, for both of us.
Who's on it?
Me and Anaya.
Okay. So you pay basically so half of that is what's that? $261?
Yes, ma'am.
Hold up, is that right?
No, it'd be like okay.
217,
something like that. 217, I think.
Huh?
It'd be 217.
Yeah. So you pay $217 per month?
Yes, ma'am. Well, $432 for both of us, but $217 because
but I'm only giving you credit for what you pay for Anaya.
On $214.
Okay, so I'll do that, and I'll consider the temporary child support in that regard. We're going to do reconciliation counseling. It is required. Okay.
Yes, ma'am.
All right.
Your Honor, can I just say one thing, please?
Yes.
Okay.
Come to my office, please.
Mr. Lovejoy was only on child support for 1 year, her whole entire life. She's always stayed with me. He's never helped me pay insurance, rent, anything like that. He only got mad because I was going through the pandemic and I was a hotel manager and we didn't have work for 6 months. I went without pay. And when I kept trying to speak to him, I went to his family, everything.
Ms. McCullum, Mr. Lovejoy told me he paid child support in 2016, 17,
no, ma'am.
19.
If you can look on the documents that I uploaded the first time to Ms. Marshall, I have them on there. Mr. Lovejoy was on child support for August 2021 to August 2022. There's also a paper that shows where I reached out to child support, asked them to stop it as soon as Anaya went.
No. I didn't ask you whether he was on child support like through the system. What I was asking is, he was saying he was paying you monthly support even if you were not asking for it.
No, ma'am. He'll get her clothes and do little stuff like that. But ma'am, no,
Your
no, ma'am.
So you didn't get a monthly amount of money from Mr. Lovejoy?
No. Now, what I will say is if I say, hey, she needs some food or something, he'll send $60 or something. But no, ma'am, nothing monthly and nothing consistently.
Mr. Lovejoy, were you paying a monthly amount to Miss
Well, I only paid 1 year, Your Honor. But the thing
I understand that, but when I asked you for child support, which you under oath indicated that you paid child support in 2016, 17, 18, and 19. That's what you told me under oath. What did you mean?
Your Honor, I only paid 1 year, and that was the only year that she put me on.
Mr. Lovejoy, you told me you paid child support in 2016, 17, 18, and 19. What did you mean by that?
No, Your Honor, I've been there. Like I said, Your Honor, I've been on my job for 12 years, Your Honor. Hold on, I'm gonna take this. I've been on my job for 12 years, Your Honor. If I was so much of a deadbeat, I would have been on child support, Your Honor.
Mr. Lovejoy, Mr. Lovejoy, you told me you paid child support in 2016.
No, I only paid one. I only paid 1 year.
By that?
I only paid 1 year. I helped out. I helped out with my daughter. I helped.
You helped. You were giving something.
Yes, I was giving something. It wasn't like I wasn't giving nothing.
Did you give something? Did you give the money to Miss McCullum without her asking, or only when you asked? When she asked?
When she asked me, like I said,
when she gave her money when she asked?
Yes, ma'am. Yes, ma'am.
Okay.
Whenever she
asked, you would give it to her.
I'm talking about whenever.
In the last 2 years that you've had Anaya, what money did you ask Miss McCullum to give you?
I haven't asked her to give me nothing.
Wait a minute. You mean to tell me that you didn't ask her to give you anything in the last 2 years?
No.
Okay.
No.
Did you feel like doing that last 2 years that she was a deadbeat when she wasn't giving?
I mean, ma'am, like I said, no, Your Honor. Like I said, Your Honor.
Did you, Mr. Lovejoy, did you feel like she was a deadbeat when she was not giving money in the last 2 years?
No.
You didn't?
No.
You just spent the whole time telling me that for the last 2 years she did nothing, and that bothered you.
She didn't do nothing though, Your Honor.
Okay, was she a deadbeat during the 2 years?
Yes, she was. Yes, she was. Yes,
okay,
she was.
because when you because she didn't give.
Yeah, because she didn't give, but I gave.
You gave, but
yes,
you gave when she asked. You didn't give. You didn't give without her asking. You gave when she asked.
I mean, I could. Your Honor, it just, Your Honor, I'm not. I've been there.
My question is, you only gave when she asked, right?
Right, or whenever my daughter asked. Whenever they asked me.
Deadbeat when you were not giving her monthly monies, right?
Right.
So she's not a deadbeat because she's not giving you monthly monies, right?
But okay, I mean, you're right, Your Honor. You're right.
All right, give me a moment. I'll come right back to you. Okay, so here's what we're gonna do. I'm waiting to get the child support numbers back, but I'll put those child support numbers in. And then we'll take a look at that number, and we'll come back in between 6 and 8 weeks. So within 2 months, the reunification process has to be in place for at least 6 to 8 weeks before we finalize anything in regards to this case. Okay. All right. Mr. Lovejoy, in the interim, please think through what you're doing and why you're doing it. Please think through it. I spent a good amount of time trying to question you and go through things with you because I wanted you to see the inconsistencies and what's the word that I'm trying to use? It's almost disingenuous because when you were in the situation, it was okay. And then Miss McCullum is in it. Somehow it's the most horrible thing you've ever seen. I really want you to think through why you feel the way you're feeling, because it's just so confusing. I don't understand how when Miss McCullum had Anaya and you were not on child support and she was not bothered by you not being on child support, you gave when you can and it was okay. When you have Anaya for 2 years, she's a deadbeat because she hasn't voluntarily paid you anything. When in the interim, you had done the same thing. It just doesn't. Come on, think through it, Mr. Lovejoy. Come on, be the co-parent I need you to be. All right, y'all.
I just need help. That's all. I mean, if she go, that's it. Whatever I just need help with my daughter.
Well, just ask her. You could have asked her that 2 years ago. You could say, Miss McCullum, send me $200 a month while I have Anaya. I'm gonna do the best I can, but just send me some money.
Okay, well, Your Honor, I mean,
That's
I'm
what
not
she
trying.
would, that's what she
Your
would
Honor,
do for you.
Your
That's
Honor,
what she
I'm
did
not
for
trying to
you.
be on you, but Your
Huh?
Honor, I can't talk to her. So Your Honor, I'd rather for you to just tell her that. I'd rather for you to tell her that because
But was she able to tell you that when she needed money from you? Was she able to call you up and say, send me the $60?
Yes, I got the cash app.
And you sent it. Why you can't call her and ask for 200 or 300, whatever it is that you wanted? Buy some clothes.
Because Your Honor, because it's too confrontational to talk to her, Lima.
I
It's too
think
confrontational.
a text message is not all of that, Mr. Lovejoy. When you can text her to tell you not to come to Anaya's job. You could text her to tell her to send her $200.
All right, Your Honor.
You'll receive an order in the mail. That reunification counseling needs to start ASAP, right? In fact, in about 7 days, Ms. Marshall's going to reach out to you. It needs to start it, okay? Y'all have, so go ahead and start looking in for reunification counseling so that there's a reunification between this mother and daughter facilitating, and you're going to help facilitate it. That's the order of the court. Y'all are free to leave.
Thank you, Your Honor.
The man she was dating at the time was involved in gangs and had a history of involvement with drugs. And I did not interview the stepfather, but he shot and killed Ms. Tresorati's boyfriend right in the house where they all lived. She hasn't been able to get an apartment. She did end up moving in with another gentleman whose background check was full of felonies and violence.
He's not a violent person. He has a daughter of his own who is Isabella's age, who he sees.
The parents are requesting that Mr. Patton be named joint managing conservatorship with a geographic restriction of Travis County and contiguous counties. Mr. Patton lives in Buda, in Hayes County, and Ms. Tresorati lives in Bastrop County. Since those two counties are not contiguous, they're requesting that the geographic restriction be based on Travis County, which is contiguous with both. For possession and access, the guardian ad litem's recommendation is that Ms. Tresorati have the right to visit with the child up to 2 times per week for up to 4 hours, and for the visits to be supervised by Mr. Patton's mother, Brittany Patton, or Mr. Patton's sister, Donnell Fabian. The guardian ad litem recommends that upon Ms. Tresorati securing a lease for her own apartment and passing 3 consecutive monthly drug screenings with a hair sample, that Ms. Tresorati be granted the expanded standard possession and access schedule. Mr. Patton and Ms. Tresorati are requesting that Ms. Tresorati have substantial visitation rights, but Ms. Tresorati's work schedule makes it difficult to construct an agreeable visitation schedule. In terms of medical and dental support, the parents agree that Mr. Patton should continue maintaining medical and dental insurance for the child through his employer. And parties agree that the actual cost of the child's coverage to Mr. Patton is $13.89 per month for medical and $9.02 per month for dental. On the issue of child support, parents are in agreement that they don't want either parent to be ordered to pay child support. In Mr. Patton's case, it's his request is due to Ms. Tresorati's circumstances and his own ability to afford supporting the child on his income. And Ms. Tresorati's request is due to Mr. Patton's requested status as custodial parent. So she wouldn't be requesting that he pay child support in that case. Both parents provided their most recent pay stubs as evidence of income, and parties agree that guideline child support in Ms. Tresorati's case would be $687 per month. Ms. Tresorati has one other child with a different parent. It's a 9-year-old son who normally lives with her, but due to the events in October has been living with his father. And Mr. Patton, in his case, guideline child support would be $865 a month after including credit for the medical and dental costs for the child. On the issue of child support arrears, Mr. Patton, oh, Your Honor, could I introduce State's Exhibit 1 into evidence? It's the pay record for this case.
Is there any objection to the pay record, Mr. Patton or Ms. Tresorati?
No, ma'am.
No, thank you. Ms. Tresorati, I'll need to hear your response.
No, ma'am.
States exhibit number 1 is submitted.
Your Honor, do I need to share my screen to exhibit the pay record, or can I just refer to it?
You can just refer to it. I have it in front of me.
Okay. The pay record shows that as of yesterday, March 3rd, 2024, Mr. Patton has a balance of child support arrears in the amount of $4,373.08. Ms. Tresorati, on account of Mr. Patton having possession of the child since the rendering of the temporary order, Ms. Tresorati is requesting the release of the full amount of those arrears and for a child support judgment of $0. On the issue of retroactive support, Ms. Tresorati is not requesting retroactive child support, medical support, or dental support. On the issue of non-disclosure, non-disclosure was ordered in the temporary order, but Ms. Tresorati is not requesting non-disclosure at this time. The parents are also in agreement on no longer having the requirement of app close for communications. Given Ms. Tresorati's circumstances, the parents are requesting that today's orders be temporary with a return date in 6 months on September 9th, 2024 at 8:30 a.m. with the belief that at that time, Ms. Tresorati's circumstances will be more stable and they'll better be able to address final terms. And that's all I have, Your Honor.
Okay. I am, I guess concerned with Ms. Swinton's time. If you could please call her, if you were going to call her as a witness, I'd ask that you do that now versus trying to get testimony from the parents. That way I can release Ms. Swinton from this hearing.
Yes, Your Honor. May I call Ms. Swinton as a witness?
Yes, sir.
Thank you.
Ms. Swinton, could you state your name for the record, please?
Jennifer Swinton.
And what is your role in this case, Ms. Swinton?
I was assigned as a guardian ad litem to represent the suggestions, recommendations to the court about the best interests of the child.
And Ms. Swinton, if you could summarize your findings and recommendations in this case.
Yes. Basically, there was kind of a tumultuous marriage that pretty much ended in April of 2023. Kind of, there was domestic violence involved. There was an order of protection, like you mentioned. When Ms. Tresorati moved out of the relationship, out of the joint living situation, she went to live with her and her stepfather. According to all the records I read and all the collaterals I interviewed, the man she was dating at the time was involved in gangs and had a history of involvement with drugs, and her parents did not at the time and were concerned about domestic abuse evidently. And again, I can only surmise, as I did not interview the stepfather, but he shot and killed Ms. Tresorati's boyfriend right in the house where they all lived. And then he was arrested, put in prison, and then subsequently Ms. Tresorati's mother committed suicide. So all this happened within, at the very outset of my assignment to the case. And, my heart goes out to Ms. Tresorati. I've been working with her to try to get back on her feet. And part of getting back on her feet has been finding her own place and a way to make a living and afford her own apartment, which has been very difficult. And she hasn't been able to get an apartment. She did end up moving in with another gentleman whose background check was full of felonies and violence. And I did not feel comfortable having Isabella in that home. The other thing that happened is that Ms. Tresorati, she took the very initial drug screening, but The subsequent one, when I was becoming to have more concerns based on people I was talking to, the subsequent test, she adamantly refused, and that gave me concern. What I can say about Mr. Patton is that he's been 100% solid. I've been to his home. He's had the same job for 10 years. He owns a home with his friend. His extended family provides wraparound services, if you will, to the little girl. For example, his mother provides free daycare, and she's more than welcoming to Ms. Tresorati to come do the visits there. His cares a lot for Ms. Tresorati, and they have no desire to cut her out of Isabella's life. They just want Isabella to be in the safest place with the least turmoil. And Ms. Tresorati needs perhaps some treatment, perhaps some time to get back on her feet and to find a place where she's not reliant on her situation with somebody who is not a good influence on her daughter. I heard you mention, Mr. Chukare, I heard you mention some steps. In our custody evaluation, we actually outlined stages that she could climb to meet to get back to more equal time. And I think you'll notice the first, the kind of, as you mentioned, give her some time. So for example, the step 2 after what we had, the first step was the 2 times a week, 4 hours a week supervised by Mr. Patton's family or an approved Kids Exchange Network provider. Stage 2, we recommended beginning on October 1st, where she would move to unsupervised visitation, and that her time would increase every Sunday, Saturday, and Sunday for up to 6 hours, and plus every Thursday for up to 2 hours, and then so on. So January 1st, she would get even more time, and March 1st, it would basically revert back to the standard visitation. So that is our recommendation. Isabella seems like a very happy, very smart, very energetic little girl, and she's in a good home. She's in a good place right now.
Thank you, Ms. Swin. Is there anything else you would like the court to be aware of in this case?
No. The family, the parents have, for the most part, at least after initially got case, they have seemed to be worked out a more civil way to engage about Isabella.
Could you put a little bit more detail in that regard?
There was initially one allegation from Ms. Tresorati about her hand being scratched when a cell phone was knocked out of her hand, but that was the only problems. Some of the texts both complained about too many texts, but the bottom line is that Mr. Patton has made Isabella available to Ms. Tresorati, even bringing her to Ms. Tresorati's shop, that she's a manager there at the retail shop that you saw online. And like I said, his mother has offered for her to come when she's watching her during the day when Mr. Patton is at work. So that's the kind of thing. It's the cooperation when it comes to the visiting. I have not heard any bad mouthing by either party of the other party, which is wonderful. I think there's concern definitely from both parties. They're not a good couple, but I think that they're both, a lot of people have said that they're both very bonded to Isabella, and that, they both want to be a big part of her lives.
Okay. Thank you, Ms. Swin. No further questions, Your Honor.
Ms. Swinton, in reading your report, it seems to suggest that since the change in the status of this child residing with Ms. Tresorati and now residing with her father, Mr. Patton, it seems to suggest that perhaps Ms. Tresorati has not been as engaged in parenting as Mr. Patton. Is that a reasonable conclusion to make right now?
It is, Your Honor.
Is it fair to say that Ms. Tresorati has not had a motivation to be presently involved? Or is there something else going on that keeps her from being actively involved as a parent?
Your Honor, obviously I can't speak to her true motivation, but I do know that there have been barriers. I don't know how motivated she is to see her daughter. She doesn't see her son from another relationship often either. So I don't know 100% about her motivation. What I do know are the barriers that she's been coming up against, which is having to work 12-hour days, not having the money to get her own place that would be safe for Isabella, and perhaps, like I said, perhaps some substance abuse. And again, I cannot prove that. I only worry because of the refusal to take a drug test and just some of the things that some of the references have said about seeing on social media and things, and just the background she's come from in that home. I have concerns about her being okay.
All right. So in terms of making parenting decisions with Mr. Patton, is it also fair to say that Mr. Patton has been by basically making those primary decisions, important decisions for the child?
Yes, Your Honor.
Okay. Where have the parents been exchanging the child? I'll probably get into that testimony with them, but as far as you know, where was that exchanging happening?
Yes, well, sometimes they would meet at a park. And sometimes, I know they used to meet at an HEB. Then when I got involved, they were meeting more at a park. And again, it was very sporadic, very short visits when they happened. But then I do believe what I've been told by both of them is that Mr. Patton would bring Isabella to Ms. Tresorati's store and they would visit there sometimes, not often, but that, and then I'm not sure if Ms. Tresorati ever took advantage of maternal grandmother's offer to have her come visit there. I know that I urged her to do so.
Thank you. Mr. Patton, did you have any questions for Ms. Swinton before I excuse her?
No, I do not. Thank you, though.
Okay. Ms. Tresorati, did you have any questions for Ms. Swinton?
No.
Okay. Ms. Swinton, thank you for your testimony and your report. I'm going to order that you be dismissed from the case and you are excused.
Thank you.
Milala, thank you. Mr. Shakir, you have another witness?
Mr. Honor, may I call Mr. Patton as a witness, please?
Okay.
Mr. Patton, were you able to hear the entirety of Ms. Swinton's testimony?
Yes, sir.
Are there any parts of Ms. Swinton's testimony that you disagreed with?
No, I agree with all of it.
So last October, you had the hearing on the 11th, and then soon thereafter, Isabella started to stay with you every day, basically. Is that correct?
That is correct.
Could you provide the court with some background on when that happened and the circumstances that led to it happening?
Yes. So the date, because I remember the dates. It was October 24th. Was the day that the murder happened. Since that day, Allie had just came to an agreement that it's best for Bella to be with me since October 24th.
And Mr. Patton, when you say Allie, are you referring to Ms. Tresorati?
Yes, Ms. Tresorati. I'm sorry.
But before that happened, was your child staying primarily with Ms. Tresorati?
We had a 50-50 split. I believe it was more of like a 55 to Ms. Tresorati and 45 to me. But yes, it was more of like a split. Yes.
Okay. And was that schedule? Was that part of your divorce decree?
So we were never married, but it was more of something that whenever we went to get the protective order, or something that the judge, me and Allie had made that schedule ourselves, but we presented that to the judge then, and he said that was something that would work out. So we stuck with that.
Understood. And was that schedule working out well for you guys?
Yes, I want to say it works for me. I don't want to speak on behalf of Ms. Tresorati, but it did work well for me and my work schedule.
And is that schedule something that you and Ms. Tresorati would be able to follow in the future, starting next month?
To be honest, I don't think so. It would still work for me, but I know that Ms. Tresorati works a lot. She's trying to get back on her feet, so I don't think it would. I don't want to speak on her behalf, but no, I don't think it would necessarily work for her.
And so since last October, what has the visitation schedule been like for Ms. Tresorati?
It's just been so I've had Bella full time. No overnight stays for Ms. Tresorati. It's just been more of like if she has an off day, she'll see Bella for a few hours. And like Miss Swinton said, I would take Isabella to Miss Tresorati's job sometimes, and she'd have her on her break or for like an hour or two while she's in the back as well. But it's probably been I counted the times. It's probably been between 10 and 12 visits since October, for a few hours each time.
Okay. Just looking at last week as an example, do you recall if any visitations took place last week?
There was a visit, I don't know if it was last week, but it was, yes, I want to say it was last week for 2 hours, yes.
Okay. And how did you arrange for that visit?
Me and Miss Tresorati, she had got off and she just was on her way, I guess, back to where she was staying. So she just offered, she was saying she's free to come and see Bella.
And so where did the visitation take place?
It was at a park in my neighborhood.
Okay.
So it was
And
in Hayes County. I'm sorry.
Oh, no problem. And is that where the visitations normally take place, or does it just depend on the day?
It just depends. It's very sporadic. There's not really been any consistency.
Okay. Has there been any consistency in like the time of day when the visits have occurred? And is that due to Ms. Tresorati's work schedule?
Yes, sir.
Have all of the visits taken place in Hayes County?
Most of them were actually in Travis. There's only been probably like 2 or 3 in Hayes County.
Where in Travis County?
Where she used to work, it was in South Park Meadows at the Route 21 that she used to work at.
Okay.
Or in that South Park Meadows area, like a restaurant or somewhere like that.
And do those visits at Ms. Tresorati's workplace, do they occur after the store closes or during a break, or how does that work?
They'd be both. There's been, I would say it's 50-50. It's been during her break, and then she'd be able to have her in the back sometimes as well. And then a lot of the time, or not a lot, but like the other half, it was like after it closed, she was performing like closing duties, and then she would have Bella for a few hours there as well.
And Ms. Tresorati's work prior to last October, was she working somewhere else with a different schedule?
We broke up. We broke up February of 2023 or end of January 2023, and I don't know anything about work besides when she started working at Route 21, which was after we broke up. So I don't know what her schedules looked like since. Yeah.
Okay. But last year, you guys were following a schedule where Ms. Tresorati had the child for about 55% of the time.
That's correct. Yes, sir.
And she was able to do that without conflicts with her work schedule?
Yes, sir.
Okay. Mr. Patton, if whatever the visitation schedule is that's ordered the court, that it may also include a stipulation that if you and Ms. Tresorati agree on an additional visitation or an adjusted visitation, that you're able to do that?
Yes, I want to have like Bella. Yeah, I want to see Bella as much as she can. Yes.
Okay. And if you propose a schedule ordered by the court, do you have an idea of what that schedule might look like?
I kind of do. So what would work for me again, because I have a consistent work week. I would have Bella pretty much Saturday night after I get off at 6 p.m. And so I'd pick her up Saturday night and then keep her till Wednesday morning.
Okay. And then would you be requesting visitations for holidays, your child's birthday?
Yes.
Okay. Were you currently exchanging, have you had any, I'm sorry, has Ms. Tresorati had any visitations with the child since last October where you were not present?
Yes, there's been a couple, yes.
Okay, and where did you exchange the child?
At the South Park Meadows, Route 21, where she was working at.
Okay, and does that exchange location, does that work pretty well for both of you?
Yeah, it worked at the moment. I think she's now working at a Route 21 in Bastrop County. So I don't know how convenient it'd be for her, but it's still convenient for me to meet South Austin, yes. Or South Park Meadows, yeah.
Okay. And the guardian ad litem, she provided testimony as to her understanding of you and Ms. Tresorati, your ability to communicate with each other. How would you characterize?
I think since like everything happened in October, before that, it was very back and forth. We didn't really see eye to eye. Since October of 2023, there's been no arguments, no back and forth. It's just, I think we both agree that whatever's best for Isabella is what we need to agree upon. And I think that Jennifer said is like, we've come a long way with communicating with each other in a good way.
Okay. Are you confident that if you and Ms. Tresorati, at the expiration of your protective order, are you confident that you and Ms. Tresorati would be able to communicate amicably without any harassment, or threats, or violence if you had each other's phone numbers and home addresses and were able to communicate freely with each other?
Yes, I do think that we'd be able to do that really well.
Okay, what would you say has made the difference? At some point that wasn't what was happening. What would you say that has changed?
To be honest, it was me getting over the relationship that we had. Me moving on and just putting Bella first is what changed it for me.
Okay, and is there anything else you want the court to be aware of in this case, Mr. Patton?
No, I think Jennifer made everything that I had, all the concerns I had, she brought them to light. It's just more of making sure that if Miss Tresorati is getting custody back of Bella, that the people that she's around are just safe, good influences, and that Bella's in a safe area as well.
Okay, and Mr. Patton, I just realized I need to ask a few more follow-up questions. Miss Swin, her record was for Miss Tresorati to have supervised visits with your child, so supervised by your mother or your sister. It sounds like, or I won't speak for you. Do you agree with that recommendation, or do you not?
I agree. I don't think Allie needs, because Allie's a great mother. She's always been a great mother. It's just what's gone through her, happened through her life, and the people she kind of associates with is the only concerning thing. So I don't think she needs supervised visits, but I do. I mean, I think not supervised visits forever. I think for the temporary time, yes, it's a good thing. But no, I don't think she really needs to be supervised with her kids. I think she takes great care of them.
And just for clarification, are you saying you agree with the recommendation for the temporary,
Yes,
period
that
of
is
the
correct.
temporary order? Okay.
Yes, sir.
Did you agree with that recommendation?
I've never had any thought that Miss Tresorati is doing drugs. I don't see it a bad thing for her to make her pass drug test, but no, I don't have a concern with her doing drugs. I've never had that thought or feeling or anything.
So would you characterize your position on that as neutral?
I'm pretty neutral with that one, just because I'm on board with because Jennifer's great with her recommendation, so I'm on board with what she wants, but it's not a concern to me, but I guess I'm neutral with it, yes.
Okay, so at this point, is there anything else you would want the court to be aware of?
No, not that it's on the top of my mind. No, sir.
No further questions, Your Honor.
Mr. Patton, did you and Ms. Tresorati engage in, say, electronic visits, since there's a distance, you live in different counties? Did the child have electronic access to her mother?
Yes, she does. Yes.
Okay. And how often does that occur?
I would say it's a couple of times a week, maybe 2 or 3 times a week.
And is it a schedule or just whenever Ms. Tresorati calls? And
yeah, so my daughter actually will ask for her mother as well, so we'll give her a call. But it's really when Miss Tresorati has time. Yes.
Okay. All right. I do need a little bit more clarification on your testimony about having supervised access between Miss Tresorati and the child. Why is that a concern? Why does Miss Tresorati need someone supervising her visits with her child?
I think it was more recommendation from Miss Swinton, but it's because of, I think, the people that she associates herself with.
All right. So if Miss Tresorati were to have a day visit, exchanged, and she can have a day with her child to do whatever they would like to do, do you have a concern that you would be placing Isabella in a dangerous situation if she's alone with her mother?
No, not alone. No.
Is your concern more if Isabella has overnight visits with her mother?
No, I don't have a concern of any overnight visits. It's just more of a concern of like if Miss Tresorati is having the people that she associates herself with around our daughter is the main concern.
Okay. Do you know the person that she is currently residing with?
No, I don't know them at all. No, just from what Miss Swinton has brought to light.
Okay. Were you surprised to learn that the current partner that Miss Tresorati is living with does have a criminal history that includes some violent criminal background?
No, it did not surprise me.
It did not. Okay.
No.
Now, Ms. Swinton did have some concerns with regards to maybe there was some alleged drug usage by Ms. Tresorati. And if you could clarify your testimony regarding any history of drug usage, is that something that you had experience with Ms. Tresorati, that she had past use of drugs?
No, so me and Miss Tresorati dated for 6 years from like 2017 to 2023. And there is no concern or even drug use from her. I can't speak on what happened after 2023, but I've never been concerned of her using drugs, no.
Thank you. Mr. Tresorati, Mr. Patton, he's testifying as a witness, so you have an opportunity to ask questions. Did you have any questions for Mr. Patton before you're called as a witness?
I do.
Okay.
He said that when I saw Isabella last week, that it was at a park. I wanted to ask if he was sure that that was where we met at last week when I saw Isabella, because to my recollection, he invited me to his home and I went there and we
Okay, so Ms.
were all
Tresorati,
together.
the question is, you want him to clarify the testimony regarding where last week's visit occurred?
Yes, ma'am.
Mr. Patton?
It was also at my house for a short period of time as well.
Any other questions, Ms. Tresorati?
No.
All right, thank you. Mr. Shakari, you may call your next witness.
Yes, Your Honor, may I call Ms. Tresorati as a witness, please?
Yes, sir.
Ms. Tresorati, Mr. Patton provided some testimony as to your visitation schedule last year prior to the temporary order. Would you say it's fair to characterize it as a 55-45 split between you and him?
Yes.
And how were you able to maintain that schedule pretty consistently?
I tried my best. Yeah.
Could you explain for the court what that schedule looked like in general terms?
Before the temporary order, Isabella was with him Sundays through Wednesday morning. And then one weekend it was Friday evenings through Wednesday morning.
Is that one weekend per month?
Yes.
And so Isabella was with you most weeks from Wednesday morning to, I'm sorry, is it Friday afternoon?
One weekend a month, one Friday a month, his mom would pick her up from Friday evening until the following Wednesday.
Okay. And so while you were maintaining that schedule, you didn't require many changes to the schedule. Were you guys able to keep it pretty consistent week to week?
I would say so.
And did you have the same employer and same job at that time as you do now?
No, I worked for Sally Beauty Supply.
And when did you start working for your current company?
The end of September of 2023.
And in September of last year, was your work schedule about the same as it is now, or has it changed?
I have gotten a promotion since I was hired on here, so I do work more than what I was initially hired on to do.
And at your prior employer, were you working full-time, 40 hours a week?
Yes, sir.
And is your schedule very different now than it was at your prior employer?
I do work more here.
Can you provide an estimate of like how many hours you work per week now compared to a prior employer?
I would say I work closer to 70 hours a week here than the 40.
Your previous employer?
At my previous, yes, sir.
Okay. Do you expect that you will continue working 70 hours a week, or may it change in the future?
No, I hope not. But the part of that is because I need to hire a team here. I also just moved stores due to the one in South Park Meadows closing. So I work at the store in Bastrop, which is where I live now. And it's a much more steady, consistent store. But again, I have to hire a couple more managers, and then I will be able to work my 40 hours, have my 2 days off a week, not have to cover the shifts where people are calling out or when somebody quits.
So if you're able to reduce your hours 40 a week, would you want to have a schedule like what you had last year?
So I would like to, however, I don't have any support anymore. My mom helped me a lot with my kids. So I don't have a lot of help at all, actually. I have nobody here in Texas. So for things like, pickups and daycare and just helping me, if I do have to work for a few hours before, being with Isabella at nighttime, that kind of thing, how Lonnie's family helps him. I don't have that. I have nobody. And I would never leave Isabella. I would never leave my kids with anybody that I don't know or trust. I wouldn't feel comfortable getting a babysitter or anything like that. So because of that, I honestly don't know. I would just need help, and I don't know who to ask.
So
but I'm sorry, but
go ahead.
But I want Bella.
Under the current circumstances, would you agree with Ms. Swinton's recommendation for you having 2 visits per week of 4 hours?
I would like to not have a time limit, and I would like to be able to see her more, but if that's the absolute minimum, then sure, yes.
And would you be able to schedule those visits on the same days every week?
I would do my best. I would absolutely do my best. My boss is incredibly understanding, more or less. And she tries to help me as much as she can. If I could do one day every single week, the same day, yeah, I would do that. I would do that. I just can't lose my job because then I can't have Bella. But yes, I'm happy to ask my boss for that.
Is there one day of the week that you can propose?
The beginning of the week is better just because I work in retail. And I am the store manager. I have to be here for peak days and business hours. So I would maybe like a Monday or Tuesday, maybe Wednesday.
Would you be able to have a Monday, Wednesday schedule where you see Bella for 4 hours on Monday and 4 hours on Wednesday after work?
Yeah, I mean, yeah, I can do that. The only thing about Wednesdays is I am not required to be here on Wednesdays, but it's preferred that the store manager is here on Wednesdays just for specifics, which I can get into if I need to. But I'm sorry, but I was gonna say is I could do like the morning. I know that would be fine. Wednesday mornings, yeah. It's preferred the store managers in the store on Wednesdays because evenings is when we do our promotional changes, and so the company asks that I do that.
Okay, can you propose a 4-hour time period for Wednesday?
I mean, I could any time before maybe 1 o'clock. I mean,
okay.
In all honesty, I'll do anything for Isabella. If I have to not be here at all on Wednesdays, I'll do that.
Okay. And on Monday, is it the same? The morning is better than the evening?
Mondays is fine. That's fine. Whatever is best.
Okay, so if Mr. Patton has 4 hours on Monday, that would work for his schedule. You'd likely be able to commit to that?
Yes.
Okay. All right. Sorry, could you remind me when Bella's birthday is? So it's Cup. Would you like to have a scheduled visit with Bella on her birthday?
Well, yeah, yes, of course. However, Lonnie and I have already discussed this, and he's having a party for her, which he said I'm more than welcome to come to.
Okay. Do you know what time, like a block of time on her birthday that would work?
Well, her party is not on her actual birthday. It's on a Sunday. The information's in my phone. But on her actual birthday, yeah, I would want to see her I mean, I'd like to have, I'm sure Lonnie and I would work together.
Okay. All right. And then Ms. Swinton, she recommended that the visitations be supervised. What is your opinion on that recommendation?
I don't think I need to be supervised with my children. I am a really good mom. I was a good mom before all of the tragedy happened. I don't need somebody to watch me with my kids. Lonnie's also said that his mom is not willing and doesn't want me to, she's kind to me and happy to help me get Isabella, like, exchange Bella, but she doesn't want me at her home.
Okay. It sounds like there's some concern from Ms. Swinton about the people who may be around Bella during visits. Do you think some of those concerns are warranted? Like that there might be friends or people in your life who, might not be a great influence on her?
I mean, I don't have anybody. I also don't live with anyone. I live alone in my own apartment, which I have the lease to. And like I said, I don't live with a guy. If I'm dating anybody, that's personal. And Lonnie and I both agree that, I'm not gonna, if I'm gonna be with Isabella, spending time with Bella, I want to do that just with Bella. With my son, of course, but with me and Bella, I don't want to share my time with anybody else.
How long have you had your apartment?
It's been a couple of weeks now. I asked Jennifer if she could come see it, and she said that she had a couple visits during that week. Not sure what week it was. And then I asked her again, I asked her a second time, and she said that she was already finished with the case. So she just hasn't seen it. I've also offered to have Lonnie there multiple times, offered to FaceTime him my home.
Okay, so you moved in the apartment 2 weeks ago and you're living there alone, just to confirm?
Yes, I live alone. I don't know if it was exactly 2 weeks ago, but it's been a few weeks.
Oh, and your name's on the lease?
Yes.
Is there anyone else's name on the lease?
No.
Okay. And what you to get your own apartment?
I want my kids.
Okay. Just check my notes here real quick. So there was some concern expressed about you not agreeing to do a drug test. And Mr. Patton provided testimony that he's not aware of you having any drug abuse issues. Could you provide your own testimony on that subject?
Yeah. So my car was stolen maybe 3.5 weeks ago now. Might be a month already. No, it was like 3.5 weeks ago. And like, I think it was the Monday after my car was stolen. My car was stolen on a Friday. Monday or Tuesday, Jennifer said that she needed me to go get the drug test that day. She said that was the final day, but she never told me previously that I needed to take a second drug test. And so I wasn't even aware that I needed to take another one, because I said to her, I was like, well, I already took one. And my car was stolen. Like, I have no way to get there. I also have no money. And she never got back to me about anything. Or I'm sorry. She just said that it was a requirement because she was trying to finish up her notes. And I told her, my car was, I have no way to get anywhere right now. And she told Lonnie, or she had mentioned to him something about how if I was able to get to work, I should be able to get to the drug test if Isabella was important enough. However, I missed work. I missed 2 days of work. And I also had to ask Lonnie for some money for an Uber one day, which he was kind enough to help me with, I think. Which even if it wasn't that day specifically, he always helps if I need it. But I didn't have a car up until a week ago. I have a police report. My car is still impounded. They found it. Well, someone found it. But I missed lots of work and I have proof of that. Called my boss. She knows it.
Okay.
I told Lonnie.
Ms. Tresorati, do you recall the date of the first drug test?
No, I'm sorry.
The month
December, maybe?
of 2023?
Well, maybe.
Okay. So within the past few months, is that accurate?
Yes. Yeah.
Okay. And do you recall what kind of test it was? Was it a hair sample?
It was a urine sample.
Okay. And what were the results of that test?
I mean, they never said anything to me, but
okay.
I passed it.
Was it explained to you why drug testing was required?
No. I assume it's just routine.
Okay. All right. So to your recollection, Ms. Swinton didn't mention anything in regards to why you were being tested.
Correct. I mean, I have assumptions, but I mean, she didn't tell me.
Okay. All right. Is there anything else, Ms. Tresorati, that you believe the court should be aware of in this case?
Yeah, Clinton and Mr. Patton both said that I haven't been motivated to see my kids, and that I haven't tried to see them or, those kinds of things. And that's incorrect. I see Isabella as much as I can. I if I have, I will go and see her wherever they are. Lonnie has invited me to his home. I've gone there multiple times, and I try to FaceTime with Isabella as much as possible, sometimes multiple times a day. I have proof of that. If I don't answer, I tell Lonnie, I'm at work or whatever's going on. I try to call him back. I do work a lot. I know that. He also help out in a few other stores as well. I'm hoping to ask for a raise soon. And so, I see Isabella as much as I can. Yes, Lonnie has brought her to my old store in South Park Meadows before, but that was because any chance that I get to have to see her, I tried to take it. Like leaving work the other day and driving by where he lives or like that area, I stopped and saw her. I have a lot going on still, and I don't do drugs. I don't have anybody, I don't have friends. I have one friend who doesn't live here. I don't live with anybody.
Oh, Ms. Tresorati, I just realized I needed to ask you a follow-up question. Ms. Swinton provided testimony as to a boyfriend that you had who had a criminal record, it sounded like. Do you know who she's referring to?
Yeah, I mean, I do have a boyfriend. I don't live with him. But I don't know of any violent charges. She didn't tell me that. She told Lonnie that he punched someone in the face, but I'm not aware of whatever. Yeah.
Would he be present during periods of visitation with Bella?
No.
Okay. And if that was in the court order that he not be present, would you find that agreeable?
Sure. I mean, I'm willing to do whatever I can to see my kids. However, I do want to just mention that he's not a violent person. He has a daughter of his own who is Isabella's age, who he sees. He's not a, but yes. And he to be my children. So but again, if even without the courts or anything, if Lonnie and I were to agree on our own, then that's fine.
Okay. Has he met Bella?
Who? No.
Okay. At this point, is there anything else you believe the court should be aware of?
I'm trying my best. With everything that happened, I'm trying my best to get back on my feet and be there for my kids. I haven't spiraled like Lonnie and Miss Swinton were waiting for, and I'm not going to because I love my kids. So I'll do whatever I can to see them.
No further questions, Your Honor.
All right, Ms. Tresorati, in Miss Swinton's report, she indicated that you have an older child, and that child you've placed that child with that child's father during this transition time where you had you didn't have housing, but now you do, right? You've got an apartment. Does your older child with you now?
He doesn't live with me now. I live in Bastrop and he goes to school in Austin, and I don't want to change his schools or change his life anymore. But same thing, you know, I try to see him and reach out as much as I can. And like I said, he's in school, he's in 3rd grade. So I don't get to see him or Bella as much as I would like to, but it's not for lack of trying or lack of motivation either.
How often do you see that child? And the reason for my question is sometimes half siblings do well when they are together. And so do you have a schedule with that older child?
No, his dad and I get along really well. So we don't have like a legal schedule. He lets me see.
Go ahead.
He lets me see and talk to him when I am available. Okay. But again, I work a lot. No, I do. I don't want to.
When you see your other child, is it also just during the day, no overnight visits?
Yes, I did just recently get my apartment within the last few weeks. It did unfortunately take me a minute, but I want to have them both. I would love to have them both overnight.
Now, one of the recommendations made by Ms. Swinton was once you obtain your own, she also was recommending 3 consecutive monthly drug screenings. But it seems to suggest that you have a standard visitation schedule once you had a stable residence. Considering that, it sounds as though your work schedule makes it difficult for you to have overnight possession of your children. Is that a fair statement?
Unfortunately, it is. Again, as soon as I can, get another couple of managers hired, it won't be that way. I just got this recently, and I just haven't had the opportunity to hire people. But also, my boss is, I work too much. I know that, but she is understanding about what's going on, and she wants me to see my kids. And so I know that if I asked her in advance for a couple of days off, I also have PTO that I'm holding on to see them, have some time. I know that I can figure that out as long as I, request it in advance. I would love to have them overnight.
So it sounds from your testimony that you are available Monday, Tuesday, and Wednesday, but better Monday and Tuesday. Is that what it is that?
So those are just the days that it would be better. Like that would be easy to request off because it's the beginning of the week. We're slower in our store, and I have to be here for the weekends and business hours. But again, if I request off time in advance, my boss is happy to give me that, and I do have enough people here that I could make that happen. Yeah.
Now, where would you propose exchanging Isabella for your weekly visit?
I mean, I don't have it with anywhere. I mean, Lonnie and I hang out with Isabella together now, and so wherever is fine for him, I guess in the middle of where we live. I invited him to see my apartment and like come hang out with me and be with me and Bella, the 3 of us together. I had somebody call out the last couple of days at work, unfortunately, but we were gonna spend the day together and do stuff here in Bastrop, the 3 of us.
So exchanging the child at one of the stores there in South Park Meadows, that's halfway?
It's about 40 minutes for me, but I don't mind, I guess.
Okay. I don't know, that's why I'm asking you, but if you don't have a specific response, then I can certainly ask Mr. Patton. Okay.
Yeah, I think South Park Meadows is a fair meeting point for the both of us.
That's a big area. Is there a specific location, store that you have in mind?
The Target in South Park Meadows.
Okay. Ms. Tresorati, did you have an opportunity to read Ms. Swinton's report?
No, ma'am.
You didn't?
I didn't know I was allowed to.
I know that part of the announcement was that you felt comfortable disclosing your location now to Mr. Patton. But is there anyone outside of this case, any parties outside of this case in which you would feel in danger if your address or location was part of a public record?
Yeah, I don't want anyone to know, even his family. Not that I'm not even his family. And it's just because there's a lot going on other than this with the murder case and my mom dying. I would just prefer that people don't know where I live.
Well, I can understand your preference, but that's not the legal standard, okay? So because this is the case that involves a child, it is required that parents disclose their locations unless there's sufficient reason.
With Lonnie, it's okay.
And in terms of, and I think you've made that clear, but in terms of that it could cause you or the child or some imminent harm, okay? And getting that from the report from Ms. Swinton, that there may be some parties that you may have some concerns, but I want to hear that from your own testimony, not from what I'm reading. So is that is there a concern with some third parties not part of this case that could cause you to feel like you may be in danger?
Yes, ma'am. Yeah.
Have you received what you feel are credible threats against you and your body from these third parties?
Yes, ma'am.
Okay. All right. Now you did ask about, you were a little confused why Ms. Swinton would have recommended drug testing. All right. Now, it seems that there were some allegations that were made, according to Ms. Swinton, by Mr. Patton, that there were some concerns with drug use. Did you disclose something to Mr. Patton about some drug use that you may have engaged in?
No, ma'am.
Okay.
Lonnie and I were young when we met. We would smoke weed together sometimes before Isabella. But I mean, he knows that I don't do drugs. Even weed gives me anxiety. But no, I've never told him that I do drugs, because that's not true. He did ask me when we were at the courthouse the most recent time. He asked me in the waiting room if I do cocaine, which obviously the answer is no, I don't.
Is there anything else you would like to add to your testimony?
I'm really trying hard. With everything that happened, I lost my home, I lost my car, I lost everything, my support system. And in that time, I've gotten a promotion at work. I've been transferred to a store that's staying open because my boss thinks that I do a good job. I'm consistent with my job and I try my best. I'm also still processing, and I would do anything for my kid. They're the only thing that I have. They're the most important things that I have. I'll do whatever I have to do to be with them, but I am a good mom and I'm a safe person for them.
Thank you. Mr. Patton, I guess I need some clarification on with your testimony. Some of the report from Ms. Swinton seems to be a little different from your testimony. So I just have to ask again about the drug usage concerns. Did you or did you not have concerns about that with Ms. Tresorati?
No concerns. I'm so sorry.
Go ahead.
Okay, yeah. So the only thing that I told Jennifer or Miss Swin was that the boyfriend that got murdered, he actually reached out to me a couple weeks before he got murdered, and that he told me that Allie was doing cocaine. And so that was the only thing I've ever told Jennifer. I never had proof of it or anything. It's just his word of mouth. And so I sent those documents over to Miss Swinton.
Okay. There was also some reports that you may have some concerns about certain photographs that Ms. Swinton, excuse me, that Ms. Tresorati may have taken of herself. Is that still a concern?
Yes, that is very concerning to me.
Okay. Is that something that is still occurring?
From what I know, yes, I've seen it here in February.
All right. I asked Mr. Tresorati regarding a suggestion for exchanging the child. She suggested Target South Park Meadows. Is that an appropriate place or something you're agreeable with, or was there something else?
So I would agree with that if Ali and Miss Tresorati's okay with it. It's more that's closer to my place, so I would be okay with meeting her farther north where she's closer to her. Somewhere downtown, like I work on 6th Street, that's where my office is. So somewhere around there I feel like would be more in the middle. Even a little bit further up north. I don't know much places there, but I just think it'd be more convenient for Miss Tresorati to even meet her more up north for her convenience as well.
Do you have a suggestion?
I really don't, just because I don't know much places up there, but if there's I know we can find like a Walmart or Target that's probably off of 35 up north somewhere. That's like public area that we can do an exchange. If all I can think about is my job, but I don't know if that's even okay with her.
Okay. Now, Miss Tresorati has now, she's reporting to this court that she has a lease, she has her own place, she lives alone. Looks like she's I didn't ask you, Miss Tresorati, but you have a vehicle now, right? You have transportation?
I did. I scrambled and I got a car.
Excuse me? You
I
do?
scrambled and I got a new car. Yes, ma'am.
Oh, okay, so you do have transportation. Okay.
It took me a couple of weeks to get.
So Mr. Patton, then is it still your position now that you've heard testimony from Miss Tresorati that she has her own place, that supervised possession still?
It's just more concerning the people that she associates herself with. Like Miss Wynn said, her current boyfriend is a felon for violent acts. She's asked me multiple times to try to meet her boyfriend so that she can have Bella around him. And it's something that we have disagreed upon. It's just more of like the guys that she associates herself with. Once the murder happened, she was receiving a lot of like bad threats and stuff. So I don't think it's necessarily completely safe where she is. I don't know exactly where she's living, but it's just more of like the threats, the boyfriend and who she associates herself with is a negative part about it. Her herself is great.
Okay, you're okay with Miss Tresorati. I mean, you don't have a concern with Miss Tresorati having possession of her daughter. It's more if they're these individuals whom you're concerned about are around. And if Miss Tresorati has testified that when she has possession of her daughter, it's only going to be for her, and this is her time with her child. Do you have any reason to believe that a statement made by Miss Tresorati is that's not something she's being truthful about?
I want to say yes. I don't feel very comfortable and like that's the truth because this is what happened with the person that got murdered, her ex-boyfriend. She had him around our daughter Isabella multiple times. And so it's not something that I don't trust. No.
Miss Tresorati, what is the name of your current boyfriend?
His name is, yes, ma'am.
Does he have a last name?
Garza.
Okay. So besides the current boyfriend of Miss Tresorati, Mr. Patton, is there someone else that you're concerned about?
So it's Josh, got her ex-boyfriend got murdered, his family and his friends. And that's who Zach is. It's one of his friends. And so it's just like the threats that they receive. They actually try to add me on social media. I don't know what the purpose is of it, if they want to find out who I am or where I live, but it's definitely that person's family, his gang, his friends, things like that. Yeah.
I think Miss Tresorati would agree with you on those other individuals. She seems to not want them to know where she resides. So I think you're both on the same page on that issue. Miss Tresorati, I failed to ask you. I don't think I heard any testimony. I just heard that there was an agreement for you to not pay support for your daughter. Help me understand why you do not want to be financially responsible in helping Mr. Patton.
So Lonnie and I just in our own daily life, if he needs something from me for Isabella, I'm happy to help him. He also has said to me that he doesn't want me to pay child support because he wants me to be able to, you know, save money and have things for her in my home and for her and I. He knows that I'm still getting on my feet, and he said that like I said, if he needs something for her, he'll ask me, and vice versa. But it's not that I don't want to be responsible for her. Him and I just agree that it's better for the both of us to just ask for help from the other person if we need it. But he normally, you know, other than today, he's really nice and helpful. And actually, even this morning, he said he doesn't think that we need to pay child support.
Well, that's the court's decision. I will tell you both that I don't agree with your zero child support agreement. Okay. So, you know, Mr. Patton was ordered to pay current support under the current temporary orders. And so, which was the right thing to do. He's a parent. He had a duty to support. Well, so do you. Okay?
I absolutely agree.
All right. I don't know how much money you make. I know how much child support was calculated and suggested that you be ordered to pay, but perhaps you can give me, I would like to hear some testimony with regards to your living expenses. Okay. Now that you have an apartment and a vehicle and that sort of thing. So how much is your rent?
My rent is $1,500 a month. That's the base rent plus my electric and water and gas. So I would add about $150, like valet trash and that kind of thing as well.
All right, so it's $1,500 for your rent, and then another $150 for your utilities.
About, yes, ma'am.
Okay. Your vehicle? Do you have a car note?
I do, yes, ma'am. It's $396 a month.
Okay. And your insurance?
My insurance is really expensive. It's $254 a month.
All right. And about your mobile, how much is that?
That one is $176 a month.
Okay. Any other living expenses that you can provide me?
I mean, none of that includes groceries or anything. So groceries are, I would say, gosh, $300 a month, $400 a month. Car, rent, utilities. I think those are like the necessities that I can think of.
Now, are you
gas? Oh, sorry. I'm sorry. Gas. So I would say $150 a month in gas.
Okay. All right. Are you salaried or you're an hourly worker?
I'm salaried.
Oh, what is your salary?
$56,000 a year.
Now, do you receive bonuses in addition to your salary?
I'm eligible for bonuses. However, because I just got this new store, I haven't been able to receive any yet.
Besides the expenses you just testified about, do you have anything else like child support for the other child, any other debts, things like that?
I do the same thing like with Lonnie, with my son's dad. If my son needs anything, he'll call me and ask me. And so I try to help in that way. But no child support like ordered.
Okay. All right. Mr. Shukir, was there anything else you'd like to add? Any other recall witnesses?
No, Your Honor.
Okay. So, Mr. Shukir, you've requested further temporary orders. In your opinion, this case isn't ready for final orders at this time?
Well, Your Honor, more information came to light during the hearing. One that was really significant, I thought, was Miss Tresorati having her own apartment now, having transportation. And in my own opinion, given the information that was shared during the hearing, I think in this case there could be final orders with step-up visitation, perhaps.
Okay. So it sounds as though the parties are wanting to perhaps get final orders after the protective order is expired. Is that more? Is that what I'm understanding? That we're waiting.
Yes, Your Honor, and during negotiation, we were just having difficulty coming up with a visitation schedule that would work. So we thought that having a temporary order might make it easier to transition to a final visitation schedule. But yeah, with Ms. Tresorati having her own apartment now and having, you know, solid employment, my opinion is that perhaps a final order would be appropriate.
Okay. It's not clear to me, but it seemed to be the recommendation by Ms. Swinton that Mr. Patton be the parent that has the right to determine primary residence of the child. Is that the agreement of these parties?
Yes, Your Honor.
Okay.
And Your Honor, I discussed with both parents what joint managing conservatorship is, and both parents agreed that they want a joint managing conservatorship, with Mr. Patton being the managing conservator or primary managing conservator, Your Honor.
Okay, so Mr. Shokare, I heard you talk about that what it would cost Mr. Patton to carry the child under his plans at work. Was there an agreement as to reimbursement for those plans, or is that something that was waived by Mr. Patton?
So parties agreed on the cost of the medical and dental, but because both parents were requesting zero child support, I didn't talk with them about whether or not they would be requesting reimbursement. However, when I calculated guideline child support for Ms. Tresorati, I did include credit for her reimbursing Mr. Patton for those amounts. Or correction, Your Honor. I think I may have said that guideline child support for Ms. Tresorati would be through $687 a month. That's actually without the credit for the medical and dental support. With the credit for the reimbursement, it would be $683.
Okay.
And we calculated Ms. Tresorati's gross monthly income to be a little bit higher than her salary of $56,000 a month. Looking at her most recent pay stub, we calculated an average of $4,680 a month. So very close, just like $13 more. Yes, Your Honor.
All right, folks. I think that being that there has been a change where this child has been primarily residing, I don't want to disrupt that. And but I think that there needs to be some regular schedule of visits. And so I am going to create a schedule that hopefully will make up some time for Ms. Tresorati. Before I give you the decision as to these temporary orders, let me give you the information about the court. I may have said this already. I need to repeat it. So I'm the associate judge for the Child Support Court of Travis County. My decisions can be appealed. So a party in this proceeding that disagrees with my ruling may request a new hearing before a district court judge. The time frame to request that is 3 working days after I sign orders. So Mr. Shukare will prepare the order. It'll be circulated by DocuSign, just like the first temporary orders. If you disagree with my ruling, your signatures aren't required. Mr. Shukare can still send the order to me for my signature, but you will be notified when it's signed. So at that time, if you would like to request a new hearing, then you have those 3 days to make that request. If you do decide to do that, you can hire a lawyer, you can do it yourself. If you decide to do it on your own, there's a self-help library online on Travis County's court's website. There's also a self-help library at our civil and family courts facility downtown. It's on the 2nd floor. I think a staff attorney that can kind of direct you in the right place. It still would be your responsibility to get your documents filed, send notice to everyone, get yourselves on the family law docket so that you can get your hearing, the new hearing held. Okay. So under these further temporary orders, I am appointing the parents as joint managing conservators, and Mr. Patton will be the parent that has the right to determine the residence under these temporary orders. Okay. There will be a geographic restriction for that residence to be within Travis or any contiguous county, since you both live in counties that touch Travis. So that I agree with Mr. Shoker that that seems to be a good restriction for now. Now, as to possession, I am ordering weekly possession on Mondays. It seems to be the slowest day for Miss Tresorati. Mr. Patton is off. So it'll be weekly, Mondays starting at 10, ending at 4. So what I would like for Miss Tresorati to have that whole day to get reacquainted with Bella, spend some time with her. I will leave it to both of you that if you think that Bella's ready for an overnight and stays over Monday night, I'm going to leave that discretion to both of you as parents to work it out. But if you don't agree, then it'll just be Monday from 10 to 4. So you will meet up at the Target at South Park Meadows, and you will have each other's numbers so that you can text, and traffic's horrible in that area. So please be patient, have some grace, but make sure that you communicate where your status. That way no one's disappointed, especially little Bella. Okay, she's probably gonna look forward to seeing her mommy. Okay, so that will be the weekly schedule until we come back in September. That's a long time. Okay, so that's why I'm giving you both the power that if you want to create a different schedule when you feel she's ready, you can do that. Okay, and I encourage you to do that, especially after your protective order is expired. That it sounds like you both are trying really hard to make things work, and I'm hoping that these orders will help you do that. Okay, now as to child support, I did deviate from the guidelines, taking into consideration that Miss Tresorati is going to have to travel further than Mr. Patton to exercise her visitation. So I did reduce the amount of support. So it was suggested that child support be set at, according to my calculation, $683. And so I am pushing that down to $585 monthly, and that will start April 1. Also, Ms. Tresorati is ordered to reimburse the cost of insurance to Mr. Patton. Okay, no retroactive child support was requested and waived by the state and I guess Ms. Tresorati, so that's granted. And the release of judgment is approved for was owed under temporary orders. I am ordering a third-party non-disclosure for Ms. Tresorati. She is still required to update Mr. Patton of her information, but it's not going to be part of the court record, so that way it protects her location. I think both parents had some strong concerns about that. All right. I don't recall if, let's see. I think the issue of court costs was reserved, if I'm not mistaken.
It was reserved in the temporary order, Your Honor.
Okay, then I'm I'm going to waive those court costs against either party, so we can address that now.
Yes, Your Honor.
Okay. All right. What was the time for September the 9th to come back?
8:30 a.m., Your Honor.
Okay. And September 9th, is that in person? Let's see.
I believe it's a
Yeah.
Zoom docket.
Okay. All right. Do you need anything else, Mr.?
Your Honor, did you want to include the electronic communications?
Yes, I did. Thank you very much. Yes, I saw a lot about that. So electronic communication will be ordered. And I think what parents are currently doing, just whenever Bella is ready, she's little, she's distracted. And so whenever she wants to call her mama, she can, that'll be fine as long as Mr. Patton makes her available that way. And she can have that time with her mom.
Yes, Your Honor. Oh, Your Honor, are there any stipulations about who can be present during the periods of visit?
Yes, I was going to enjoin Miss Tresorati is enjoined from allowing the individual
Garza?
Mr. Garza. He's ordered to not be present during the possession whenever Miss Tresorati has possession of the child, and also individuals that have made threats to Miss Tresorati. She knows who they are. Those individuals are not to be present during her time with the child. Okay, so it'll, and so I'm gonna count on you, Ms. Tresorati, to make sure that you take care of that. Don't let people around that are gonna be threatening. I don't know if I missed anything. I think I've got everything. Was there something else, Mr. Shukar?
I think you covered everything, Your Honor.
Yes, just insert some language that the guardian ad litem is dismissed.
Oh, yes, Your Honor.
Yeah. Okay, I think that'll do it. It was a very long hearing. I know I kept y'all, and I appreciate your patience. So, are we done, Mr. Shukar?
Yes, Your Honor.
Okay.
What was the amount that you said he was behind?
As of October the 31st of 2020, according to this pay record that I have, he owes $1,710.34 in child support and $25 in medical support.
Your Honor, what about the child support that was paid since the child support was
You'll have to take
terminated?
that up with the Attorney General's office, Mr. Smith. I don't have any jurisdiction, Mr. Smith. Mr. Smith is ordered to pay Crystal Smith the amount of $765 a month in child support. I'll order Ms. Smith to maintain the health insurance that she has on the child, and he will be ordered to pay an additional $150 a month in cash medical. Mr. Smith will pay back the judgment that he owes for child support by paying an additional, let's say $30 a month on the child support, and we'll say $5 a month on the medical support.